bajya gusaba umwanditsi yibutse urubanza rugiye gusomwa.
Nakoze urubanza RPA 0060 agakwego 2021 agakwego ca rwahujwe n'imanza zikurikira 0032 0035 0036 0037 0038 0039 0070 0072 0073 0074 0075 0077 0078 0079 0080 0081 0083 0084 0085 0030 0089 0090 0091 0092 0094 0095 0097 na 0099. Murakoze.
Urukiko rugiye kureba ko ababuranyi bose bahari. Abahagarariye ubushinjacyaha.
Turahari umushinjacyaha ku rwego rw'igihugu Ruberwa Bonaventure.
Ruberwa Bonaventure, Assistant Counsel Angelique, Dushimana Claudine, National Prosecutor, Defense, Saimana Kalesa Elias Sankara, the accused. Who is your counsel? Maitre Rugira is not yet present. Sangimanda Harman. I am present. Zaimana Mark. I am present. Bizimana Kassian. Zaiman Mark. Is your counsel present? Yes. Madame Marika Tete Arlette is his counsel. Bizimana Kassian. Present. We also defend this accused. Commander Jean-Beric Mas. Present. Who is your counsel? Madame Mokarusageza Chantal. Mukandutier Angeline. Present. Who is your counsel? She's also represented by Madame Mokarusageza Chantal. Shaban Emmanuel. I'm present. Who is your counsel? Mr. Ouimana Shami, he is not present. Sayumana Jean Damascene. I'm present. Who is your counsel? Ouimana Shami is my counsel. He is not present. Wiramira Innocent. I am present. Who is your counsel? Mr. Ngamije Kira, he is not present. He's present. Jean-Claude. I am present. Who is your counsel? Who is your counsel? Kirabu Guido Ngamije. Joseph. I am present. Who is your counsel? Ngamije Kirabu Guido. Nsanzumukire Félicien. I am present. Who is your counsel? Mr. Herman Twajamahoro. Munyaneza Anastas. I am present. who is your president? Mr. Herman Twajamahoro. Iyamuremye Emmanuel, it's your turn. I am present. Who is your counsel? Mr. James Nirora Marcel. I am present. Who is your counsel? Mr. Uramije James. Chimiman Emmanuel. I'm present. I am represented by Uramije James. Quitonda André. I am present. Who is your counsel? Mr. Mugabo Sharif Yusuf. Hakizimana Theogène. I am present. Who is your counsel? Mr. Mugabo Sharif Yusuf. Ndegijimana Jacques Chrétien. I'm present. Who's your counsel? Mr. Mugabo Sharif Yusuf. Nikuze Simeon. I am present. Who is your counsel? Mr. Herman Twajamahoro. RUSESABAGINA Paul. Not present. There are also civil parties who are represented by Munyamahoro. I am present. Mr. President, Havugimana Jean-Marie Vianney, we represent him. We represent him. Abfakurera, we represent him. Sebagema Simon, we represent him as well. Brian de Maviateur, we represent him. Simon Straton, we represent him. Simon Aviateur, we represent him. Nelson Damasen, we represent him. Habimana Vestine, we represent her. Beninga Marcelina, we represent her. Bengisha Emmanuel, Rosingzande Kweleandre, Shumbusho Damasen, Munyenwari Cassien, Nanga Caliste, Gema Josephine, Habyarimana Vianney, Habimana Anastase, Gendakumana David, Nyirahora Godelive, Kangabe Christine, Nyiramana Bérancile, Ndikumana Calixte, Sangué Jean, Mangara Jean-Marie Vianney, Chirakira Théophile, Nyiraziver Théophile, Rugerignang Dominique, Mukaisheka Joséphine, Ngavire Marie Chantal, Nyiraminan Mélanie, Ndikumana Aviateur, Sevarinda Emmanuel, Nyamugaba, Pigirimana Fanuel, Enos, Daisunga Edward, Baragamba, Bari Rwanda, Haririmana Emmanuel, Habiman Innocent, Hundimana Damasen, Hundirema Damasen plutôt, Ashongore Samuel, Savimiaremu Pascal, Zadiwam Yoram, Théogène, Viateur, Gayaberura Emmanuel, Sengimana Solange, Niranya Siravere Diana, Claudine, Hayerimana Patricie, Kanyandekwe Venant, Sanguiez Emmanuel, Giron Sanga Venuste, Navarisha Dative, Yambabari Evedas, Kakurere Gerard, Nkurunziza Jean de Pomsen, Sabimana Joseph, Niyonegere Gilles, Amahoro Jean Damascène, Wamba Gégé Françoise, Rutaisire Félix, Nirandibwa Marianne, Niraminani Daniel, Nzaimana Paulin, Bonigaba Richard, Niraribum Eliane, Kaitesi Alice, Mugisha Yves, Vianney, Abakurama Gracien, Rudahunga Ladislas, Rudahunga Dieudonné, Shumbusho David, Kirenga Darius, Umuriza Adeline, Karegesa Phineas, Désiré, Samuel, Mukeshimana Diane, Dikumana Isaac, Mukangundi Alfonsina, Uzaisenga Liliane, Habakubaho Adeline, Rugabagabo Jean-Marie Vianney, Murengirantwari Donat, Hakizimana Denis, Rwamihigo Alexis, Nyirangabire Valérie, Semigabo Deo, Kareragabo Antoine. We represent all those, says Council. Maître Léopold, are you there? Karerangabo Antoine is present. Is he present? Saint Yumva Vincent is represented by Rurangwa, Mr. Rurangwa. We represent him. Dutier Yusuf, Company Alpha Express, we represent it also. Thank you. I will now request my colleague to read the judgment. We will first recall the proceedings up to this stage of the case. The prosecution accused alias Sankara, Nsengimana Clément, RUSESABAGINA Paul, Nizeyimana Marc, Bizimana Cassien alias Passy, Matakamba Jean Bergmans, Shabani Emmanuel, Nebira Mira Innocent, Biokusenge Jean-Claude, Nikuzo Estiméon, Navanganyimana Joseph, Sanzubukire Félicien, Mounianeza Anastas, Yamuremi Emmanuel, Nirora Marcel, Chimiman Emmanuel, Kuitonda André, Hakizimana Théogène, Dagijimana Jean Chrétien, Mukanduti Angéline, et Nsabimana Jean Damascène alias Motar at the High Court in the Special Chamber for International Crimes, accusing each one of them separately various crimes. Among those crimes, there is a creation of an illegal armed force, being a member of a terrorist organization, terrorism for political ends. There is also killings. There is a kidnapping as acts of terrorism, stealing with arms, attacking transport infrastructure to harm, physical harm as acts of terrorism, and complicity in murder as an act of terrorism. And there is also the complicity in terrorism, and there is also incitement against the government of Rwanda in foreign countries, denial of genocide, complicity with the foreign countries in order to use documents that are illegal. The case has the number 006-ICC. 99 people suffered a prejudice because of the acts of the accused. These people have sued for damages through the prosecution. One of the accused, RUSESABAGINA Paul, in the middle of the trial, refused to attend trial. And on the 29th of September, a judgment was rendered. The court found them guilty, found that the accused were not guilty of terrorism, because those acts are not part of the act that threaten the security of the country or foreign countries, and they were not doing that in support of a force that is not the national army. The court found that the acts of which RUSESABAGINA was accused were classified under two different categories of crimes. One, the court found that the acts he's accused of should be considered as acts of terrorism instead of aiding and abetting acts of terrorism. In its decision, the High Court decided that Saimana Kalisa, alias Sankara, was guilty of being a member of a terrorism organization, of being active in terrorist acts, the act of denial of genocide, and the act of obtaining illegal documents that issued by a legal organization. He is not guilty of being an illegal armed group, and he was not guilty either of committing genocide for political ends and incitement to terrorism and incitement for the hatred of the Rwanda government in foreign countries. He was sentenced to life imprisonment, and his electronic devices and his passport were ordered to be confiscated. The accused was convicted, and he was condemned to 25 years in prison. Isaimana Mark is convicted of being a member of a terrorist organization, but he is not guilty of being a member of an illegal armed group. And he was condemned to 20 years in prison. Biziman Kassian was guilty of being a member of terrorism organizations, of using explosives in public places, and he was not found guilty of creating or being a member of an illegal armed group, and he was convicted he was punished with 20 years with 20 years in prison. The three mentioned accused were convicted of being members of a terrorist organization, of using explosives in public places, and of inciting to terrorism. And each one of them received 20 years of imprisonment. Nikuzwe Simeon was convicted of being a member of a terrorist organization, and he received 20 years of imprisonment. Akizimana Theogene and his colleague were convicted of being members of a terrorist organization, but not guilty of creating such an organization. They were punished with 5 years in prison. Kwitonda André, Nshimiyimana Emmanuel, Ndagizimana Jean Chrétien, and Mukandutiye Angelina were convicted of being members of a terrorist organizations, but were not found guilty of creating an armed group, an illegal armed group. Iyamuremye Emmanuel, Nirora Marcel, Kwitonda André, and Mukandutiye Angelina were all given punishment of 5 years in prison, and others were given 3 years. Concerning damages, it was decided that all the accused, except Sanzibukire, Felicien, and Neza Nastas, contributed to paying for those damages as follows. Saying Guillaume Vincent, 20,500,000. Havgimana Jean-Marie Vianney, 500,000. 600,000. Pakurera Venus, 600,000. Rugerinyange Dominique and Ntabaresha Dativa, each one 5 million. Sebyarimana Jean-Marie Vianney, 300,000. Ingabire Marie Chantal, 10 million. Shumbusho Damasen, 30,000. Sabimana Anastase, 30,000. Mukasheka Josephine, 10 million. Sibororema Venus, 300,000. Gendakumana David, 300,000. Dutier Yusuf, 7 million. Omega Express Limited, 164,700,000. Alpha Express Company Limited, 80,100,000. Rudahunga Ladislas, 7,690,200 francs. Kirenga Darius, Omuriza Adeline, Shumbusho David, and Rudahunga Dieudonné, represented by Rudahunga Ladislas, will each pay 2 million. Karigisa Phineas, 5,500,000. Nyiramve Liliane, 10 million. Ngirababye Desire, 2,500,000. Habimana Zerota, 2,500,000. Niyonegirije Azel, 2 million. Kaitesi Alice, 2 million. Nyirandibwami, 2 million. Wambajije Françoise, 10 million. 5 children belonging to Mukaba Hizi Hilary, represented by Mboniga Barisha, who are Mukeshimana Diane Dikuman Isaac, Mukanghundi Alphonsine, Uza Isenga Liliane, and Habakubaho Adeline, each 5 million. 7 siblings of Mukaba Hizi, Boniga Barisha, Mbugabagabo, Jean-Marie Vianney, Murengera Antoine Dona, Hakizimana Denis, Ruamihigo Alexis, Nyirangabire Valérie, and Semiga Bodeo, each 2 million. Ngurunziza Jean de Pomsen, 3 million. Musaimana Joseph, 3 million. Rotaisire Felix, 4 million. Mauro Jean Damascene, 5 million. Zeima Paulin, 2 million. The Court of First Instance decided that ne Kitabi Yambabari Vedast, Nyaminani Daniel, Mugisha Gashumba, Yves, Buimba Vianney, and Samuel do not receive any damages. Those from the village of Nyabimata, namely Habimana Viateur, Guillaume Sanga Venus, Beninga Marceline, Nyiraminani Melanie, Nyirahora Godelive, Ruhigisha Emmanuel, Munyenwari Cassien, Bangayandusha Jean-Marie Vianney, Sabimana Straton, Sebagema Simon, Barayandema Viateur, Karerangabo Antoine, Nyiragema Joséphine, Saguye Jean, Nyirazibera Dative, Ndikumana Viateur, Ndikumana Caliste, Nyirashirakira Théophile, Kangabe Christine, Nangwa Hafi Caliste, Nyirahabimana Vestine, Nyiramana Benasir, and Habyarimana Damascene. Those will receive no damages. The court also decided that those from the Ruheru village, namely Gashongore Samuel, Nzabirunda Viateur, Mugaba, Ndaisenga Edouard, Bigirimana Fanuel, Baragamba Ruti Honza, Enos, Barironda Innocent, Nsabiaremye Pascal, Habimana Innocent, Sebarinda Emmanuel, Zadima Mioram, Hondizera Damasen, Habakurama Gracien, and Hariman Emmanuel. Those will also receive no damages. Kivu Village, Saimana Solange, Kanyandeko Venan, Yanamia Silvere Diana, Hagirimana Patrice, Sanguiez Emmanuel, and Nyirakomeza Claudine also will receive no damages according to that judgment. Even one inhabitant of the village of Nyakarenso. The accused and those who applied for damages were not happy with the judgment, and they appealed. The prosecution was not satisfied with the judgment on the decision on the creation of an illegal armed group, and also the decision on RUSESABAGINA, kidnapping, robbery, armed robbery, and complicity in murder, and other acts that were qualified as terrorism. And the prosecution was not satisfied with the judgment on those decisions. Saimana Sankara was appealing because he pleaded guilty and he considered that the sentence was too severe. And Saimana Calixte also appealed because he considered that despite his guilty plea, his sentence was too severe and that he was ordered to pay damages while he did not have any immediate responsibility for that. Nizeyimana Mark appealed, saying that he did not take part in the crimes for which he was convicted, and he did not have any part to play in damages. Cassien said that he was not heard enough, but Akamba Jean Berkmas appealed because the Court of First Instance does not analyze the reasons for his committing the crime, and that he was punished for an attack in Karangiro while he did not take part in it, and he appealed the sentence. Sabimana Jean Damascene and Shaban Emmanuel also appealed because the Court of First Instance did not consider their mitigating circumstances that they presented, and that they were ordered to pay damages for attacks in Rusizi. Vita particularly criticized the court for having convicted him of incitement to terrorism when that crime was not one of his charges. Others appealed because the mitigating circumstances were not considered, and that the time of arrest was not indicated, while this will be the basis for determining the length of their sentence. Others appealed because the Court of First Instance did not indicate when they were arrested, and because their sentence was not reduced to 1 year, despite the fact that they had pleaded guilty. Others were not satisfied with the sentence because they were convicted instead of being released, and because there was no stay of punishment while they had no role in the case and in the damages. 3 others appealed because of different reasons. Those who applied for damages, including Jean-Marie Vianney, Pakorera Venus, Rugirinyang Dominique, Navarisha Dative, Navyarimana Jean-Marie Vianney, Ngavire Marie Chantal, Shumbusho Damasen, Sayumana Anastase, Mukaseka Josephine, Sibororema Venus, Gendakuman David, Rudahunga Radislas, Kirenga Darius, Maurice Adeline, Shumbusho David, and Rudahunga Dieudonné, represented by Rudahunga Radislas, Kare Josephinius, Nyira Yonve Erian, Ngirababye Desire, Habimana Zelot, Nionegire Aziel, Kaite Salis, Nyirandibgami Marianne, Mwambaje Françoise, 5 children of Kabahizi Hilary, represented by Nganigawa Richard, who are Mkeshimana Diane, Habikuman Isaac, Mkanduti Alphonsine, Uzaisenga Lilian, and Habakubaho Adeline, Mukabahizi Hilary, Bonigaba Richard, Vugabagabo Jean-Marie Vianney, Murengera Noiri Donat, Hakizimana Denirwa Migo Alexis, Nirangabire Valérie, and Semigabo Deo, Hurunziza Jean de Pomsen, Saimana Joseph, Tarisir Félix, Mahor Jean de Massen, Izemana Paulin, Sengimva Paulin, Dutier Youssef, Omega Express Limited, Alpha Express Company Limited, appealed the size of their damages while they had proof of the damages. The following people: Bimba Vianney, Habziaremwe Samuel, Habimana Viateur, Nziron Sanga Venus, Beninga Marcel, Lynn, Nyiraminani Melanie, Nyirahora Godelive, Ruhigisha Emmanuel, Munyentwari Cassien, Bangayandusha Cassien, Saimana Straton, Sebagema Simon, Barayandeba Viateur, Karerangabo Antoine, Saguye Jean, Nyirabagema Josephine, Nyirazibera Dative, Ndikumana Viateur, Ndikumana Calix, Nyirashirakera Theophila, Kangawi Christine, Nangwa Hafi Calix, Nyiramana Benansil, Habyarimana Damasen, Mana Theosen, Jeune, Nzabirinda Viateur, Nyomugaba Ndaisenga, Edouard, Bigirimana Fanuel, Baragamba, Ruti Hunza, Bari Rwanda Innocent, Sabiyaremye Pascal, Habimana Innocent, Sebalinde Emmanuel, Nzagibwami Yoram, Nkundizera Damasen, Abakurama Gracien, Harerimana Emmanuel, Ngayebero Emmanuel, Dusengimana Solange, Kanyandekwe Venant, Nyiramyasi Rovere Diana, Hagenimana Patrice, Sangiez Emmanuel, Nyirakomeza Closen, and Gakwaya Gerard, appealed the judgment because no damages were given to them on the ground that they gave no evidence to that, and they hold that they gave sufficient proof. All those damages and all those grounds of appeal were put together, and during the last sitting, all the accused were present, and RUSESABAGINA, except RUSESABAGINA Paul, and there was a debate whether he was notified on the after deliberation. The court decided that he was duly notified, and as decided that as Law 027-2019 of 29 September 2019 provides that he was going to be tried in absentia, and the trial was set for the 21st of January 2022. And the 5 categories were decided to be considered.
The accusations for which they were cleared, and those for which they were condemned, and also those concerning damages. It was a new timetable was agreed and it was shown that Simon Emmanuel was guilty of complicity in a terrorist organization, and it was decided that there had been insufficient proof, and that should be revised so that in a later trial, the court changed the title, the category of the accusations to say that only RUSESABAGINA, Mark, and a third were to be condemned in connection with this terrorist organization, MLC-FLN. Now, the analysis of the cases, RUSESABAGINA Paul, Nzeyimana Mark, Samana Kalisa alias Sankara, were condemned as regarding the terrorist and illegal combatant group, and the High Court and the Transborder Crime Tribunal had agreed on a number of items, but disagreed with the way the case was analyzed. And Nzeyimana Kalisa alias Sankara, RUSESABAGINA Paul, Nzeyimana Mark should not be condemned in person, but condemned as members of a terrorist organization, MLC-FLN. And the prosecution said that the arrest of these people was proceeded as if these people were part of a terrorist organization, had aided and abetted a terrorist organization, whereas in fact they themselves were terrorists. And it was, and this according to the definition of terrorism, the law of 46/18 of 2018. This is a law on terrorism as amended. It says that law says that terrorism is any act deliberately conducted to harm, wound, or kill people or a group of people, or the government property or private property, or the environment, cultural heritage. And these acts are done with the purpose to terrorize, to force, or to compel people to act in a certain way. And therefore, if a person is convicted of having participated or intended to participate in such acts with the purpose of disturbing the peace, or causing unrest, with the purpose of combating the government and the leadership. It is also any act that supports, aids, contributes to, incites, teaches, or encourages treason, complicity in terrorist acts, rebellion, or any of the acts that are condemned in the relevant article. It also says that in paragraph 1, subparagraph 1 of the 2018 law on terrorism, it also says that this law also says that anyone who participates or tries to participate in terrorist acts, supports terrorist acts, or in any way aids and abets terrorist acts will be punished according to the relevant article of that law. And the law says also that, therefore, the conclusion was that Nsanzimana, Karisalia Sankara, RUSESABAGINA Paul, and Xavier Bank, who were heads or in the leadership of this terrorist organization, MLCD, and who took part in financing, supporting, organizing, and also in planning the attacks and encouraging others or mobilizing others to take part in such attacks. Therefore, they should be punished for condemned for terrorism, and not just for participating in terrorist acts. Mr. Rigeusha, counsel for Nsanzimana Sankara, said that in his view, the proceedings were properly conducted according to Article 18 of the law of 2018 against terrorism. And he says that the relevant article is clear that the terrorism is what they were involved in. So they should not be judged in the general article, with the general provisions about definitions and so on, but the relevant article that concerns actual commission of acts of terrorism. And therefore, alias Sankara had said that some of these acts that he is accused of, he was not responsible for, because he was just a military man, and these decisions were taken by others. It was explained that the appeal court summary of the proceedings were correct, and the court agreed that proceedings had been carried out properly. Further, concerning the condemnations or the punishment, the specific punishment for these crimes, it was also relevant to specify where these acts were conducted. So these people, the three people, were terrorists, acted as terrorists, and not just as people who took part in terrorist organizations. In summary, the prosecution was asking that they should be punished not just as supporters, but of being actual terrorists, having actually taken part in these acts. We should be distinguished from being a helper or supporter or an accomplice. The point is to determine the mode of participation in these terrorism acts. Paragraph 1 and 2 of the terrorist law in 2018 provides for the punishment of such crimes, and it says that a person has got to have committed this act themselves or worked with another accomplice, and he has got to have done this deliberately. So it is personal responsibility. The same law of 2018 and also the law, the criminal law in general, also provides that the responsible person is one who committed acts or was an accomplice in those acts or in some other way aided and abetted a crime, but directly. So an accomplice is somebody who helped or facilitated the preparation and the commission of such an act. Therefore, but also somebody who acted looking for a salary of some profit, or who was who instructed or supported or incited in various ways, or helped in some other direct way the commission of that crime, but knowingly. Also, if somebody has promoted publicly acts of terrorism, or attacked or did in some other way promote terrorism, either through written material or speeches or announcements, provided these are announcements or even publications that are meant to reach a number of people. Also, if somebody has helped an accomplice, hidden them, helped them escape, or in some way help them find a hiding place, or help him hide the tools and means that he used for his terrorist activities, or that he contributed in other ways to the tools, means, and resources of commission of these crimes, has hidden some of these items, supported directly a person to hide the evidence of the crimes. International law also provides that attacks with explosives in crowded places, this is a law that was adopted by the United Nations, and was incorporated in Rwandan law, provides that anybody who uses explosives in crowded people, in public transport or other infrastructures with the purpose of killing, maiming, wounding people, or destroying property with the purpose of damaging the property, private or government, or has encouraged or abetted such acts, or supported in any other way any group or at any stage of the commission of such acts should be punished. Paragraph 4 of the law of 2018 against terrorism also provides that anyone who supports, promotes, encourages, teaches, trains, or in any way tries to encourage people to adopt terrorist activities or ideologies should be punished according to the provision of this law. It shows, therefore, that as we see all around the world, that terrorism usually is carried out by individuals, but those individuals are not always the ones that have planned the act of terrorism. There are, they are leaders. And very, very frequently, it is very difficult to find a uniform punishment, because sometimes these people who are the leaders and who were actually the planners and even the originator of the ideas of the commission of these acts of terrorism, sometimes are just punished as accomplices, because it's very difficult to convince them. And it is clear that if there is a terrorist organization whose objectives are terrorism, the Rwandan law has decided that anybody who supports, encourages, promotes, or provides tools and means of the commission of these acts of terrorism that are intended to cause trouble, or to cause revolts, or to rebel against the government, or to fight the government and the leadership, and to also to attack the peace of the population. These acts that will be punished by targeting anyone who planned them, encourages them, or promoted, or sensitized the people who committed these acts. So the person will be punished for the acts that he or she personally committed in the preparation, the execution, and the general organization of such acts. Therefore, at the appeal, at the level of the appeal, RUSESABAGINA, Simon Akaris and his colleague were condemned for all these activities, for planning, for supporting, for promoting, and for organizing and carrying out these activities, the terrorist activities. And in fact, they bragged about them in the media, social media, and other form of communication tools, and therefore it is clear that they did commit them. It was clear that they did commit them. So Salman Amark was not directly convicted of committing the acts on the territory of Rwanda, but he's the one who had planned these activities, or with others, planned these activities, helped the crossing of those who were to come to commit such acts on the territory of Rwanda, and therefore should be punished under the Terrorist Act, because these were terrorist activities, and he was not punished as a direct participant in the actual act of terrorism, but as a planner. Simon Akaris, Alias Sankara, RUSESABAGINA Paul, Nizeyimana Mark were involved in the terrorist acts of MLCD-FLN, but under the law of 2018 against terrorism, they were convicted of committing or having committed terrorist acts, and having organized acts that were meant to terrorize the population. Now, the High Court and the Trans-Border Crime Tribunal were said to have misjudged this law, this case. of 2000 and they were condemned under the criminal code. These people were accused of being part of illegal terrorist acts, and a number of their accused.
Jean Chrétien, Sanzukire Félicien, Munyaneza Anastase, na Hakizimana Theogene baregwaga kujya muri uwo mutwe.
Who were also accused of being part of this terrorist organization. So the prosecution said that the case required that Rwanda, that the intention would be to conquer Rwanda, and also there had to be a use of mercenaries. But the criminal code said that these people were convicted of having taken part in terrorist organizations and other acts that constituted terrorism. So the High Court, it was said, as confirmed by the Supreme Court in the case of Umuhoza Victoire and Deogratias, it was said that terrorist activities were not properly analyzed in this case because the law of 2177 of 2017 concerning mercenaries, and this was considered as a constitutive element of the judgment on terrorism. But in fact, this word was not used in the same way and was not described as an act that is considered terrorism, because the law deals with the other elements and not terrorism. And the High Court, in the judgment, said that the case should be that of invasion, but in fact, the reality is that an attack by illegal fighting groups can also be classified under that law. And the case of 97-13 CS of the High Court in 2016, when the case that was tried in 2013, it was a case of Ndarimana alias Gaheza and co-accused, and the relevant case was tried by the High Court, the Supreme Court, in the case of Harimana Emmanuel. These two cases, the precedents showed that a terrorist activity does not need to include foreign armies or foreign military formations, so that RUSESABAGINA and Nizimana and Cassien and co-accused can be convicted under this count. But Yamere Emmanuel, Nuyura Marcel, Kwitonda, Indrenda, Judgement, Jean Chrétien, Nsanzubikire Félicien, Munyaneza Anastase, Hakizimana Theogene should be convicted of participation or joining an illegal fighting group, an illegal armed group. So in the case, as in the case of Mushahidi Deogratias and Umuhoza Victoire, the law under which they were convicted or cleared of particular counts was later amended So Mr. Rugeyo said that the fact that this line of proceeding was not followed does not mean that there was a mistake in the trial. So that terrorist activities and taking part in terrorist activities is agreed, but the problem is that they didn't know that it was an illegal armed group, and also they did not join willingly. They were forced to join these groups, and therefore should not be prosecuted or convicted under this specific count. Maitre Andre said that actually if you just follow precedents or jurisprudence, you will not try this case properly, because you should also look at the intent or the reason why they were committing these cuts. If they actually intended to join the terrorist groups and illegal armed groups, it is enough, because that is already a crime. Maitre Mugao Sharif Yusuf, Maitre Ramija James, and Maitre Rugeyo Jean did not comment on this particular item. Now, the way the court sees these proceedings, first of all, the appeal. The items about taking part in terrorist organization and the provisions of the laws of 2012 on the criminal, it's actually the criminal code. There were also cases tried by the Supreme Court that can be used to determine the aspect of the item of the will or willingness to take part in act of terrorism. Also, the way those cases are tried followed the case of a court decision that was made in 2019 in the case of Great Lakes Initiative for Human Rights Development versus the state of Rwanda. And in paragraph 33 of the judgment, the court showed that following started diseases, the court has got to follow the line that it adopted, but the higher up a court is in the hierarchy, the more authoritative its decisions. Decisions of higher courts will bind lower courts to apply the same decided principles. And this principle was also stressed in further proceedings by the President of the Supreme Court in the case of the summary proceedings that were made according to those cases. The President said that each judge has to follow the line with the procedure of his court, the level of the court, or the jurisdiction. And if there are any distinguishing characteristics, then he should set them out. And he should also explain why he's overruling that particular line of judgment, and justify properly to the higher court using the various cases that he had tried, provided that they are along the same line of the particular case. And therefore, the higher court can revise this judgment. And indeed, the law of Rwanda has provided that if a precedent is not accepted or is challenged, then that should be explained and justified. Also, I think that we can also say that the Supreme Court at one time was asked to rule on the issue of when a precedent is not followed. And it was said that that can be changed explicitly or implicitly. If it's an explicit, or rather an implicit difference, then it has to be explained. So the court will explain why the judgment was such in this particular case, and why in this particular case the precedent can no longer be followed because of various circumstances or changing times or conditions. But that has to be properly justified. And therefore, the court will decide after having examined all these issues, all the precedents, all the decisions in similar cases, why a change had to be made, what has been modified, so that there is no accusation of superficiality or insufficient reflection and research. In other words, the last case that was tried, if the case is similar to the new one, that last case the decision should apply to the new one, unless there are justifications. Because when a judgment has been made in a particular case, all the courts of Rwanda should follow this precedent. But in this particular case, the accused under 445 of the law of 2012, that is the Code of Criminal Justice, in fact. And he said the following: anyone who creates an illegal terrorist organization, or take part in it, or promotes it, or funds it, or otherwise encourages it, is punished with 10 to 15 years imprisonment. Anyone who accepts to join such groups is punished by imprisonment of 7 to 10 years. The article also says that the accused should be tried and convicted for his taking part in these military activities. And this is a law of 1977, which says that it will be 7 to 10 years imprisonment and 200,000 francs fine for somebody who took part, joined, or otherwise supported through willingly, but knowing that this was an illegal organization, an illegal violent organization. So the fine will be 100,000 francs maximum for those who were persuaded or encouraged to join. Organizations or armed, illegal armed groups. And what he says in this paragraph is that the government of Rwanda, or the state will prosecute this case. Also, the Trans-Border Crime Tribunal gave some precedents as well, saying that joining illegal groups should be tried and condemned following previous similar cases. So the issue is now to know whether these previous cases that were tried were actually conclusive.
Gabire Umuhoza, Victor, and others were accused of creating Coalition des Forces Démocratiques CFD, which is linked to the party FDU in Hingi in order to create disorder in the country, in order to pressure the government of Rwanda to participate in negotiations. The prosecution based on those acts accused them of creating an illegal armed group in order to attack militarily under Article 63 as described above. The Supreme Court considered that this was not an act aimed at creating a conflict between the government and other countries, but rather to take forcefully power or to force the government to participate in negotiations, because this Article 63 is part of the acts, crimes against the country. In this category, we find crimes that aimed at threatening the external security of the country, while the crimes in their case constituted in threatening interior security of the country. The Supreme Court also considered that this was the first time they were examining this question, because in the case of 24 February 2012, in the case of Mshahidi Deogracius, the Supreme Court did not examine this question because at the appeals level, no accused raised it. That's also the reason why in the case decided on 13 September 2016 in the case of Gaheza and colleagues, this argument was not going to be used because the court did not examine the issue of creation of an illegal armed group because it was not part of the appeal. The appeal also concerned the sentence. Therefore, the case of Ingabire Victoire Umuhoza and others should be the reference. The case of Habyarimana Emmanuel was the last one. He was accused of being part of Rwanda's protocol for the return of the kingdom, a party supporting the King Kigeli. This party worked with Kayumba Nyamwasa, and it was aimed at bringing back the king to Rwanda. And his role was to recruit young people who were meant to attack Rwanda. Analyzing the definition of the crime, the appeals court did not consider whether the creation of this group allied to RPA, whether this was aimed at adjoining part of Rwanda to a foreign country, or whether this organization was to be made up of mercenaries. It was rather considered that recruiting people into an armed force, which other than the national legal force, was enough to constitute the crime of creation of an illegal armed groups. That's why Habyarimana, having asked Sebatemba to recruit young people who are to join Kayumba Nyamwasa in his party that works with the King Kigeli, Sebatemba accusing him the same thing, whereas those youth who were arrested in Kayonza on their way to Uganda, this was sufficient to constitute the crime. The Supreme Court considers that the case of Habyarimana, Emmanuel, Ingabire Victoire, and others mentioned before have one thing in common, namely that they are all Rwandans who wanted to create illegal armed groups aimed at changing forcefully the government in place. And none of those armed groups were not made up of foreigners or mercenaries, because those members of it and those who are being encouraged to join them were all Rwandans. This, therefore, proves that the acts incriminated are similar to those of Habyarimana Emmanuel. It was not demonstrated that for this crime to be constituted legally, foreign countries must be involved or foreign mercenaries must be part of those combatants. In the case of Ingabire Victoire, therefore, this was changed. The court finds that although this issue was solved on the one part, considering those who can be accused, the elements, constituting elements of this crime were not sufficiently organized, namely violation of international external security of the country. Those who threaten the security of the country work together with an organization based outside the country, even if these are collaborating with people present in the country. Therefore, all those members of such organization would be subject to prosecution because they are part of an organization that is not allowed in the country to promote it, to have agreements with them, to support military attack of such groups, and to support those through contributions, rewards, or pressure. In this, the present case, those accused of this crime are also accused of the crime of participation in terrorist organizations and in participating in acts of terrorism. Both these crimes are only separate or different in terms of what is the goal. Whereas in Article 459, what is aimed at is to support forces that are illegal, and any terrorist organizations aims at committing terrorist acts. The accused in the present case can be placed in two categories. Some are members of FDLR-SEGA, others are members of FLN. These were never members of MRCD, FLN. These are sons of Kire Felicien Munyaneza and Nastas. And some were members of MRCD, MLN after joining with FLN and other parties. Those who are part of FDLR-FOCA are part of a terrorist organization because this organization is on the list of the UN, the list of terrorist organizations. The court finds that these cannot be found guilty of creating an illegal force when they have been convicted of being part of terrorist organizations as explained by the law. Members of MRCD FLN who are considered here are accused of acts of being part in terrorism and being part in acts of terrorism. In the first category, these have been convicted. Some appealed, others did not appeal. Regarding Nizeyimana Mark, who appealed, saying that his acts were not constitutive of terrorism acts, the court found him guilty of creating a terrorist organization, being part of such organization as seen in Article 41 of this judgment. Regarding Shimimani Emmanuel, he was also convicted by the present court, as we can see it in paragraph 89 of the judgment. Those who were convicted and did not appeal were RUSESABAGINA Paul, Saimana Kalisa, Arias Sankaran, Sengimana Herman, Yamuremi Emmanuel, Nirora Marcel, Kuitonda André, Judgement Jean Chrétien, and Hakizimana Theogène. This means that they acknowledge they were part of a terrorist organizations. The court finds that the FLN, an organization that was created and others participated in it, was not an illegal organization because it did not aim at carrying out a military attack, but its actions were evidenced by the attacks laid in Nyamasheke, Nyamagabe, and Nyaruguru. These organizations aiming at a terrorist organization as we see them in Article 2, 18, and 19 of Law number 46-2018 of the 13th August 2018, related to anti-terrorism as modified to date. The court finds, therefore, that the appeal of the prosecution has no basis, is unfounded. Regarding the crime of support to terrorism, regarding the crime of support to acts of terrorism, the prosecution is dissatisfied with the fact that the court did not convict RUSESABAGINA for the crime for itself, only combining his acts in that regard with others committed under other crimes. This is relevant to Article 1A1 of the Law 69 of 2018 of 31st August 2018 that is aimed at preventing and punishing terrorism. The prosecution thinks that the Court of First Instance should not have based on Law 46-58 aimed at combating terrorism, because when there are two laws punishing one crime, only one law is followed. The prosecution continues saying that since these two laws are aimed at punishing terrorism, the Law 39-79 of 2018 was the applicable law. Because this is a special crime, not one constituting the crime of terrorism. The prosecution also considers that the Court of First Instance finds that the act of crime of terrorism should be a charge against a person who supported an organization, and they consider that this was an error because the legislator never disposed that a person who created an organization or participated in it cannot be also guilty of supporting such an organization when his acts prove that they did. They considered, therefore, that those two acts or the two crimes were committed in the context of a joint criminal enterprise. They also argue that the acts of RUSESABAGINA, namely supplying money and military means, are provided for in Article 3 of Law 69-2018 of the 31st August 2018 that was mentioned earlier. That therefore nothing should have prevented the court to convict him of the crime of supporting acts of terrorism, without excluding the fact that he was part of a MRCD terrorism organization, because both crimes were committed in the context of a joint criminal enterprise. RUSESABAGINA Paul did not respond to this argument of prosecution. The Court of Appeal considers that no convincing grounds were presented to show that RUSESABAGINA Paul supported the MRCD organization that he heads. The Appeals Court finds that the issue should be aimed at knowing whether his support to a terrorist organization should be punished on the basis of Law 69-2018 of the 30 August 2018 that punishes terrorism, or whether rather Law 69-2018 of the 18th of August 2018 should be the basis, a law that is aimed at fighting terrorism, or whether both laws should be considered. Law, Article 2 of the law of 31st August 2018 that aimed at preventing and punishing acts of terrorism says that those concerned by says this regarding those concerned by this law. This law applies to an individual or an organization that is legally constituted in regard of their activities, or whether they are in any way transfer money or other resources. The law also says that for a person to be prosecuted on the basis of this law, first it should be proved that they are concerned by this law. So that means there should be an individual or legally constituted organization, and they should be heading or controlling or an advisor in matters of conserving, changing or transferring money or any other activity. That was not the case under the law of September 2018 aimed at preventing and prosecuting terrorism. This means that the legislator wanted that the law of the 31st August 2018 punishes those mentioned in its Article 2 only. Article 2 of Law 46-18 of 2018, aimed at preventing terrorism, explains what constitutes those acts. In its Chapter 4b, it provides that an act of terrorism is any act that promotes, supports, gives, aids and abates, leads or incites, threatens for, prepares or provides the means for such a crime by any person in order to commit any act committed in Part A. Article 19 of the same law provides that any person who does or attempts to commit or supports acts of terrorism is liable. Those two articles read together lead us to understand that any person supporting terrorism in any possible way has committed an act of terrorism. There is no restriction because this law applies to anyone who commits such acts. As explained above, Law 69-18 of the 31st August 1919 law against against terrorism. This law requires that the person concerned be concerned. These two laws do not concern the same people. Therefore, there is no conflict because each law has determined who can be prosecuted. Therefore, the law can be applied to acts that RUSESABAGINA Paul is charged with without any need to consider whether he is he's part of those people who can be prosecuted under that law. The court did not examine whether RUSESABAGINA was one of those who can be prosecuted. It rather said that this crime should be charged any other person who is not one of those who created it or are in its leadership or management. The appeals court finds that the issue is not whether the person concerned was part of its leadership and at the same time part of those who committed any acts of terrorism, rather that we should consider whether RUSESABAGINA Paul is can be prosecuted under the law that aims at preventing and punishing crimes of genocide. We consider that at no level this, it was never examined or discussed whether RUSESABAGINA Paul was one of those leaders who was responsible for transfer or money or any other resources in order to be liable under this law. Therefore, the court finds that the law 69-18 18 of the 30th of August 2019 can in no wise be concerning him in this regard. We are now about to consider the crimes against which the accused have appealed. Concerning the creation of Nizeyimana Mark and Nshimiyimana Emmanuel appealed for against the ruling on the crime of creating a terrorist organization and being part of acts of terrorism. Emmanuel acknowledges that he was forcefully taken out of his school at the age of 17 and was part of FLN, and then he could not leave this organization because he tried it and was given 300 strokes, and that any person who tried to do that was severely punished, including the possibility of being killed. He considered that the court did not consider the fact that of his personal difficulties, the circumstances of his personal circumstances, and that they did not consider that he was only part of CNRD. He also says that the fact that he was never a member of the FLN, as General David Dirabahizi says it, he says that this shows that he was cannot be guilty because whatever acts he committed them under duress. The prosecution considers that Nshimiyimana says the same thing at appeal as he had said in the first instance, and he was punished. He says that in order to appeal, the appellant must show any error at the first instance, and Nshimiyimana Emmanuel did not do that because the High Court, having examined the arguments of both parties and their arguments, considered him guilty. At appeal, he has no additional evidence proving that there was error at first instance. The prosecution also argues that the first instance convicted him for being a member of FLN based on evidence that he acknowledged himself as he was he was appearing and he was being asked questions by prosecution. He said he was part of FDR FOCA from 2012 and 2016 and in FLN until his arrest on 12th February 2020. He admitted that himself, including on the 22nd September 2022. They also argue that his assertion that he was never part of an terrorist organization has no is unfounded because on the 21st February 2020, Nshimiyimana did not demonstrate that he was not part of terrorist organizations. On the other hand, saying that he was a child at that time, he was young at that time, does not matter because he was of the age of responsibility, criminal responsibility. Regarding the error that the court of first instance is alleged to have made by not taking into account his personal circumstances, his age, and his non-participation in MRSD FTLN, the appeals court finds that this argument is unfounded because, as explained in the paragraph 444, he was part of FDLR when it was separated. He went into CNLD, and he admits that himself. Also, another thing that can not be doubted is that this organization joined others and they created MRSD FLN. Therefore, if when Nshimimana Emmanuel was arrested on the 22nd February 2020, that at that time CNLD had no separate forces because they had become FLN MRCD. For that reason, the appeals court finds that the court of first instance was not wrong in concluding that he was part of that organization and he was arrested while a member of that organization. Regarding the fact that the court of first instance did not take into account his personal circumstances because he was forcefully brought into the organization when he was young and he could not escape, the court finds that also this has no foundation, because as he admitted himself, he entered the organization at the age of 17, and at that age he was not a child. He was therefore liable for his actions. The court finds rather that, as the High Court has concluded, that this age was considered and his sentence reduced from 15 to 13. Therefore, the Court of Appeal considers that when he joined CNLD, he was old enough that he was 23 at that time. This also shows that when the force of CNLD became MRCD FLN, he had no excuse of saying he's a child or he's under duress because he remained in that organization. Considering the fact that he could not escape, the Court of Appeal considers that apart from his statements that he tried to escape and he was punished, and that everyone who tried to escape was severely punished, he does not provide any testimony or any proof that this was the case. The Appeals Court finds that what he says, his assertions cannot be considered to be true because those who said it did not leave that group voluntarily. Therefore, the court finds that the crime of being a member of a terrorist organization is still that he's still guilty of that crime. Zeimana Mark considers that he was not part of the terrorist organization, as the High Court concluded. When he was arrested, he was a colonel within FLN, and he was a deputy commander in 2nd Sector, and he entered later into FDLR FOCA and became a commander protecting Market, responsible for protection in the Masisi sector. He says he left FDLR in 2016 when there was a misunderstanding regarding the counting of refugees, because census of refugees, because those who supported that idea went into CNLD, and he was a member of that organization. He continued acting in his previous capacity, and he said that come 2018, the general told him that the parties were joined under MRSD as a political party, but he did not really give any value to that because he was not have any contact with any politician. He was involved in fighting. He did not participate in meetings, and he says he cannot be accused of that crime, and prosecution has no proofs of that except asserting it. Zeimana Mark was, during trial, and during the hearing, and the appearing of Kwiton and Yamrem Emmanuel and Simon Emmanuel and others and Sankara, all those who lived with him. The prosecution says that Article 107 of Law 027-2019 of the 19th of September 2019 regarding rules of evidence says that when the accused or their lawyer have proofs or evidence that an accusation should not be admitted, or whether, or rather, or that they are innocent, they should say it. But Nizeyimana Shah and his lawyer did not prove that the court erred in basing themselves on that law. They therefore did not contradict the prosecution. The prosecution says they based their accusation on the way the military decisions were taken and his rank in the military, and that he did not bring any new elements. Therefore, as said in the judgment of the High Court on the 14th March 2014, in the case of Thayman and his et al., the appeals court decides that his appeal has no foundation. The court finds that the arguments on this ground of appeal of Nzeyimana Mark are based on the fact that he does not admit that being part of FLN does not mean that he was part of a terrorist organization, that he participated in those acts. The Article 2 of Law 46 of 2018 regarding prevention of acts of terrorists explains these acts in two categories. First, the acts themselves that have consequences on life and property of people, in acts that are committed in order to terrorize, to attack the government or the community, or any given group of the population, to act or omit any act to follow or abandon a given ideology, to destabilize services to the population or the normal course of life, or to rebellion against the government. The second category talks about the acts themselves, preparation and conduct of those acts. Paragraph 11, Part 11, defines the perpetrators as a group of people who come together, and Article 18 punishes such an organization, punishes any person who is accepts a part of that organization or does anything that supports a terrorist organization. Article 19 concerns the punishment of a person who attempts to commit or takes part in acts of terrorism, has committed a crime. When all these articles are read together, they show us that being part of a terrorist organization, committing any acts, those acts are planned, organized, systematically organized organization against the population that meant at terrorizing or harming part of the population to attack a government, to commit or not to commit any act, to adopt or abandon a certain ideology, or to follow such an ideology. Nizeyimana Mark says that he didn't know the aims and goals of such organization. The court considers that this has no basis because he knew that FTLR FOCA was a terrorist organization and remained in it, and he remained in it when it joined other organizations to create FLN. The appeals court considers that, as Nizeyimana Mark explained himself in the High Court, that he admitted that such organization aimed at removing to topple the regime in Rwanda, and that he conducted the acts of such organization in Nyamasheke. These acts are acts of terrorism as explained in Article 2 of the law of 13th August 2018, a law for prevention and punishment of acts of terrorism, as explained earlier. Regarding his arguments that he did not set foot on the territory of Rwanda where the crimes were committed, the court finds that this does not exclude him from responsibility, because I explained in article, in paragraph 38 of this judgment, the superior is not punished for what was committed by others, but acts that were committed previously and the execution of the subsequent act of terrorism. The Court of Appeal considers, therefore, that on this ground of appeal, Nzeyimana Mark's appeal is unfounded. Regarding complicity and incitation to commit acts of terrorism, he appeals the decision of in the judgment, saying that the High Court erred because he was not accused of this crime, and he requests the appeals court to declare him innocent of this crime, because Batakamba, Jean Berkmans, and others incited people to commit this crime, but he was not mentioned in this regard. The prosecution agrees with Simon Elias Motar that he was not accused of that act, therefore, that the court should not convict him. The Court of Appeal considers that, as this appears in Article 367 of the judgment, the appeals court, in its decision, has convicted Elias Motar of this crime. But as it appears in paragraph 679, he was not one of those that had committed this crime. As Elias Motar says, in agreement with the prosecution, the High Court erred in convicting him on the basis of this crime. We have now come to the fourth part that is examining the grounds of appeal related to the sentence. Some sentences were not found to be fair by prosecution, and others were appealed by the accused. We will first examine in the first part the grounds of appeal of the prosecution. The prosecution attacked the High Court's judgment because some accused have pleaded guilty and the court reduced their sentence. Also, the court reduced the sentence on the basis that this was the first time they committed a crime. The prosecution also considered that it was an error for the High Court to reduce the sentence to the point of going below the standard reduction fixed by the law. We will first see to what extent the accused pleaded guilty. Was that plea sufficient to warrant reduction of the sentence? Secondly, it will be examined whether there are other reasons why the sentence should be reduced. And to conclude, the court will examine whether the previous court went below the standard reduction approved by the law, considering whether the guilty plea was sufficient to warrant reduction in the sentence. In this regard, prosecution criticizes the special branch of the High Court that judges international crimes, considers that these individuals mentioned were obtained a reduced sentence because they pleaded guilty, although they did not do that fully and without any doubt. Considering RUSESABAGINA, the court did not consider that from the time he was arguing against the increase of his sentence, he did not consider the court. He did not consider that the court has jurisdiction, and he withdrew from the case. The prosecution considers that under Article 59 of Law 69 18 of 30 August 2018, that law provides that only those who admit their crimes from the beginning and without any doubt can benefit from the reduction of the sentence, and that this does not apply to RUSESABAGINA, and this should not be mitigating circumstance for him, because the act of creating a terrorist organization and being part of a terrorist organization were established, and that there is no reason why RUSESABAGINA should benefit from the reduction of sentence. He said nothing about that because he did not take part in court hearings. He did not attend. Concerning Nizeyimana Mark, prosecution argues that Nizeyimana was convicted of acts that led to death, and that normally these acts lead to a life sentence, but he was only sentenced to 20 years because he because he admitted a number of things during the trial. But during the trial of 29th April 2009 and 26 May 2021, he denied all the acts. He admitted only one crime, namely being part of an illegal organization, military organization. And on this one, he was declared not guilty. He denies all the others. Prosecution continues by arguing that the High Court considered that Nizeyimana Mark admitted a number of things during investigations, but later on he changed his mind and denied them. The Article 59 of Law number 68-18 of the 30th of August 2018 that provides for crimes and their sentences says that any admissible plea is the one that is done from the beginning to the end, and that is done fully. The prosecution considers that Nizeyimana Mark did not do that, and that nothing justifies his reduction of sentence. He admits that he was part of a terrorist organization, and he expressed his regrets, but he denies all these other crimes that he admitted in the face of investigations. And he says that the reports that were written were not true, and that's why he did not accept them. Maitre Murekatete Harriet, his lawyer, considers that the Court of First Instance did not commit any error because, as we can read in paragraph 376, this is explained. Regarding Sanzubukire Felicien Munyaneza Anastas, prosecution considers that the High Court found them guilty of one crime, namely being part of FDLR FOCA, and reduced their sentence because they pleaded guilty to some acts, and during the pre-trial detention and during trial. But the prosecution finds that on this crime, the High Court found them not guilty. But they had indicated they do not admit being part of a terrorist organization because when they were arrested, they were no longer members of FDLR FOCA, and they were now members of SN Ubuyunge. Also, they said that since the time they left the country, fled from the country in 1994, they never came back to Rwanda, and no attack by FDLR FOCA was conducted in their presence, and that they never made any decision because then they were not among the leadership of this organization. The prosecution considers that this argument of Sanzubukire and Munyaneza do not fully admit their crimes to justify their reduction of sentence.
And the fact that he was in FLL was not wrong, because at the time he joined, it had not been described as a terrorist organization, and therefore the first instance may have founded its judgment, should have founded its judgment on this background, and since they did reduce his sentence on that basis, they were right. Munyaneza said that he was in FDLR, but regarding the reduction of his sentence, he thinks it was properly done. Maître Twajamahoro Harman the counsel for Munyaneza, Ustaz, and et al. Explained that his clients had agreed with the sentence, and that and therefore there should be their pain should be reduced, their sentence. And Judgement Jean-Chrétien Hakizimana Terrorism et al. As far as they are concerned, the reduction of sentence was based on the fact that they pleaded guilty, but in fact, during the trial, they did not admit the 3 counts on which they were accused, only on two counts as regard their participation in terrorist organizations. And therefore, saying that they pleaded guilty is not correct. And therefore, that should not have been the basis for the reduction of their sentence. So their lawyer said that Andre did plead guilty, but what he meant was that he was not responsible for what they are accusing him. Therefore, that cannot be counted as admission of guilt or pleading or a guilty plea. And therefore, the reduction was wrong. His co-accused said that he agreed that he had joined these organizations or terrorist organizations, but in fact, when he joined, they were not called terrorist organizations. But so the fact that he admitted being part of them was an admission of guilt. The lawyer said that there was nothing wrong with his client admitting to the accusations, because in fact, because that was the case. Judgement Jean-Chrétien admitted that he was a member of FLN, but he also says that he did not know it was a terrorist organization. And in fact, he joined because his father was one of the leaders of this organization, and that he just joined like that. Why? So he admitted that whatever he's accused of, he admits, but he did not know it was a terrorist organization. The third accused also said that he joined the organization because he was frightened into it. They told him, or they threatened him with all kinds of things if he failed to join. And therefore he said he joined unwillingly, which means that he should have his punishment reduced. But this is contested, because in fact he did join an organization, a terrorist organization. He admitted that he did so, and therefore the fact that he admitted and confessed earned him a reduction of his punishment. So the Hakizimana Theogene, Jean-Chrétien et al. With regard to Andre, he did admit, and in fact the relevant article of the criminal code says that if somebody confesses and admits, nobody should come and challenge that admission. So Judgement says that he did the things that he was accused of, and therefore there is no reason to reduce his sentence. Or rather, since he admitted, there is nothing wrong with reducing his sentences. Maître Mugabo Sarif Yusuf said that his clients also admitted and confessed to their guilt. and that they never said that they were not part of these terrorist organizations, and that they explained that they did join, but under duress. And the lawyer, Mr. James, also concurred. As regards Makaruti Angelina, the prosecution says that she was convinced of one count of being part of a terrorist organization, and that she admitted to some of the things she is accused of during investigation. But during the trial, she said that she had recruited a number of girls to join the organization before it was MLCJ, when it was under a different name. And therefore, witnesses, but however, witnesses, including those girls she recruited, explained that she recruited them when the organization was already viewed as a terrorist organization. And therefore, the relevant article of the Criminal Code should apply. Makanuti Angelina said that from the beginning she admitted that she was a member of MRCD and Unje because she was a commissioner for women's development or women's promotion. The idea being that the Mai were attacking them, and therefore she told girls and young women to go and fight, learn to fight in order to defend themselves against these attacks of Mai. But she was not planning to attack Rwanda, to get them to learn to attack Rwanda. Her lawyer said that the Mkandutie should not have had her punishment reduced, her sentence reduced, because all she did was to admit that she was guilty. She said she did the same during the trial, and she explained that she was a commissioner for women promotion, for the family and women promotion, and that her role was just to encourage these girls to join the army. And she listed the number of the girls who had, when the girls had been convinced, she sent them to Antoine Giva Wilson for further training, to take charge of these girls for later. But the accused said that she was a civilian, she was not a military person, she did not know what those girls were being trained in. Maître Mukaruzagiriza Chantal said that her client was a member of the Ubwiyunge, but that was which then joined other terrorist organizations. And the lawyer, the counsel says that Mkandutie Angelina had actually clearly admitted her guilt, on the basis of which her punishment was reduced, which is in conformity with an article of 2018 on the Code of Criminal Justice, where it says that a judge will assess the sufficiency or otherwise of our confession and admission of guilt. Thank you very much. Thank you very much. Let us have a break for 15 minutes and come back at 6:30. 11:30. Or what do you think? Yeah, you just say what you think. Should we have a lunch break, or should we continue and finish and then go to break? It's up to you.
Nganiki batubwira yes gira imbere.
Come and take a microphone. Thank you, Your Honor. We don't know how much work you have. I mean, so we cannot decide whether we shall have a break at lunchtime, because if it's up to 1, okay, or maybe 1 something. But I mean, if you're going to, yeah, but Lure means long how? Long how? But because it's very long, then if very many more hours, then we should have a break, lunch break. Okay, so how long? How long? I mean, like the prisoners, are you going to take them back to lunch? How much time do you need? This is what I'm worried about. Because if you have to take them back for lunch, well, then you tell them how much you can, how soon you can bring them back. Well, maybe, I don't know, you can't make up your mind, Paz? Anybody who wishes to speak? I think the normal, the standard lunch break of 1 hour. Okay, so we break at, let's break at 12:30. No, it's 12:30 is already, it's just now. So maybe, how about 1 to 2? We break at 1 and we come back at 2. At 2. If you all agreed, okay, so let us continue. We were talking about how the about the legal discussions of the various legal debates. Thank you very much. So we were discussing how the appeal conclusions were viewed by the lawyers, and now we move to how the court assessed the proceedings. And generally the discussion was about whether their punishment should be reduced or not, or their sentence. And there are articles that provide for a reduction of sentence, and the discussions was about that item, and therefore we should see whether all those decisions were taken properly. The article says that in Article 1, the judge can reduce the sentence if the accused has admitted guilt, asked for or apologized and asked for pardon, and accepted to pay whatever compensation they were asked to give. Second, paragraph 2, the judge may reduce the sentence if there is admission of guilt straightforwardly. Actually, before this article, this article revises or amends a previous one of the Criminal Code, the Code of Criminal Justice, that said that a judge may reduce the sentence if the accused admits guilt, apologizes in a straightforward manner, accept to pay the compensation that was decided. The difference is that in the earlier law, it was enough to admit guilt clearly. But the Supreme Court, when trying the case or judging the case or deciding the case of 2015, that was a case of Hiranya Boniface versus the prosecution. And it said that sometimes admitting guilt benefits the accused so long as they are not hiding anything or they don't have ulterior motives. So long as it's not a means of covering up whatever else may have turned up. The case of 2022, that was a case of Musangamfura Damian. In that case, the judgment was that a sentence may not be reduced simply because of admission of guilt alone. So the decision being that it is necessary for the following conditions to be filled. First, the admission of guilt should be straightforward and should apply to the case as tried from the beginning to judgment time, and that there should be no minimization of some aspects or desire to hide some of the aspects of the guilt, but also to acknowledge the consequences of that guilt. Second, to be sorry, not just to be sorry, but to promise or to commit to never repeating it again. A third, to apologize clearly, and to commit to paying compensations that were decided. And that should also be done at first instance. Therefore, this court will now examine the case of Sejibana Herman and RUSESABAGINA et al., including Jean Chrétien, Hachizimana Theogene, Mukandutier, Angelina, who had admitted and confessed as a means of having their sentence reduced. As regards the RUSESABAGINA Paul, the tribunal on international and transborder crimes concluded that he admitted some of the accusations and should therefore see his sentence reduced. But during the appeal before the special court, it was, and also before a decision to sentence him to imprisonment, the RUSESABAGINA refused to come to court to attend the proceedings. And the appeal court found that the accused, having accepted or admitted his guilt, should admit his guilt on all counts and should do it at the first instance when the trial is being conducted. If the accused does not admit, or rather, if he intends to admit then he should say it straightforwardly and accept his guilt on all counts. And but he should then not come back during the actual trial and try to come back or to go back on some of the items and maybe challenge his admission. Also, he should make these issues clear during the proceedings. Another point is that the judge should therefore assess the nature and importance of this admission of guilt or the guilty plea, because the relevant law explains when it's applied, the assessment of that case is that during the proceedings, the way RUSESABAGINA, for example, accepted that he sent some money, he admitted that, but he did not admit that the FLN was a terrorist organization. And therefore, he said that if there were crimes, okay, maybe he can admit them. But that's not enough. He cannot say that he's sorry, but at the same time say that he doesn't think he had a role in that, or FLN had any role in that either. Therefore, this guilty plea is not sufficient to warrant a reduction of sentence. As regards Nizeyimana Mark, the case shows that the Special Court on Transborder Crimes, in the case of Nizeyimana Mark, during the case, the trial, especially when at the beginning when there was a discussion of whether he should be tried in prison or out of prison, it was found that before Nizeyimana Mark started the plea, before that, he had already said that he does not agree that he was involved in terrorist activities or in illegal organizations, or that he intended to attack Rwanda. He said that at the beginning. And then during the trial, he did admit that he was a member of FLN-FOCA, that he was a colonel when he was arrested, that he was also the sub-commandant or the deputy commandant of the sector. And he said that, in fact, he was not actually a member of the other organization, that he was not involved in terrorism, and that, in fact, there is nothing in the articles of the statutes of these organizations that say they are terrorist organizations, that they want to do terrorist activities, nothing of that. He only learned when he came to court and when he was being, or rather when he was being interrogated and when he came to court. Before that, he didn't know it was a terrorist activity. The court found that during his trial, his hearing, the initial hearing, and when he was asking to be tried outside the court, he did say that these organizations were not terrorist organizations because their aim was to topple the government of Rwanda, and that is not terrorism. He said also that he was asking for 8 of the counts of his accusation be scrapped because he did not recognize him. Second, he said that being a member of an illegal armed force That he admitted, he asked pardon for that, and he said since he was a first offender, he should be treated with leniency. During the appeal, he also said that he did not admit to terrorism or to having joined a terrorist organization. Therefore, given the above, what we just explained, he was actually in the first instance, it had been agreed that he was not a terrorist. All he did was to join this organization, and he joined before these organizations were described as terrorists, and that what he did had nothing to do with attacking the security of Rwanda, and that he admitted to joining an organization, an armed organization other than the Rwandan army. The law, the relevant law of the criminal code provides that since he did not admit the accusations, it was wrong of the lower court to reduce his sentence, because the relevant law does not allow a reduction of sentence for somebody who has not admitted to guilt. Regarding Sanzobukire Felicien Munyaneza Anastase, it was found that the proceedings of Transborder Crime Tribunal about Sanzobukire Anastase and his co-accused, as that during the trial, especially the time that they were asking to be tried outside prison, that it was found that given that the criminal code does not, or the amendment of 2012 on sentencing, it was found that the two men were convicted of having joined a terrorist organization, but not an illegal armed group. But reading further in the proceedings report, he actually said that he joined an illegal organization, or a terrorist organization. But he said that he joined it unwillingly, because in 2016, when he left one group to another, and then he was arrested by the Congolese army, and therefore he left that organization before it was described as a terrorist organization. He had already left it. He had gone to CNLD on his own will, and therefore, having left that organization, he can no longer be held responsible for the activities as provided for in the relevant law of 2012, as we mentioned above, the criminal code, because that law punishes someone who is actually in a terrorist organization and involved in terrorism. Right. So, as in paragraph 403 to 405 of the report, Munyaneza said that he was part of an illegal organization. 2002 to 2012, 2016, he was in that outfit until he was arrested by the Congolese army in 2017. And he said he was not a member of that organization because that organization was described by the American authorities, an American report saying that it was a terrorist organization, but he didn't know that it was so described. And in any case, he never took part in any terrorist organization because looking at the list, the UN list of terrorist organizations in that area, he was not a member of any of that. So that Felicien and Anastase Munyaneza had admitted that they were a member of the FDLN from 2002, and they left in 2016. And therefore, they were members of a terrorist organization. But since they were no longer members of that organization when it was described as a terrorist organization, they cannot be convicted for that. But the article we just cited says that when a person is a member of an organization, a terrorist organization, that is later found to be, or rather confirmed as a terrorist organization, he can still be accused under that. But he said, no, I left that organization in 2016. When I was arrested, I was no longer a member of FDLN. Therefore, you cannot accuse me of the crimes of that organization because the decision to describe it as a terrorist organization was taken later. Okay, so there Munyaneza himself said actually he didn't even know. Although that had been already described as a terrorist organization, he didn't know. And he just joined it because, well, you know, he needed to survive. And the two men admit that they were part of that organization, but they refuse to admit that it was a terrorist organization at the time that they were in it. Therefore, they're not sorry for anything. And given the explanations that we have just given above, Munyaneza, Anastase, and Sanzwikire Felicien should not have had their sentence reduced because the conditions are not there. So regarding the other group, of which Theogene is one, Judgement Theogene, the decision of the tribunal on transnational crimes, it is found that Nsanzimana Theogene, when he was pleading to be let out of prison during the trial, he also said that his sentence should be reduced because of his behavior during the trial, because he and Andre admitted that they were part of a terrorist organization. This admission should have earned them a reduction of the sentence. But another paragraph in the report says that the two men admitted that they were part of a terrorist organization and therefore should have their sentence reduced. But another paragraph says that, in fact, Nsanzimana Herman, as he had said earlier in the case, he actually admitted being a member of FLN, and that is Semana Kalisa Sankara who recruited him, but that he didn't know it was a terrorist organization or even an illegal organization, because their aim was just to fight in order to force the government of Rwanda to negotiate with them. And Nsanzimana Herman was also explained that he was not guilty because he was not really a member of MLCD, and neither a founder nor a member, and therefore he should not be accused of that. The fact that he was in the fighting branch, he should not be. He should therefore not be responsible for the crimes of a political group or political branch. Nsanzimana also accepted that he was part of this organization, but he went there by force. He was only 17, and in fact he was just taken there by force, and that in fact he had explained during the investigation, interrogation, and so on. He explained clearly that he was never a member of the MLCD because it was separate from FLND, being the armed wing. Andre, when he was during the trial, he accepted, or he confessed being part of these three organizations, but he did not know they were terrorist organizations. And in fact, this is what he had been asked during the investigation, during the trial, and when he was requesting to plead out of prison rather. And he insisted that these are the issues that he had raised from the beginning at all stages. And Hakizimana Theogene said he was a member of FNL Focus, NLD, but he did not know this organization was terrorist. And that he went on being part of them because he couldn't leave, because anybody who wanted to leave was very furiously punished, ferociously punished. And that but in any case, he was never a member of MLCD-FLN. The paragraph 49 of the court report, the proceedings report, say that in the case of Nsanzimana, he admitted during the trial that he was a member of FLN, but that he was coerced into it and remained in it because of fear of punishment. But therefore, whatever he did, he was manipulated into it, and therefore he cannot be held responsible. The appeal proceedings found that Nsanzimana had admitted that he was a member of this organization, but did not admit that it was a terrorist organization because it was the armed wing of the political wing of that organization, and there was nothing that has proven that he was one of the founders of MLCD-FLN, and therefore he should not have had his sentence reduced because he didn't admit clearly guilt of this. And also the way he talks is like he doesn't really understand how serious his case is, how serious his participation in terrorist activities is. He just doesn't weigh the weight sufficiently. He said that he was part of this organization, that he remained there because of fear and coercion, but he was convinced or convicted of being a member of a terrorist organization. And therefore, since he did not admit anything, he didn't even understand that what he had done was wrong, and therefore could not apologize and feel sorry, and there was no need, there was no basis for reducing his trial, and therefore there is no error in his trial. As regards the third accused, well, like the two preceding ones, he also admitted that he was a member of this organization, that he joined it willingly, that he knew it was a terrorist organization. But they say the branch they were in was the armed group, and therefore they were not guilty. So the conclusion of the law court was correct. As regards Nsanzimana Theogene, he admits that he was a member of FLN, but that he joined it and remained there because he was afraid of being punished if he left. But he didn't know it was a terrorist organization, that the leaders never told them that it was a terrorist organization, and that he was never told to commit any act of terrorism. And therefore, since he said he didn't know it was a terrorist organization, it means that he does not recognize his error, his crime, does not understand the extent of his crime, and in fact is just trying to reduce his guilt, and which means that there was no grounds to reduce his sentence. As regards Makanduti Angelina, the paragraph 445 of the proceedings of the Transnational Crime Tribunal, it shows that this is the first time that she's a first offender. She admitted the guilt, and therefore there should be leniency. Well, before that conclusion was made, it was found that in fact she admitted being part of this organization, and that she was in charge. She was the Commissar for Family and Women's Promotion, and that she actually mobilized girls, recruited them for training, but she didn't know what they were being trained for, and she was not involved in anything other than just that. Paragraph 424. It says that Mukanduti was a mobilizer, but she used to mobilize before her party joined these terrorist organizations, and she did this because she thought it was good for girls to learn to protect themselves, defend themselves. And it was found therefore that although she said that she joined FTLR and again also CNL later in 2006, when this structure had an armed branch, and when she joined, she was promoted to the officer responsible for women and girls, and she said that yes, I was a member of MLCD-FLN. Yes, but I didn't know it was a terrorist organization. And the appeals court found that, as I said on page 6 of the proceedings of the lower instance, Mukanduti admitted that he mobilized women and girls to join this organization. And in fact, 2 of the girls that she recruited have confirmed that and have explained this. Therefore, as it was explained later, saying that she was a member of this organization without knowing that it was a terrorist organization shows that she doesn't admit guilt. She doesn't admit that this was wrong. She is simply trying to escape responsibility, and therefore, as regards this particular count, she should not have had her sentence reduced, and therefore there was no error in the trial.
The following ground of appeal concerns the issue of knowing whether the reduction of sentence for some accused based on the fact that they were the first-time offenders was justifiable. The accused are RUSESABAGINA Paul, Nizeyimana Mark, Tsazubukire Félicien, Munyaneza Anastase, and Mukanduti Angelina.
Paul.
Concerning RUSESABAGINA Paul, whether the reduction of sentence for him based on the fact that he was a first-time offender, prosecution considers that this per se should not be a reason for reducing the sentence, since based on this reason, the court did not consider Article 49 of the Penal Code and the seriousness of the act he committed involving death and destruction of property and people being physically harmed. On the 24th of February 2012, in the matter, the prosecutor against Mushahidi, on its paragraph 40, we see the jurisprudence that should be followed. This is case number RPA 0298-10- Cour Supreme. Rusesabagina said nothing about that. Also, the fact that Nizeimana Mark is the first-time offender and therefore that he could benefit from reduction of sentence. The prosecution says that this was an obvious disregard for the gravity of his actions. And this, as it is the case for Rusesabagina, even if this is the first time, the judgment of February 21, 2012 rather, in the matter of Mushahidi, also he did not deserve to benefit from the reduction of sentence. Munyaneza Anastase. The reduction of sentence based on the fact that they were the first-time offenders and that their crime did not have any effect or consequences because they never committed the crimes on the territory of Rwanda. These two senior officers of FDLR, FOCA, organizations that attacked Rwanda at different times, the fact that they spent 14 years within an terrorist organization as it appears in the appeal judgment, namely from 2012 and 2016, this means that they had an opportunity to leave this organization, but they didn't do it until they were arrested. They did not leave them voluntarily. Saying that it's the first time they are prosecuted, this is not true because Sanzibukire Felicien is on the list of the UN as one of the decision makers within these terrorist organizations. Therefore, the fact that the court in first instance based its decision on this was an error. Sanzibukire Felicien and Munyaneza Anastase have not proposed any arguments to this effect. Concerning Mukanduti Angelina, the reduction of sentence based on the fact that she was a first-time offender is considered by the prosecutor as not being true because she was already serving a life sentence that she obtained from Gacaca courts. She says that she knew about her sentence in 2006 and she has said nothing about it, and therefore prosecution should not base its argument on that. Her lawyer says that the ground of appeal of the prosecution on the reduction of sentence of Mukanduti and Angelina based on being a first-time offender because she has been convicted by the Gacaca courts, says therefore that the paragraph 685 of the judgment should be the reference. The Court of Appeal will now examine whether the reduction of sentence is justifiable because an accused is a first-time offender. Mitigating circumstances exist, and we find them in Article 64 and 65 of Law 68/18, 2018 of 30 August, that concerning the penal code. There are grounds for reducing the sentence. We find them in Article 59, but it's not the only one that is relevant because it shows only examples that could be followed. This means that there could be other grounds, other reasons, namely the fact that an accused is a first-time offender. Article 49 and 48 of Law 68/2018 of 30 June provides for that. Article 49, paragraph 1, says that a judge can examine the crime, the reasons for the crime, the personal circumstances of the accused, and the mode of commission. Article 58 says that the judge decides whether mitigating circumstances can be given any value. Confirmation of mitigating circumstances must be done within the judgment. The judge examines the life of the circumstances of the life of the accused, the crime itself, its gravity, and its consequences in society. These two articles also provide that the judge can has the power to grant those mitigating circumstances even in cases of serious crimes and serious crimes. Reduction of a sentence does not reduce the gravity of the crime. This means that the gravity of a crime and aggravating circumstances should not prevent a judge from deciding that that the accused deserves to obtain a reduction of sentence based on their particular circumstance of their life. And that's the reason why the legislator in Law 68/2018 of the 30th of August 2018 decided that the judge should consider the aggravating circumstances and the mitigating circumstances in deciding the sentence. We will now examine whether the court committed an error by reducing the sentence of RUSESABAGINA Paul, Nzeyimana Mark, and Nsanzumukiire Felicien, Munyaneza Anastase, Mukanduti Angelina, on the basis of the fact that this was the first time they were committing a crime. Regarding RUSESABAGINA Paul and Nzeyimana Mark, regarding those two individuals, as mentioned before, when we were considering the mitigating circumstances, we found that they were first-time offenders. Based on the law cited before, the court finds that Article 49 of -18 of 2018, that this fact should not be mitigating circumstances in and by itself. because this article gives the judge the authority to base on it does not mean necessarily that the judge should grant that reduction, namely the mode of commission, the life of the accused, and the consequences. The judge must only consider the law that was mentioned before and determine an appropriate sentence. RPA-98-Cour Supreme, in the matter the prosecutor against Cour Supreme, against the prosecutor, the court decided that his crimes were serious and they should not deserve any reduction. This should be also the case for Nzaimana Mark and RUSESABAGINA Paul. The appeals court finds that the prosecution misunderstood the operationalization of the law of 30 August 2018, because the articles that were cited grant the judge the authority to appreciate the sentence. This also appears in the case of Ingabire Umuhoza, who, like Mshahidi Gracias, was accused of treason, and her case was the second one. Her sentence was reduced on the basis that she was the first-time offender. Therefore, the Court of Appeal finds this argument of prosecution not founded. Concerning Sanzbugira Anastase, as we see it in the appealed judgment, the court found that since they were first-time offenders, these Sanzbugira and Munyaneza were first-time offenders, this was to be considered to reduce their sentence. The appeals court finds that the argument of the prosecution, namely that these two were senior officers of FDLR FOCA, that they were 14 years long in that organization, and considering the gravity of their crime and the consequences of the attacks conducted on the territory of Rwanda, that they should not benefit from reduction of sentence just because it was the first time that they committed a crime, or that their actions did not have any consequence because themselves did not take part in the attack in Rwanda. The prosecution saying, therefore, that that should not be considered because the aggravating circumstances do not the appeals court finds that this is not founded because the aggravating circumstances do not limit or prevent a judge from reducing the sentence, appreciating the circumstances of the accused, and adopt an appropriate sentence. For those reasons, the appeals court finds that this argument of prosecution is not founded. Concerning Mukanditie Angeline, as indicated above, one of the mitigating circumstances adopted by the Court of First Instance that led to reduction of sentence was provided for by the law, namely that she was a first-time offender. The analysis of the appealed judgment shows that the prosecution did not raise the issue that she was sentenced previously on the Mukanditie Angelina herself in the judgment mentioned or informed the court that she was sentenced by the Gacaca court. The appeals court finds that what Moka Ndutie Angelina herself informed the court, and that the prosecution said nothing. The appeals court finds that the prosecution should not attack the decision of the court when they did not raise this matter or adduce any evidence in trial showing that Moka Ndutie was convicted by Gachacha court, and that this constituted an aggravating circumstance. But we find that on the 21st of February 2022, that the prosecution submitted the judgment of the Gachacha court for the second category, showing that on the 23rd of February 28, the Gachacha court of the Rugenge district in the Nyarugenge district had convicted her to life imprisonment. The court of appeal considers that had the court of first instance seen the judgment in Gachacha, that this court would not have confirmed or indicated that she's a first-time offender. Therefore, this idea that she's a first-time offender should not constitute a basis for reduction of sentence. Another issue is whether the court erred by deciding a sentence below the standard accepted norms. The prosecution appeals the fact that RUSESABAGINA Paul, Sanzimana Kalisa Sankara, alias Sankara, Tabanga Nyimana, Nikuze Simeon, Irola Marcel, Yamurem Emmanuel, Sengimana, Kwitonda André, Shimimana Emmanuel, Dagimana Jean Chrétien, Hakizimana Théogène, and Moka Ndutie Angelina, that they obtained a reduction that went below the accepted standards. Prosecution continues by saying that the Court of First Instance misused Law 68-2018 of 30 August 2018 related to the Penal Code concerning the reduction of sentences in consideration of mitigating circumstances. He criticizes this by saying that the sentence should not go below 25 years when the accused deserves a life sentence. Therefore, the argument is that the sentence should not go below the reduction that is allowed. Also, the Court of First Instance is accused of having misregarded Article 48, saying that the judge should be bound by the law, and that no sentence should be reduced outside of what is provided for by the law. That is very true. The fact that the court reduced the sentence below the admitted standards, that was an error. There is precedence and jurisprudence about the hierarchy of laws, and the decisions of courts are not above the law. The fact that the law existed and it was understandable, those laws should have been the norm and the reference, unless those laws are proven to be contrary to the Constitution. But but a law should not apply if it's against the law. The the court finds that the decision of the High Court was misrepresented on the application of Law 69 that was never abrogated by the High Court. Rusesabagina Paul did not react in this matter because he did not, he was not present at hearing. Sankara and his co-accused and their lawyer considered that the reduction was justified and that not going below that standard was not in accordance with a fair trial as enshrined in the Constitution. They, Nsengimana Herman, considering the mitigating circumstances, obtained 5 years of imprisonment, and he considers that there was no error. Maitre Mrekatete Henriette, who represents Mark, considers that the fact that the court went below the standard reduction in order to ensure a fair trial as in accordance with the Constitution of Rwanda. Maitre Mahoro Herman says that the fact that his client was sentenced to 10 years, a sentence below the standard fixed by the law, he considers that is not an error because the jurisprudence of the High Court adjudicated that the judge is sovereign in sentencing, and that the importance of the sentence should not only be based on the gravity of the crime, but also on the interest of the accused. Therefore, he says that also looking at the Constitution of Rwanda that provided for the independence of a judge in determining the sentence, he considers that the reduction of sentence for Nikuzwe Simeon below the standard fixed sentence was not an error. Kirabo Guido, representing Nabanganyimana Joseph, considers that fair trial is such that the judge does not base the decision on the law only, but also considers the jurisprudence. That's why the jurisprudence of the Supreme Court of the 2019 Kabasinga, Florida, against the government of Rwanda, judgment of 28 February 2022, and the RPA dash of 28 October 2021, that these judgments on the aspects of preventing a judge from deciding a reduction of sentence, that this is a violation of the principle of fair trial. And on that basis, he argues that the reduction of sentence was not an error. The lawyer of Chimiman Emmanuel and the co-accused argues that the law 68-2018 of 30th August 2018 should not be a hindrance for the judge to use his independence as long as the judge can justify his reasons for reducing the sentence. He considers that the reduction of the sentence of his clients was therefore founded. Mr. Sharif Yusuf, Mugabo Sharif Yusuf, representing Kwitonda Andre, Ndagijimana Jean Chrétien, and Hakizimana Theogène, is of the opinion that, on the one hand, Article 68 of the Law 3818 of 30 August 2018 concerning penal code. For him, he considers this article poses no problem. That's because when the court adjudicated in the aforementioned matter, did not set aside that law, but considers that compared to Article 151, paragraph 5 of the Rwandan Constitution that provides for independence of the judge, he says that this article limits his powers when he needs to ensure fair trial. He continues to say that what is said in the previous section, that the law of 30th August 2018 and Article 9 of Law 022, number 22, stroke 2018 of the 29th of April 2018, that concerning the rules of procedure on various matters shows that the judge should be sovereign. He argues that based on case RS space 33003 stroke Cour supreme, judgment of February 2019 in the matter Kabasinga against the government of Rwanda, and the judgment of the 28th of February 2018, the prosecutor against Safashanawi Jean de Dieu, in order to considering the independence of the judge, which cannot be limited by a smaller sentence, and that this shows that the judge could go below that standard, and that this is confirmed by the judgment that the judge is independent to find a solution based on those laws. He therefore considers that the reduction of sentence, even below the standard proposed reduction, was no error. Mukaruzagiza Chantal, who represents Mukanduti Angelina, is of the view that the reduction of the sentence below the standard fixed reduction is no problem, because a sentence can because the fact that the court of sixth instance based on a judgment and jurisprudence of the High Court in showing that not to reduce the sentence below the fixed standard or the fixed norm is a violation of the judge's independence. The judge's independence to pronounce a sentence below the lowest threshold is not an error, and this was confirmed by the judgment RPR 0031-2011 Court of Appeal, rendered on 28th October 2021 in the matter the prosecutor against Bahati Francoise in its 43rd paragraph. The appeals court therefore considers that the arguments on this matter are based on the fact on the issue whether the High Court erred in reducing the sentence below the fixed standard. The principles concerning execution of sentences provides that the judge should be able to apply the law to the matters at issue. When a decision is made by explaining the law, a wider explanation can be given, or the law can be interpreted in a strict matter, as explained in the on paragraph 51. When somebody is not happy with the application of these principles, instead of seeking ways of the court to not to apply them, they should seize the court applying for non-application of these laws. The referenced judgment was the judgment of the 28th of February 2020, by which RUSESABAGINA Paul, Nzaimana Kadik Saria Sankara, and Nzaimana Mark Nikuze Simeon, and Banganyimana Simeon, Nira Marcel, Yamrem Emmanuel, Sengimana Yarma, Kwitonda André, Shimimana Emmanuel, Judgement Emmanuel Jean Chrétien, Ekizimana Théogène, and Demokaji Tie Angelina, reducing the sentence below the standard proposed reduction. The lowest threshold was gone below, also based on the judgment RS-003-2019-20 Supreme Court, rendered on the 4th of 12/2019. On the basis of principle explained in paragraph 2016 of this judgment, the appeals court considers that this judgment of Fashionnaire Jean de Dieu expanded the interpretation of the law of the 30th of August 2018, a law that concerns the Penal Code. This opens the way for the appeals court, and also this applies to lower courts, because also based on the nature of the crime, the mode of the commission, its gravity, and the personal circumstances of the author, these courts can reduce the sentence below the standard proposed reduction. As to whether this reduction, as provided for by Article 69, was an error, this is not founded, because we have just seen that the court was founded to make that kind of reduction. The Court of Appeal considers, therefore, that by reducing the sentence for Nizeyema Mark, for Sankara, Nanganyimana Joseph, Nirora Marcel, Yamuremi Emmanuel, Rusesabagina Paul, Sengimana Herma, Kwitonda André, Shimimana Emmanuel, Judgement Jean Chrétien, Akizimana Théogène, and Mukando Tie Angelina, that their reduction of their sentence below the standard proposed sentence was not an error. Therefore, that ground of appeal is considered as not founded and is rejected.
Uririye ku bw'ubushinjacyaha. Muri iki gice urukiko
In this section, the court will examine the receivability of that appeal by the prosecution, and then it will examine the appeals by those accused that were filed on time. About the appeals by some of the accused, the prosecution said they were not in due form based on the arguments they gave the court. And the prosecution says that in Article 1, Law 22 of August 2018 about procedures in different procedures, the law provides that this is the law that is applied in other cases in case there are no other laws governing such proceedings. But it finds that there needs to be an analysis whether such an appeal in criminal cases would be acceptable. And Jean Chrétien, Théogène, and Siméon's appeal needs to be examined, whether they could appeal and have they appealed in due form. And the prosecution finds that those appeals were just a strategy to evade their responsibility, though they should be doing what they do based on penal criminal procedures and on a timely fashion. It finds that when the accused found that they ran out of time to appeal, they resorted to such a strategy. So the prosecution finds that there's no way to appeal in those cases when there's a law that is clear about that. Attorney Sharif Yusuf, representing Kwitonda André, Hakizimana, and Jean Chrétien, says that based on Article 264 of the Law 027/2019 of 19 September 2019 about criminal proceedings, and it says that the law about civil proceedings would be applied because their appeal was based on the prosecutions, and they were requesting certain things based on Article 152 of the law. Attorney Twajamahoro Herman, representing Nikuzwe Simeon, says that his appeal is based on Article 264 of the law 027/2019 of September 2019 on the cases that he was pleased with the sentences on the primary court, but he says he had an opportunity to appeal because the law grants him that possibility. Here is what the appeals court thinks. The court thinks that the arguments about this issue, to know whether that appeal based on the prosecution is possible, Article 181 of the law 027/2019 of 19th September 2019 provides that one can appeal within 30 days based on the day the verdict was rendered for any of the parties who were present when the case was when the verdict was rendered. And the same timeline applies for any of the parties, even though they did not show up during the verdict. Article 181 says that about criminal proceedings, the one who's found guilty and who do not like the verdict should necessarily appeal within 30 days based on the date the verdict was rendered, whether they were present or represented during that trial. This means that appealing after 30 days or appealing based on somebody else's appeal after 30 days makes that appeal irrelevant, because all appeals need to be the principal appeal. And now, about what some of the defendants said, that some principles in civil matters are applied when there's no law about that. This court finds that such appeals, the law wanted for these laws to be applied, and when it comes to compensation, the law says that civil procedures are relevant here. About the appeals based on someone else's appeal, the law does not say anything about that, because there was a known principle in the law that appealing can only be made as a primary principal appeal. And based on those explanations, the defendant in this appeal can do so within the time limits. Nikuzwe Simeon submitted his appeal on 28 November 2021, and in his appeal, he appealed based on the prosecution's appeal, based on the constitutive elements of the crime he was accused of. And Kwitonda André, Hakizimana Theogène, and Jean Chrétien, they appealed on 29th November 2021. And in their arguments, based on a prosecution's appeal, it was about the sentence they received based on the crime they were accused of by the primary court, and also based on their mitigating circumstances. The appeals court finds that if the case was tried on 20th September 2021, and that Nikuzwe Simeon appealed based on the prosecution's appeal on 28 November 2021, Kwitonda André, Hakizimana Theogène, and Judgement Jean Chrétien also appealed based on the prosecution's appeal. After 30 days, counting from the day the verdict was rendered, their appeal is irrelevant. It's not receivable because it's not a primary appeal, and you cannot appeal based on someone else's appeal in these proceedings. Those who appealed for sentence reduction, Calixte Sankara, Nsengimana Herman, Matakamba Jean Beckmans, had their sentence reduced, but they appealed to reduce it even more. But Nsengimana Calixte Sankara, in Nsengimana Calixte's arguments that he submitted to the appeals court, he says that the primary court sentenced him to 20 years, and it prevented him from returning to the Rwandan society because he will be released in his old age. He asked the court to take into account his health issues, that he's also a genocide survivor, he survived the genocide against the Tutsis, that he has one sibling who's handicapped and they have no shelter. So he requested that, based on the cases of FDLR leaders, including Nyas Murwanashyaka and Musoni Khatom, who got less sentences, and some FLN soldiers who went to Mutobo reintegration camp, and those who confessed their crimes and got less sentences, including public works. He also says that he asked the court to take into account the fact that he disassociated himself from FLN and MRCD FLN, and that he accused publicly the countries that supported FLN, including Burundi, Uganda, former Zambian President Edgar Lungu, and those who they have become his enemies and they can hurt him. So he says that he has no choice rather than work for the Rwandan government, which is likely to ensure his security. He asked the appeals court to take all those points into account and give him a low punishment all the way to 5 years, and he's kept seeking forgiveness. About what the prosecution says about the Supreme Court's guidance in RPA 283/10/Supreme Court of 19 December 2014, prosecution versus Gahongayire Jean, about not reducing a reduced sentence in a lower court. Semana Calixte, aka Sankara, says that that court is different from his court. That case is different from his case, because the other one got 10 years by the High Court, even when he himself got 20 years. Attorney Ruggiero Jean, his representative, his lawyer, he says that the lower court did not give him. Does not satisfy his request for 5 years when he volunteered to come forward and give information that the prosecution used, and that the court was also supposed to take into account the accused health issues. And the attorney says he's looking after his client's interests, and also based on the case RC 003/2019. So the Supreme Court in section 45, and the case RPA 00031/2021/Court of Appeal of 28 October 2021. And give him an even lesser sentence. The prosecution says that his appeal is irrelevant because he got what he wanted, less punishment already. And based on Article 68, about how sentences are given in Section 265 to 267, they reduced his sentence from life to 20 years in jail when he deserved no less than 25 years in case of mitigating circumstances based on that law. So the prosecution says that what Semana Calixte, aka Sankara, should prove is to know whether or not the prosecution was wrong in any way. About new elements that he puts forth, the prosecution says there's no relevant point. The fact that he survived the genocide, he should be among the first who's against the war. And the fact that some FLN elements have not been tried and they went to Mutobo rehabilitation camp, that's not should be a basis for his request for a lower sentence. They did not commit the same crimes, and nothing guarantees that those elements will not be prosecuted themselves. And about Musoni Straton, who was tried in Germany and got a less sentence because of mitigating circumstances, it was said that in Germany they have their own analysis of and how they explain mitigating circumstances. So the prosecution wants the appeals court to look at RPA/66/08/Supreme Court, a case that was tried by the Supreme Court in 2019. Was prosecution versus Kawahizi Jean, and another case related to an appeal in that case, and a case RPA 283/2019 was prosecution versus Gahongayire Jean in section 10 and 11, and then this appeals court should confirm that Nsabimana Kalex Sankara's appeal is irrelevant. Now, Nsengimana Herman, with attorney Ruggiero Jean, who represents him, they say that Nsabimana Herman was accused of being part of a terrorist organization. They say that the court did not reduce his sentence enough while he had confessed his crimes, so they want an even lower sentence, from 5 years to 2 years, because the court has that authority. They say that the prosecution has no right to ask the court to raise the sentence. The prosecution says that Nsengimana Herman wants a lower punishment from 5 years to 2 years. They say he received what he wanted in a lower court, and there's no obligation to reduce it even more. They said that based on Section 18 of the law of 2018 about the fight against terrorism, he should have given no less than 15 years, but no more than 20 years. If you look at what the law provides, the High Court went below the threshold, the lowest threshold. Matakamba Jean Berkmans says that the High Court did not take into account his confession of the crimes, and he was found guilty of the crimes committed in Karangiro while he was not on the scene, that he had suffered an accident and he was in a hospital. And those who committed those crimes have confessed them, but he was sentenced based on what he did in Rusizi, even though he helped justice to access information. So he asked the appeals court to consider his plea and analyze further the reasons why he committed those crimes so he can get a lesser sentence. Matakamba Jean Berkman says that usually he's a good citizen, but he was trapped and got involved in a crime only because he once provided information on about FDLR elements, and some of them were arrested. In 2017, he shared information about Bizimana Cassien and Magali, who had come to him asking for work, but he said that their intention was to commit crimes. So he informed local leaders, and Magali was arrested and Bizimana Cassien fled to the Congo. He also says that he suffered consequences for that because the FDLR later on killed his brother in retaliation. But he also ran into Bizimana Cassien and Bugingo Justin in Bukavu, the Congo, where they were making brewing a drink, and they threatened him. They said they would hurt him if he didn't join them. So he accepted to join them, to save his life. Attorney Mukarugiriza Chantal, representing Matakamba, says that based on Article 49 of the Law 69/2018 of 30 August 2018 about crimes and sentences, provides what the judge can look at when giving a sentence, finds that the court did not take into account the accused's behavior pre-crime and the fact that he confessed the crime when he was arrested. She says that the court took into account aggravating circumstances. She says, the court says that he brought weapons in Rwanda, and the court is giving him a sentence with the highest sentence given the crime. And they say that's why they ask the appeals court to look at mitigating circumstances, put them on a balance, compare with aggravating circumstances so they can reduce the sentence. The prosecution says that Matakamba's arguments that the court did not take into account his plea, that is irrelevant because he confessed his crime of treason and inciting people for terrorist acts, and he explained that together with Nibira Mireille Innocent and Byokusenge Jean-Claude, they confessed their terrible plan with Bizimana Cassien and others to be part of a terrorist activities. He said that he did not plan to commit the crime and that he found himself in a trap. But the primary court explained that Matakamba Jean Beckmans, together with his accomplices, had the intention to commit those crimes. They did it willingly. They attacked different areas, including Karangiro, using weapons, grenades, and they brought those weapons from the DRC. And once in Rwanda, they hid some at Matakamba's house before they attacked. So the court was based its decision on all that to prove his role in terrorism. And when he wants to have a less sentence, the appeals court finds it irrelevant because when he was interrogated, he's always confessed his role in the attacks carried out in Rusizi. But then he says that he was used. He says he had no intention to do it. But you know that he has never did anything to disassociate with himself from those elements. So his crimes are serious crimes. They had consequences on individuals and their property. The court says that if the sentence is not reduced, as it is in RPA 02/2018/10/ Supreme Court of 24th February 2012 in Mushaidi Gracias versus the prosecution in section 40. the appeals court finds that on this point, what needs to be analyzed is to know whether the court can reduce further when the defendants do not prove anything wrong in the proceedings, rather than wanting a lower punishment. But with the law 68/2018 of 30th August 2018 about crimes and sentences provides that the judge gives a sentence based on the gravity of the crime, the consequences, and the reasons to commit that crime, and the personal circumstances of the offender, and how the crime was committed in 58/2018 of 30th August 2018. As was mentioned above, it says this: the judge is the person who decides whether those reasons are relevant. The second section says that those reasons for mitigating circumstances needs to be confirmed by the court. At the law 68/2018 of 30th August 2018, it says that the judge examines mitigating circumstances or other reasons to mitigate the circumstances. He explains them and decides whether they are valid or not. When the judge decides that they are valid, he gives a sentence that is appropriate. And every judge has that right, including the judge at the appeals court. The appeals court judge needs to to keep in mind that he can change the sentence given by a lower judge once he has established the mistakes committed by that judge, the previous judge. It means that the appeals judge needs to examine whether the judge at the lower level has followed the law when assigning the sentence according to law 78 and 58. And on this point, the Chamber for International, the International Criminal Court in Yugoslavia in Voislav's Chile case, they explained that a judge in a lower court has the right to render such a decision. The judge does that, changes the sentence when they prove that there was a mistake at the lower level. This was also explained in RPRR 00406/2020/Court of Appeal of 22nd February 2021, Prosecution versus Nahayo Iñas, where the court says that though Mr. Nahayo had a low sentence because he confessed the crime, he could get an even lower sentence by the appeals court if it was proven that the sentence was heavy and that his reasons put forth were valid and legal. Based on all this, this court finds that for all the defendants, the court will rather examine whether or not any defendant has proven that there was a mistake in the trial or how the law was applied. Now about Nsaimana Calix, aka Sankara. Mr. Nsaimana, in his appeal, he does not show anywhere that the law was not well applied in the trial. He says he did not his sentence was not lowered enough, and he wants the Court of Appeal to give him an even lower sentence. And in 664, 665, and 671 of appeals cases, the court has explained that though Mr. Nsabimana committed crimes that resulted in people's death, the court says that he collaborated with the court by sharing information, and that he's a first-time offender, and he says that he should be given 20 years instead of life imprisonment, based on Article 68/2018 of 30th August 2018, as mentioned above, and based on explanations in cases RS/0003/2019/Supreme Court and case RPA 00032/2019/Court of Appeal by the Court of Appeal. Nsabimana Calixt, aka Sankara, wants to be given a lower punishment because the 20 years will not give him the opportunity to go back to the Rwandan community, and though he has also sought forgiveness. He says he has collaborated with the court by sharing information on himself and his co-accused. He says he willingly resigned from FLN, and he has accused the FLN that he has a chronic disease, and that's why he wants the court to give him a lower punishment, 5 years. He says the primary court, while sentencing him, they should have not looked at the gravity of the crime he committed, but his interests and the interests of justice. The prosecution says that Nsabimana had his sentence reduced and does not deserve to be given more reduction. They mention RPS 008/Supreme Court of 16 February 2019 and RPA 008509/Supreme Court of 17th June 2011, and the case RPA 0243/10/Supreme Court of 19 January 2014. As explained previously, the judge, while pronouncing the sentence, they look at the personal circumstances of the accused pre-crime, during the crime, and post-crime, and they compare that with the gravity of the crime and its consequences in society. So the judge pronounces a sentence which is proportional to the crime, and the judge does that while protecting the society and also punishing the accused and defending the interests of the victims, and keeping in mind how to make sure that the person will be reintegrated in society. And as clarified before, the appeals court finds that the primary court has done what it had to do when pronouncing Nsabimana Calixt's sentence based on the gravity of the crimes he committed. And if you look at, they also took into account his situation pre-crime and his behavior from investigation up to the trial on the merits that he shared information based on those crimes. So they sentenced him to 20 years. It also finds that the primary court could not have based its decision on other elements in his personal life when they were not in his dossier, or because there was no debate on that either. So the appeals finds that Semana collects mitigating circumstances, that he is a genocide survivor and an orphan, that he has a fiancée, he has a bride, that he's 39 years old. He says that he left MRC de FLN, that he has high blood pressure and other chronic diseases, and that some FLN high-ranking officers went to Mutobo re-education camp. Those are not the reasons for his requesting for a reduction of the sentence. The appeals court finds rather that the primary court did not give enough importance to this, that he participated fully in the crimes he committed that had consequences on the Rwandan society, that he shared information about the terrorist organizations and information about the countries and other financiers of that organization, that he gave that information consistently, which helped during the case and the trial, and the information he gave helped take appropriate measures against those organizations. Based on those reasons, the court finds that his request for a lower punishment, a lower sentence, is valid. About the prosecution that mentioned 3 previous cases, those cases state that there's no reason why there could be more reduction of sentence because it was done according to the law. The appeals court finds that that is irrelevant because the Supreme Court explained that the defendants should not have an even lower sentence because the sentence had been reduced at the primary level. And about Gahongayire Jean's case, the Supreme Court has explained that the sentence cannot be reduced because of the gravity of the crime. Now, about Nsengimana Herman. This court reiterates that, as it's been said, mentioned in Article 149, Nsengimana Herman's sentence was reduced, but there's no other reason why it could be reduced further. Before we analyze the reasons he puts forward, and in light of the principle we've mentioned earlier, that the appeals, that the sentence can be reduced at the appeals level when there was a mistake in applying the law while pronouncing the sentence at the lower level. And here we find that his appeals is not based on misuse of the law, but just because he did not get enough reduction. In section 665, the primary court reduced his sentence based on the fact that he confessed his crime of belonging to a terrorist organization and helping the judiciary and his first-time offender status. And instead of 15 years, he got 5. And based on whether or not Nsengimana Herman confessed his crimes, the appeals court finds that what Nsengimana Herman is asking for is irrelevant. He the primary court gave him 5 years, and that was too low, just based on the fact that he admitted his crime. But he refused that FLN was not a terrorist organization, that it was a military organization. It means that he refuses, he doesn't accept that he is a member of a terrorist organization. And based on this, the appeals court finds that Nsengimana Herman cannot have a more reduction of the sentence. So his request is irrelevant. About Matakamba Jean Beckmans. In paragraph 267, the primary court finds Matakamba to be part of the terrorist organization, participating in terrorist activities, illegal use of explosives in a public place, treason and incitement of others to participate in terrorism. Paragraph 661, the court has decided that Matakamba and his co-accused have confessed the crimes, but when it looks at how they committed the crimes in Rusizi, how they crossed the border carrying weapons, and their operations, their cooperation with FLN leaders, and the consequences of the attacks on the population and the property, they should be punished with the highest sentence based on the crime, with 20 years. With paragraph 637, 643, the prosecution wanted Matakamba Jean Beckmans to be given the most serious sentence, 25 years, that it should not be reduced just because he confessed. He should not be reduced because his confession was not full, and because he's accused of very horrible crimes. Matakamba said that the sentence was too heavy. He wanted the court to analyze the reasons why he committed those crimes. He also wanted his sentence to be deferred, and he also says that the sentence has affected him mentally. In his arguments, Matakamba asks the court to analyze his unequivocal confession and reduce his sentence. Therefore, he says the court had based its decision on the aggravating circumstances of his commission of the crime, and as the law says, and in this case, Matakamba Jean Beckmans says he wants to have his sentence reduced because he says before the crime he was an exemplary citizen. The sentence says that based on 61 of law of 30 August 2021, the primary court did not overlook Matakamba's confession, but he cannot get a reduced sentence because of the way, because of how he and his co-accused committed the crimes in Rusizi district. They say had the court given more importance to his confession, the sentence could not have been lower than 20 years, based on Article 60 of the law 68/2018 of 30 August 2018. As it's been said earlier, the court does not have to accept the mitigating circumstances whenever they are put forth and to reduce the sentence. The court does that after proper analysis and taking into account how the crime was committed, which is what the primary court did.
Regarding Matakamba Jean Berkmans, he did confess, but his sentence was not reduced because the lowest is 25 years for that particular crime. And as explained in 631, paragraph 631 of the proceedings report, it was found that confession does not suffice to reduce the sentence because of the nature of what he's accused of. And the law does provide that in such a case, the sentence cannot be reduced just because the accused has confessed. As a matter of fact, the law provides that for such a crime, confession alone does not suffice to reduce the sentence. Also, Matakamba raised another issue, and that he had mentioned the fact that he had attenuating circumstances, but these were not raised at the right time. They were not raised during the trial. He brought no proof. Therefore, 25 years is what the law provides for that particular crime. In fact, he only got the minimum. This is a minimum. And if it's a minimum, then you cannot appeal for it to be reduced because it's already the minimum. And therefore, there is, unless there are other circumstances, that sentence cannot be reduced. I think we shall stop here as we agreed. We shall have a break. In fact, we are very late. We had said we'll break off at 13 hours. We are half an hour late. But I think we wanted to finish this section of the reading so that we don't interrupt it. So please, we shall now have a lunch break. We resume at 2:30, 14 hours and 30.
isomwa ry'urubanza rirasubukuwe.
We shall now resume our proceedings. We shall proceed to the item about whether or not the appeal was conducted properly, and especially speaker has stopped.
kumenya niba urubanza rwarire
Especially to know whether the appeal about the reduction of punishment was proper. The list of people who together appealed against the length of the sentence, Nhibira Mire said that from the beginning, from the investigation, he had admitted his culpability throughout, but he was given 20 years despite this. His counsel, Maitre Ngamije, said that the reason was that he's accused of the highest crime and therefore cannot be reduced. So the document about a case in 2019, in its paragraph 219 of the case, and the case being a case of 2021, all concerning the independence of the judge as regards the setting of sentences. So the accused said that he admitted to everything. He cooperated in everything, and yet he did not see his sentence reduced. He was accused of terrorism, and terrorism is punishable by 20 years in imprisonment, and he got 20 years, not more, and therefore there is no cause for reducing it. And Shaban Emmanuel says that he also confessed and admitted throughout and from the beginning. He admitted to having taken part in acts of terrorism, in throwing explosives in crowded places, and joining others to commit acts of genocide, and that he was recruited by one Justin, who recruited him and encouraged him, and also that the acts that he was accused of, he did not really directly take part in them. His counsel said that Article 49 of the Penal Code regarding sentencing was not respected because he was not involved in all the crimes that he is accused of, along with others. And that Article 59B of the same law of the Criminal Code sets that 20 years imprisonment was given without explanation. That's why he deserved that. So Shaban Emmanuel said that the court should consider reducing his sentence, and also because there are circumstances, attenuating circumstances, as provided for in a 2019 case where Bagaragaza, in the Bagaragaza Michel case, Bagaragaza admitted, he confessed, and he got only 7 years instead of life sentence. And so the lawyer said the appeal is based on the fact that his client admitted everything, confessed, and apologized. And instead of that, he got 20 years instead of lesser, as he was right to expect. Nsembala Jean Damascene said that in his case, he also confessed and also gave information on where he had hidden the weapons, and plus other information that he delivered. And unfortunately, he also was given 20 years along with others who had not behaved like him. And also he said that he was not really responsible directly for any of the things that they accused him of. So his counsel says that the law of 2018 against the terrorism, or the law on terrorism, that he should see his sentence reduced, because the sentence he was given is very severe. Taking part in terrorist activities. In fact, it's 20 years. The law says 20 years. He got 20 years, and therefore there is no cause to reduce it. Bizimana Alias Kwasi said that he has confessed, regretted, apologized, gave up all his weapons and all his other tools, and therefore he should have less sentencing. And he said, his counsel said that the relevant law of article of the Criminal Code provides that his punishment was 20 years because he was convicted, and in fact he admitted to a crime that is punishable by 20 years imprisonment. So there is also the law, or rather the case of 2021 in the case of Hebimana Pascal, paragraph 39 of the judgment. So therefore there is no reduction. So the next group of people appeal together and say that they are accused of having led an attack in Rusizi, or taken part in an attack in Rusizi, and they were given maximum sentence because of the seriousness of the effects on the population of Rusizi. And therefore, this group of people cannot see their sentence reduced, because there is no, even when there are circumstances, attenuating circumstances, there is no obligation for the judge to reduce a sentence. Fine. So also the fact that this group of people were appealed because they say the explanation they gave should have led to a reduced pain, a reduced sentence. That the law of 2018 on terrorism says that anybody who takes part in acts of terrorism, even in obeying a leader, or so long as there is a death and of the people that were attacked in that act of terrorism, if people are dead, they are dead, you get that sentence. You cannot have it reduced. So the next lot, Byukusenge, Jean-Claude, and Nurahami Emmanuel, well, they also say that their sentence is too severe. But in this case, we say that Article 49 of the Anti-Terrorist Law of 29 of the Criminal Code, the General Code of Criminal Code. And it explains clearly that in case people are killed, well, they get that sentence. Article 59A says that the judge determines whether any attenuating circumstances are acceptable, admissible, and may cause a reduction of the sentence. The judge decides. In this case, the judge decided that way, and that is proper. Also, looking at a first offender, for example, a first-time offender, if the person had a good life before that, he was a very good person, you can see in the case of somebody who joined such criminal groups, how they came to join those groups. But if there are no attenuating circumstances of that sort, then the sentence cannot be reduced. And in the case of these two people who were accused of joining a terrorist institution on an illegal armed group and also explosives in crowded areas, all being acts of terrorism. Therefore, the court has said that Jean-Claude confessed and apologized, but looking at what they did in Rusizi during those attacks, how they will cross the border, hide their weapons, working with various terrorist groups, the people that they wounded, the property that they destroyed, and various other very serious effects. This shows that, from this we conclude that 20 years is what they should get. It was also found that the two men criticized the trial at the first instance, saying that the first instance did not take into account their confession, because they confessed and they admitted everything. But the court says that because of the damage they did in the Rusizi province in various places where they attacked, they cannot have a reduced sentence. Not less than 20 years. As the first instance has decided, and this is in conformity with Article 60B of the 218 law against terrorism, as we have been citing. It is therefore clear that there was no obligation for any court to accept attenuating circumstances as a source or the reason to reduce the sentence. It is not so, especially given the type of crime, the consequences of that crime, it is not enough to have these attenuating circumstances. Now, as regards Jean-Claude and his co-accused, 20 years is a minimum for the most serious crime, l'infraction la plus grave. And in fact, this is very clearly stated and set out in the judgment. It is stated that their confession and their regrets were not sufficient to reduce the sentence and set it below 20 years. 20 years is a minimum. Also, the next group also is appealing to their 20-year sentence because they too think that they should have less years in prison. In fact, they could have had a maximum. 20 years is the floor or the minimum. Therefore, it is not right, or they have no reason to appeal, because in fact they could have got a much heavier or longer sentence. So Jean-Claude cannot expect their sentence to be reduced. Therefore, the appeal has no basis. Shaban Emmanuel and Shaban Jamasen, also known as Motar, they did not accept responsibility. They got 20 years because their crime is very serious, but they got 20 years, which is a minimum. But they object to this. But in fact, they got 20 years when they should have got much more. But they are appealing because there were no sufficient explanations of the law in the lower court for these 20 years. Nsaimana Alias Motar said that he had hidden weapons, and he admitted this to the police, and the police found them, and that should have acted as an attenuating circumstance so that his punishment is reduced. But Article 47 of the 2018 law on terrorism it should apply, and it applies in the sense that also in the sentence, in the report of the proceedings, it shows that they committed crimes in various places in Rusizi, and therefore that article of the 2018 anti-terrorism law provides that there is no way of reducing the sentence below 20, because 20 years is the minimum, and their crime is very serious, especially as they carried out explosions and attacks with explosives in crowded places. Therefore, the sentence is 20 to 25 years, and they got the floor sentence. Now, Shaban Emmanuel and Jean Damascene alias Motar had a role in terrorist activities, especially explosives in crowded places. And Shaban Emmanuel, in addition, mobilized others to commit acts of terrorism. And Shaban Emmanuel and Simon Jean Damascene alias Motar admitted and confessed their crimes, but they committed many crimes in many places in the province of Rusizi, and therefore they should be very severely punished, and they were given 20 years. So the appeal court found that no judge is obliged to reduce the sentence because of confession or attenuating circumstances. There is no obligation for the judge to reduce, but to take into account these circumstances and reduce the sentence. And this is what the court did in case of these two men. And therefore, as explained in this document, the law on reducing sentences or reduced sentence says that the judge decides and may refuse to take it into account if the crime and the intentions and other circumstances allows the judge to conclude that he should get a serious rather than a reduced sentence. Therefore, the two men committed very serious crimes, very cruel as well, and therefore the court, although they were the people confessed, but there should be no considerable reduction of their sentence given the damage and the suffering they caused in Rusizi province. So they got 20 years, which is a minimum in this case. So instead of 25, which is a maximum. And therefore, Shaban Emmanuel and Motar should not have had their sentence reduced because there is no cause to reduce it below 20 years. As to what Jean Damascene alias Motar says, the relevant article of the terrorism law does not provide for a reduction of pain simply because he showed the authorities where he had hidden the weapons and admitted various other things. In fact, it was one handgun and a grenade that he had hidden through his wife. It is true that his wife had gone to Congo, and therefore only the accused knew where to find these weapons of terrorism. However, that is not sufficient to reduce the sentence, and whatever other circumstances may be adduced, none suffice to reduce the sentence to something less than 20 years. Therefore, the appeal is not founded. As in the regards of Biziman alias Pasi, he got 20 years, and he said he was a first offender. He confessed very clearly, outright. He cooperated with the authorities, and in fact that led to some of his accomplices and others to be arrested. And therefore all this should suffice to reduce his sentence. However, the law that we have been citing of 218, a law on terrorism, does not justify a reduction of this very serious sentence, capital crime. He cannot get less than 20 years. He also said that he confessed, he's very sorry, he apologized, but nevertheless this is not sufficient because Biziman Kassien alias Pasi was convicted of being a part of a terrorist organization, taking part in terrorist activities, exploding devices in populated areas, plotting to commit these acts, and generally promoting terrorism. There is no way, therefore, that Bizimana Kassien, alias Passy, and others may have their sentence reduced, given the things, the crime they committed in Rusizi, and the seriousness of those crimes. 20 years is the minimum. It is therefore found that the explanations by the law court is sufficient to show that although Bizimana admitted, confessed, and cooperated, this is not enough to reduce the sentence below 20 years, because he and his co-accused can only get 20 years, which is the minimum for the capital crimes that they have committed. Normally, they should have got 25 years, which is the maximum, and they didn't, so therefore, that is the minimum. Also, the accused said that this was his first time, that he's a first offender, and that he behaved well, but in fact, there is no obligation for a judge or a court to reduce the sentence, because this person admitted having committed these serious crimes. And therefore, as Article 59A of the law of 2018, as we've been citing, cannot apply. It is clear, in conclusion, that the explanations given by the law court of the 20 years given to Alias Passy, given the way he pleaded and the seriousness of his crimes, there is no reason for him to appeal. He has no grounds for appeal. As regards the people who have asked for a postponement of the punishment or the sentence, and these people begin with Shimiman Emmanuel. He said that from the start, he had appealed to the Constitution, amended on 2000 as amended, but also the law 2021. He should have a delayed sentence because he has a family that he should want to go and see, and he has high blood pressure and other chronic diseases. And he deserves that. He also said that he was very young when he joined those groups. Yamunem Emmanuel also said that according to the Constitution as amended, and also according to the Code of Criminal Justice, he should he should serve his he has already served a number of years, and therefore he should that should be accounted, so that he serves less years. And in fact, the problem is that he has really not explained clearly why he is entitled to a reduced sentence, because he was in terrorist organizations, and the terrorist organizations, well, the punishment are provided for under the law of 2018. He said he was in FDL for car up to 2016, and then he moved to FLN, and this is where he was at the time of his arrest, and therefore he should not be punished for the time that he was in that previous organization, because in fact when he was arrested, he was charged with terrorism, and in his particular case, the minimum is 16 years. Therefore, his appeal has no basis. The laws, in fact, provide that that is the minimum. Nirora Marcel said that since he confessed and further to the 39 article, paragraph 39 of the terrorism law of 2018, he should have his sentence reduced, and therefore also the criminal court also allows him to have his sentence reduced.
When he was arrested, he didn't know his family's whereabouts. Attorney James, representing Marcel and Emmanuel, says that the primary court reduced their sentence to 5 years. And based on that sentence, he would like them to go back to their normal life, to be released. And based on that sentence, they should be released on conditions. And he committed a serious crime that deserves more than 5 years. And that court said that it's contrary to Article 68/18 of 30 August 2018, governing crimes and sentences, because the law provides for no less than 5 years. And about Nsabimana Jean Damascene and Shabani Emmanuel, Nsabimana says the primary court refused to defer his sentence because they don't have his address, even though the address is in the file. So he says that troubled him. Shabani Emmanuel seeks forgiveness because he confessed his crimes and he has changed, and he wants a less serious sentence. Attorney Shani, representing Jean Damascene, says the primary court refused him to be released because he doesn't have a known address. He had said that he wanted to be jailed in Rusizi, close to his sisters, and he's asking the court to suspend his imprisonment. So he wants his sentence to be reduced. He had sentenced to 20 years unjustly, according to him. The prosecution says that the court refused to suspend Motar's sentence, not just because of a lack of address. In paragraph 668 in the appeals case, the reasons he puts forth, together with his co-accused, it's about the gravity of the crime. So suspending his sentence based on suspending the crime when the crimes he committed deserve more than 5 years is impossible because of Article 64 of the law 68/2018, as mentioned before. Suspension of sentence is given when the normal sentence would be no more than 5 years. This is how the court finds this. Article 64, paragraph 1 of Law 68/2018 of 30 August 2018 about crimes and sentences provides for this. Suspending sentence is a decision by the court when the sentence is normally no more than 5 years. That suspension is awarded based on the gravity of the crime. Article 68, paragraph 1, seems to have an error because it says that suspension of sentence is possible when a sentence, when a crime gets a sentence with no more than 5 years. But the sentence is not there for a crime, but a crime is assigned a sentence. So there's confusion when it comes to what the law meant here. If suspension of sentence is awarded for a crime whose sentence is no more than 5 years, or for a crime whose sentence is no more than 5 years. In Article 85 of Organic Law 01/12/ON of 2nd May 2012 about sentences clarifies suspension this way. Suspension of sentence is a decision by the judge suspending the verdict for a crime whose sentence is no more than 5 years. And this matches the explanation by the new law in French and in English. And that is what guides the court when it says that the law in Kinyarwanda has a mistake in writing. Suspension is for a crime whose sentence, and he should have said that suspension is the court's decision for a verdict on a crime whose sentence is no more than 5 years, which meant that that suspension is based on a sentence for a crime that is punished by no more than 5 years, instead of being for a law about a crime whose sentence is more than 5 years, no more than 5 years. And that's so the suspension should be based on the gravity of the crime as per Article 64 of the law about crimes and sentences in general. So the court, based on Article 333 of 30 August 2018, suspension must be understood as based on a sentence which is no more than 5 years that the judge assigns to a defender when they are guilty of their crime, as per Article 64 in French and in English. This is how it used to be understood in different laws that were used previously, like the Article 97 of the law number 21/1997 of 18 August 1977 on suspension of sentences, and Article 85 of Organic Law 01/2012/OR of 2nd May 2012 on the criminal on the sentences. The punishment, the sentences by the judge can be given even when the person found guilty has not expressed themselves on that sentence, but only based on the gravity of the crime. So that is, it's a decision made by the judge. And about Shimimana Emmanuel, in trial of 31st January 2012, Emmanuel Nshimiyimana said that if he is found guilty of the crime, he requested that the 3 years he was given in the primary court be suspended. And the prosecution said that when he requested for suspension, that article was not to be applied because he has requested for the same previously and it was denied. The prosecution says that even if this court examined that, it would be impossible to give him suspension because he was guilty. Participating in a terrorist organization gets 20 years, but that suspension is for a crime whose sentence is no more than 5 years. So the prosecution says he does not deserve that suspension when he does not confess his crime. Now, about the sentence that the prosecution sought for him on the primary level, it says that he cannot answer for the crimes he's accused of because he was forced to commit them. But the laws should apply as they did for others who were re-educated. The appeals court finds that Emmanuel Nshimiyimana does not deny that he belonged to a terrorist organization, but he accepts that he was forced to be a member when he was young. And he says he cannot answer for that, but the court says that should he be guilty, his sentence of 3 years could be suspended, the sentence given at the primary level. Based on what's said above, Article 64, that suspension is how the modalities of executions are decided by the judge, and that the judge is that suspension is given by the judge. The court of appeal accepts that Nshimiyimana Emmanuel applies for that suspension, and this means that the reduction of his sentence of 15 years, but his 20 years sentence is irrelevant. Nshimiyimana Emmanuel joined the terrorist organization young. He was in high school, and he admitted his crimes and shared information. And he's a first-time offender. And but even though he belonged to FLA and FDLR until he was arrested in 22nd February 2020, and he accepted that in May 2016 he joined CNRD because they're the one whose ideology matched his. He joined military training in 2019, and he became a second lieutenant. And because he was a member of a terrorist organization, he cannot get the suspension of his 3-year sentence because that sentence is proportional to his crimes. For those reasons, the appeals court finds that Nshimiyimana's appeal is irrelevant. Now, Niyirora Marcel. But his sentence of 15 years that the prosecution sought for him on the primary court, Niyirora said he should be released and be re-educated like others. The primary court gave him 5 years. In the appeals, Marcel wants the court to confirm that the primary sentence should be suspended. The prosecution says he does not deserve suspension because his crime deserves more than 5 years, as per Article 64 of Law 64/2018 of 30th August 2018. And as has been said, the appeals court finds that what the prosecution says, that suspending Niyirora's sentence is impossible because his terrorist status was confirmed, and it's 15 years and no more than 20 years. So it's clearly more than 5 years. Because deciding suspension is not just about the crime, but it's also a decision by the judge. And the prosecution says that Marcel cannot have his sentence suspended because of the nature of the crime, because he joined FDLR-FOCA, terrorist organization, since 2013 up to 2016, and he joined CNRD, a captain, and then he joined FMRCD-FLN until he was arrested on 16 July 2020 as a lieutenant colonel when he was a leader of FDLR-FOCA in northern Kivu and Rusizi and other regions in the Congo. And he was also in the CNRD command. So his appeal is irrelevant, according to the prosecution. But Yamuremye Emmanuel was sentenced by the primary court 5 years. So he wants the court to suspend that sentence. Prosecution says Emmanuel was a member of a terrorist organization, FDLR-FOCA, until May 2016, when he joined MRCD-FLN, until he was arrested in 2019. So being a member of a terrorist organization was confirmed with 15 years and no more than 20 years. So based on 64 Article 64/2018 of 20 August 2018, that sentence will not be suspended. So the appeals court finds that the prosecution's argument is impossible because being a member of a terrorist organization gets you 15 years, no more than 20 years. So it's more than 20 years, more than 5 years, as Article 64 provides that the suspension is for a crime whose sentence is no more than 5 years. It's been explained before. The decision about suspension is not about the crime, but it's the judgment of the judge and the appeals court, based on the fact that Yamuremye was a member of FDLR since 2020, and he left in 2016, joining CNRD until 2019 when he was arrested. He was one of FDLR MRCD. He was a member of a terrorist organization with FDLR-FOCA and MRCD-FLN. That he was a company commander when he was arrested, a lieutenant colonel. And when you look at his role and his place, he played a key role in their activities, so he cannot get the suspension he's asking for. So for that reason, the appeals court finds his appeal irrelevant. For Sabimana Jean Damascene and Sabimana Emmanuel, in paragraph 688 of the appeals case, the court has explained that based on the crimes Sabimana is accused of, and just like Sabimana Emmanuel, they have no real address, and the gravity of the crimes they committed, they cannot get their sentence suspended. Sabimana Jean Damascene and Emmanuel, they said that the primary court denied them suspension because of lack of a real address. But as Sabimana says, they said the prosecution's indictment clearly shows his address. Sabimana Jean Damascene, aka Mutar, says he has an address, and he says the law does not pose a real address as a prerequisite to get suspension of sentence. He also says, yes, the primary court he says that if they don't suspend his sentence, he should at least be imprisoned in Rusizi prison close to his sister's residence. The prosecution says they agree with Nsabimana that he has an address, but that denying him suspension was not just for that reason. It's also based on the gravity of the crimes he's accused of, as per paragraph 668. And in addition to that, a suspension could not be possible given the crimes he's accused of, given Article 64 of Law 68/2018 of 30 August 2018. The appeals court finds that the lack of address was not the only reason to deny Nsabimana Jean Damascene, aka Motar, and Nsabimana Manuel suspension of sentence. The primary court was wrong in saying that they had an address because there was no address in their file. The appeals court finds that based on the explanations according to Article 64 on crimes and punishment sentences, the primary court gave them 20 years. The suspension of that sentence would be impossible, because that would be possible if they had gotten no more than 5 years. For those reasons, the appeals court finds that Nsabimana Jean Damascene, aka Motar, and Shabani Emmanuel's appeal for suspension of sentence that they were denied in the primary court is irrelevant. But what Nsabimana's request to be imprisoned in Rusizi, the appeals court finds that ordering the location where the sentence is served is not in this court's competence. And to know whether the accused who want to be taken to a reintegration center for the former combatants, that can be awarded. And to be taken to the reintegration center as requested by Nsanzibukire Felicien, Munyaneza Anastase, Emmanuel, and Nero Marcel. Nsanzibukire Felicien and Munyaneza say that in the primary court they wanted to not be prosecuted and be taken to Mutobo reintegration camp like it was done for their colleagues, and based on Lusaka Accords of 10 July in 1999 and on a communique of 9th November 2007 signed by Rwanda and the DRC in Nairobi, Kenya, on the ministerial decree number 66 of 13 November 2002, it is said that the High Court did not respect Rwanda's principle to seek solutions through consultations and consensus as provided for in the principle in Article 10 of Constitution of the Republic of Rwanda. And that's why they appealed, requesting the appeals court to look into that. Nsanzibukire Felicien Anastase and attorney Twazar Shamahoro Rahman, who represent them, the case is appealed, and the court said that they cannot be released because what's provided for in those accords do not prevent them from being prosecuted for other crimes. They did not specify what crimes, though. However, their belonging to terrorist organizations was confirmed, and they want the court to look into that and release them because they have that right according to those accords, and that they meet the conditions and they are no longer part of those armed groups. Shimiman Emmanuel says that the primary court misinterpreted the Lusaka Accords because the combatants in armed groups in the Congo would be allowed, according to those accords, to be reintegrated and re-educated. He says that the prosecution is prosecuting him, though they know that he's not accused of those crimes. He says he should be released like everyone else. Nirora Marcel says he requested the primary court to release him like they did for others who left the armed groups who were arrested after him. But he says they denied his requests. That's why he's appealing that. He wants the court to apply Article 15 of the Constitution that all citizens are equal. Then they should apply the Nairobi communique about disintegrating armed groups and disarming them and returning those former combatants to normal life. So he wants this court to look into that. This is the court's take on it. Article 83, paragraph 6, Law 27/19 of 19 September 2019 about criminal cases. It provides that appealing is done based on reasons on every point, showing the mistakes that were made and how to right them based on the laws and evidence and what you asked of the court. And Article 83, paragraph 6, clarifies that when the appellant does not provide clarifications on every point or mistakes in the case and how they should be corrected, the appeal is irrelevant. And as we see in 463 and 464 of the appeals case about returning to normal life, the primary court clarified that either based on the Lusaka Accord or the communique between the DRC and Rwanda in Nairobi on September 2007 and the ministerial decree of 13th September 2012 about receiving and reintegrating former insurgents. Nowhere is mentioned those who are suspected of crimes. Nowhere is it said that they cannot be prosecuted, because those accused of genocide crimes, crimes against humanity and war crimes, they should be prosecuted, because that is what was decided by the Supreme Court in RPA/0255/12/CS Ingabire Victoire and co-accused of 12 December 2013. And the accused mentioned here say that the primary court did not do the right thing, because given the Lusaka Accord of 1999 and the communique of 9 September 2017 between DRC and Rwanda in Nairobi, Kenya, and the ministerial decree 066 of 13th September 2002 about the principles in welcoming and reintegrating former insurgents who should not be prosecuted but rather be reintegrated in the community. And apart from being accused of terrorism, they are not accused of genocide, war crimes, or crimes against humanity. So it decided that even though they are not accused of those three crimes, those accords that do not stop them from being prosecuted for other crimes they committed. And that's why they want the court to release them and send them to Mutobo to be reintegrated and re-educated. The prosecution says that the appeal is irrelevant because they do not show any mistakes committed by the primary court that denied their request to be taken to the re-education camp for former armed groups. The appeals court finds that this appeal by the accused has no basis, because apart from the fact that the primary court, they say the primary court did not take Lusaka Accords into account, they do not accuse the primary court of anything, any mistake when they decided as they did. Though they say that they did not commit genocide, war crimes, or crimes against humanity, but they can be prosecuted for terrorist acts. The appeals court finds that what the primary court explained based on the Supreme Court case with Ingabire Victoire is confirmed by what is said in paragraph 22 in Lusaka Accords of 1999 to stop hostilities, that say that those, apart from those accused of genocide crimes, other armed groups and for other strategies taken, among strategies taken, they can be pardoned for other crimes they may have committed and other common law crimes. But that is not what the Rwandan government did. Even though they did not commit those 3 crimes, they can be prosecuted for other crimes that were confirmed in this case. For others who committed crimes with them, the appeals court finds that they have no basis, because the prosecution is supposed to establish their guilt. And for all those reasons, the appeals court finds that Sanzukire Felicien's, Munyaneza Anastase, Nshimiyimana Emmanuel, and Nirora Marcel's appeal is irrelevant.
From what time does the sentence be started to be counted? Jean-Claude and others have asked for explanation of the starting point for computing the sentence. These accused claim that they were not told that this time is computed from the time they were arrested in Congo. They were arrested in Goma on the 9th of February 2017, then brought to Kigali then they were taken to Kinshasa, Makala prison. 6 months later, they were brought to Rwanda, and they claim they were not given any arrest warrants or any other documents that would help compute the time that their sentence would last. They request the court to correct the errors of the court of first instance. Byukusenge and his co-accused also claim that their time of arrest in Congo should be established so that the time for their sentence should be better computed. They claim that the court of first instance did not express itself on this. Ntawiramura says he was arrested on 19th, 1999, and Byukusenge also gives a date. Ntawiramura Innocent says that the evidence he has is that this is the date on which he was arrested. He says on 6th of October, he was presented to the people and to the media in Kamembe, in the district of Rusizi, for him to explain the crimes he committed. Byukusenge Jean-Claude, on his part, says that he was arrested on that time because also on the 26th of October 2016, he was presented to the people and to the media, and he demands that the 9 months he spent in detention detention be deducted from his sentence. The dates that are claimed without any proof could not be considered. The court decided that the time should be computed from the date people were legally incarcerated, and the PVA which were issued by RIB should be the reference, and thus, since they have no proof contradicting that, they had signed those documents, whatever they say regarding the date of arrest had no value. The court considers that the Article 28, Article 1 and 2, paragraph 1 and 2 of the law of 30 August 2018 says that the date of imprisonment should be computed from the date when the imprisonment is established. This time is deducted from the sentence. Article 18, paragraph 2 and 3 of the law on criminal procedure determines that the investigator can arrest and incarcerate a person under this law. The investigator writes the minutes, and the accused is given a copy. The law of the 12th June 2004 shows or provides that a claimant must prove what they're saying. The fact that the minutes that mentioned by the law of 19 September 2019 that solve this problem is not presented unless it is shown to be a forgery. There, it should be considered as the truth. The Court of Appeal considers that the document that shows when the accused was arrested is the document, the warrant of arrest that was produced by the investigator or any prosecutor habilitated to order an incarceration. General Major Sanzubuke Felicien alias Irakiza Fred and General Major Munyaneza Anastase alias Rukundo Job Kuramba have documents that were issued on 15th July 2020 by RIB exist, and there are also such documents regarding Naira Merinosa and Byukusenge Jean-Claude, which were also issued in 2020 by the Criminal Investigation Bureau. The prosecution considers that apart from their claims about the date of the arrest in Congo, there are no other documents that justify their claims. Therefore, they consider that it should be confirmed. They were arrested on the dates that appear in the incarceration documents, namely 15th of July 2020 and 16th July 2020, respectively. The appeals court considers that these documents clearly demonstrate that these were the effective dates because they signed these documents without any coercion. The court considers, therefore, that their sentence should be computed from considering Sanzibukire Felicien Munyaneza Anastase from 15 July 2020 and Byukusenge Jean-Claude and the co-accused 16 July 2020. This is also what has to happen with regards to all the accused. The investigation, the document from the Investigations Bureau being the reference to establish the date. This issue was raised first, for the first time, at the appeals phase. For all those reasons, the Court of Appeal finds that these claims of Niramir and Munyaneza Anastase, Kusenge Jean-Claude, and their co-accused, that this claim has no merit. Now, on the issue of the sentence. Prosecution is of the view that the Court of Appeal should confirm that RUSESABAGINA Paul should be imprisoned for life. Nizeyimana Mark, life. Nsabimana Callixte alias Sankara, 25 years. Nsengimana Herman, 20 years. Iyamuremye Emmanuel, 20 years. Kwitonda Andre, 20 years. Nshimiyimana Emmanuel, 20 years. Hakizimana Theogene, 20 years. Ndagijimana Jean Chrétien, 20 years. Sanzibukire Felicien, 20 years. Munyaneza Anastase, 20 years. Nikuzwe Simeon, 20 years. Ntabanganyimana Joseph, 20 years. Mukanduti Angelina, 20 years. Niro Marcel, 15 years. Prosecution also requests the court to confirm that nothing is changed for the sentence of Matakamba Berkmans, Niramir Innocent, Byukusenge Jean-Claude, Nsabimana Jean Damascene alias Motar. Nsabimana Callixte alias Sankara requests the court not to give any value to the opinion of the prosecution because he distanced himself from MLCD and has confessed and asked for forgiveness, and that he behaved in such a way that his sentence should be reduced. He concludes by asking for that reduction because he's ready to become a model citizen, and that the mitigating circumstances are not only measured by the gravity of the crime. So Emmanuel says that he should not be judged on the fact that he was a member of a terrorist organization. Emmanuel says that the 20 years that he was given were not sufficient, or not fair, because he was he has cooperated and he had pleaded guilty. He's asking the court to re-examine his guilty plea and reduce his sentence so that he can become a civilian citizen again. Kwitonda Andre says that he requests the court not to find him guilty of creating an illegal armed group because he was not accused of this crime, and because he did not voluntarily join this organization, and he says he should be found guilty. Nshimiyimana Emmanuel says that the sentence should be quashed because prosecution was not able to refute his evidence about the forceful integration into the terrorist organization. Hakizimana Theogene says he joined a terrorist organization by force, and he had remained in it, and he was physically handicapped, and he could not do otherwise than remain there. He requested the appeals chamber to re-examine these circumstances. Judgement Emmanuel claims that he joined this organization as a child by force, and that he should be forgiven for that, so that other young people in the forest should also distance themselves from this organization. Emmanuel says that he was not charged with this infraction, and he requests to be sent to the reintegration center, and he wishes that his sentence start being computed from the 9th of February 2017. Munyanteza Anastase says that the crime of creating a terrorist organization should not be held against him, because the indictment did not contain it. And he requests that his 5 years of sentence should be maintained counting from February 2017. Nikuzwe Simeo says that prosecution requests a sentence that is beyond what he had received before, without showing his acts that we find in Article 18 for the law of 13 June 2018 that concerns prevention and prosecution of terrorism. Naonganyiman Emmanuel says that he can't be convicted for creating a terrorist organization because he was not accused of this. Angelina says that she should also be forgiven. Bizimana Kassien, alias Passy, claims that this charge of creating an illegal armed group was not in his indictment, and that the information he gave would not have been known had he not cooperated with the justice. Matakamba says that he helped the justice system to arrest others, and he is asking for forgiveness so that he could be liberated, because even now he is held in solitary confinement. Right now, Tira Mirwinyosa requests for forgiveness, and he requests that his sentence should be computed from 24th October 2019 rather. Saimana Jandamaten alias Motar claims that he continues to apply for a reduction of sentence because he behaved correctly, and that if he were released into the society, he would not misbehave, and alternatively he would like to be imprisoned in Rusizi prison so that his family could take care of him because he has issues with ulcers. Concerning RUSESABAGINA Paul, the present court considered that the decisions of the first instance, that RUSESABAGINA Paul accepted his crimes without doubt, that this is not founded. But since he is a first-time offender, the court finds that his sentence should not be increased, because the 25 years that he obtained still is in accordance with the weight of his crime, and the court maintains that sentence. Regarding Sankara, the Court of Appeal considers that this is the first time that Arias Sankara is accused, considering that he acknowledged without doubt the crimes that were he was charged with, and that he asked for forgiveness to the Rwanda generally, and that he helped prosecution to obtain information about these terrorist organizations and the people who support them internationally. He continued also to maintain his revelations during the trial on the merits. And there was no appeal against that. The Court of Appeal considers that the Court of First Instance did not sufficiently reduce his sentence considering what he has done. And within its independence, the court considers that his sentence should be reduced from 20 years of imprisonment to 15 years of imprisonment. Considering Nizaimana Mark, the Court of Appeal finds that in view of the above, Nizaimana Mark denied the crimes that he was accused of, that for that reason he should not obtain a sentence reduction just because he acknowledged some of the crimes. But because this is the first time he is an offender, his sentence on first instance of the 25 years of imprisonment should be maintained because it is commensurate to his crime. Concerning Nsengimana Herman, as discussed above, he, during trial, denied that he was a member of a terrorist organization. He only accepted that he was a member of a military organization that is illegal. But for three reasons, he obtained a reduction of sentence. This led to a reduction of up to 5 years. The Court of Appeal considers that although the first instance rejected his explanations, it considers that he does not admit this crime because he says he did not intend to commit terrorism. Therefore, they consider that the reduction of the sentence was too large, was too big. He should therefore have a sentence within the independence of the appeals court. He is given 7 years of imprisonment instead of the 5 that he had received at the first instance. Iyamuremye Emmanuel obtained a reduction legally on the basis that he was the first-time offender, and the appeals court considers that the sentence of the first instance is commensurate to the nature of his crime and his particular circumstances. Kwitonda Andre, as demonstrated above, the Court of Appeal considers that the reduction of Kwitonda Andre was legally acceptable on the basis that this is the first time that he is accused legally, and the Court of Appeal considers that the sentence of the first instance is commensurate to the crime committed as well as his personal circumstances. Concerning Shimimana Emmanuel, the Court of Appeal considers, as discussed above, that Shimimana Emmanuel obtained a reduction legally on the basis of the circumstance under which he became a member of a terrorist organization at a young age, and considering the fact that he is a first-time offender. The court considers that the sentence of 3 years of imprisonment that was decided by the Court of First Instance was commensurate to his crime and his personal circumstances. Regarding Hakizimana Theogene, as explained above, Hakizimana Theogene obtained the reduction of the sentence legally because he acknowledged some crimes during the trial on the merits and during investigation, also during the hearing on the provisional detention. The Court of Appeal considers that the sentence of imprisonment of 3 years is commensurate with his behavior since arrest, his personal circumstances, and the weight of his crime. Therefore, the Court of Appeal maintains the sentence. Concerning Judgement and Jean Chrétien, the Court of Appeal considers that, as demonstrated, as discussed above, Judgement and Jean Chrétien obtained a reduction legally, considering the circumstances under which he was recruited at a young age into an organization because his father was one of the leaders, MRCD FLN, and he admitted having been a member. He has revealed information that helped the justice, and this is the first time that he is accused in a court of law. Therefore, the court considers that the 3 years of imprisonment that he obtained at first instance were commensurate to his crime, to his behavior since arrest, and his personal circumstances. Concerning Sanzubukire Félicien, his sentence was reduced legally on the basis of the fact that he acknowledged some acts he committed during the trial on the merits, during the investigation, and also during the hearing on provisional detention, and based on the fact that he is a first-time offender. The Court of Appeal considers that the sentence of 5 years that he obtained at first instance for being a member of a terrorist organization is commensurate with his crime, his personal circumstances, as well as his attitude since arrest. Therefore, the court decides that this sentence should be maintained. Concerning Munyaneza Anastas, the Court of Appeal has established above that Munyaneza Anastas was legally his sentence was legally reduced because he's a first-time offender, and the court considers that the 5-year imprisonment sentence that he was given for being a member of a terrorist organization is commensurate with his behavior since arrest, his personal circumstances, and the weight of his crime. Therefore, the court decides that the sentence should be maintained. Regarding Nikuze Simeon, the Court of Appeal considers the reduction of sentence for him was illegal, considering that his acts did not have caused damages, serious damages, and the grenade that he had was never used, considering that he is a first-time offender, and also taking into account all this, the court considers that the 10-year sentence that he obtained for being a member of a terrorist organization is commensurate with his attitude, generally his behavior, and his crime. Nabanganyimana Joseph. The Court of Appeal, as discussed above, considers that the reduction of sentence was illegal in consideration of the fact that his role was limited to procuring boat without participating in attacks, considering also that he's a first-time offender. And the court considers that the sentence of 3 years for being a member of a terrorist organization should be maintained because it is commensurate with the mode of participation, the gravity of the crime, and his personal circumstances. Now on Mukanduti Angerina, as discussed above, one of the mitigating circumstances that at first instance was acknowledged is that led to the reduction of her sentence for the crime is that she is a first-time offender. However, it was proven that on the 23rd of November 2008, the court of Gacaca of Rugenge had sentenced her to life imprisonment. The Court of Appeal considers that based on Article 52, paragraph 1 and 3 of Law 68-2018 of the 30th of August 2018 on criminal procedure, an article that says the following: for crimes, the a recidivist after a conviction, on third paragraph says that any recidivist should be punished by a sentence that is normally the standard, and such sentence could be multiplied by 2. On the basis of those laws, Mukanduti Angelina should obtain the sentence for the crime she was convicted of, and since she's a recidivist, she should obtain 20 years of imprisonment. Nirora Marcel. As established above, the Court of Appeal considers that the reduction of the sentence for Nirora Marcel was illegal on the basis that he is a first-time offender, and the Court of Appeal considers that the 5 years that he obtained at first instance should be maintained because it's commensurate to the nature of the crime, his behavior since arrest, and his personal circumstances. Concerning Matakamba Berkmas, Shaban Emmanuel Tibira Miramesan, Vikusengi Jean-Claude, and Sabiman Jean Damascene, alias Mota, the Court of Appeal considers that, as discussed above, there is no reason why Bizimana Kasi alias Batasi, Matakamba Berkmas, Shabani Emmanuel Tibira Mira Innocent, Bikusinge Jean-Claude, and Sabimana Jean Damascene, the court considers that there is no reason to reduce the sentence they obtained at first instance. Therefore, the 20 years of imprisonment should be maintained because they are commensurate to the nature of the crime they committed, their behavior since arrest, as well as their personal circumstances. The grounds of appeal on damages. A number of accused were dissatisfied with the judgment of the special chamber on international and transborder crimes regarding the damages, because some of the claimant provided their documents with some delay. Some accused say they are requested to pay for damages without having committed any acts or caused any prejudice to the applicants, and some applicants claimed they received very reduced compensation for damages or no compensation at all. regarding the admission of the application for damages that were, or the attestation for indigence that were filed, but with excessive delay. Sayumana Elias Sankara, Bizimana Mark, Bizimana Cassien, Navanganyimana Joseph, Nivera Mira Innocent, Piukusenge Jean-Claude, Sabimana Jean Damascene, and Shabani Emmanuel, as well as the council, claim not to agree with the decision at first instance where the admission of the application was done. Mukashima Marie-Louise and Munyamahoro Rene, representing the claimants, were submitted their documents in the name of Gimana Jean-Marie Vianney, and they paid the same amount, or though their claims are not the same, and their documents proving indigence were filed later on. The court did not take this, rejected that claim, and said that those documents can be filed at any time as long as the trial is still ongoing. Mr. Rugeja, counsel to Sayumana Elias Sankara, claims that in criminal matters, civil procedure was used, it must be used, so that a claim for damages cannot be admitted when documents, supporting documents are filed in due time, and that these documents were filed right in the middle of the trial, and that this constitutes a regularization of acts that they should have, documents that they should have submitted earlier on. Paying court charges or supplying or providing attestation of indigence are the basis of the claim. This should have been the ticket enabling the applicants for damages, enabling them to say that they have a common interest, but the court found that they did not have a common interest.
And also, actually, everything was done according to the law. You could send Jean-Claude and his colleague, represented by Guido, Mr. Guido, further to the appropriate law of 2018, and on administrative cases, and also Article 20 of this same article, it says that the applicant has to pay the required fee before their case is heard, or even before it is filed through the process. Therefore, the case before it was heard, it was explained that they had to pay the required fee. And Maître Ngamije Kirabo, representing Joseph, Jean-Claude, and Ntibiramira, that they did not pay the court fees, but their case was filed with the explanation that they were indigent and were not able to pay. But in fact, the Article 21 stipulates that you cannot be heard in court if you don't fill the requirements. Maître Wiman Shami and his client, who, as we just mentioned them above, that lawyer says that they followed the law of 2018 on ordinary cases, trade cases, and other types of cases. That even in these cases, your case will not be heard if you do not have not followed the process, including the payment of the fee. Judgement Jean Chrétien and the colleague also said that the fees have to be paid in time. There is a window that you have to follow because it is not just any time that you will pay the fees. So the lawyer said that this case should be examined along with the decision that was taken by the court in this regard. Also, the people who were late in paying the fee and therefore their case couldn't be heard at that time, Article 116 of the law of 2019 on the submission of cases. It says that the accused, or rather the complainant, has time to pay the fees, and they can pay the fees so even when the case has started. And also in the case of the appeal, not all the required fees were paid because some of them say they had no resources and therefore couldn't pay the fees, and the decision was taken that the cases can go ahead without the fee. Therefore, the complaint that the case shouldn't be heard because they didn't pay any fee is baseless. This court has examined these issues, including those who paid the fees or failed to pay the fees, especially for the case, the first case where no fees were paid, but also no proof or evidence that the court had decided that they had no resources. None of these two were made. The court decided that the court itself, the presiding judge, decides who is able to pay and who is not able to pay. But this decision should be taken in good time so that the fee can be paid at a later time. So long as the fee is paid or the proof of incapacity to pay is provided or submitted before the judgment, the reading of the judgment. As regards those who pay or who apply for damages, the applicable law, which is the law of 2019, and related laws about about the proceedings, the way the court should proceed. This article says that a person, a qualified person, can apply for compensation or for damages, and they have time to file their request, provided they do it before the judgment is read. And therefore, in these particular cases, if a person applies for damages, they can apply at any time, as long as they fulfill the requirements and pay the fees or have a dispensation, and provided they do it before the final judgment is read. No law says that anybody applying for damages should fulfill all the requirements at the same time for their case to be heard. The law says simply that the application should be made before the reading of the judgment in the first instance, and otherwise at any other time they can apply. Secondly, if it's a group of people, or rather if it's several people who are concerned with the case, there is no law that says they have to do it at the same time. Each one can do it at any time during the proceedings, so long as it is done before the reading of the judgment. Therefore, and singly or severally, various times or staggered, doesn't matter. Further, the required documentation and the required items in the application can be submitted at any time until just before the reading of the judgment. If a filing is not complete, or there is an element missing in the dossier, the court will examine the issue, and if there is something missing, the court should explain what is missing, when they can submit what is missing, and so long as they are submitted before the reading of the judgment. So this is a case with application for damages. There is no refusing any application so long as it's made before the reading of the judgment. Second point, the law that governs the application for damages was respected because the people concerned applied in time. But there were cases where the required fees had not been paid. They were paid on the 14th, just before the reading of the judgment, which is a fine. Therefore, since the trial itself ended on the 24th and was to be, the judgment was to be read on the 24th, this means that the application came in good time. In conclusion, given the above, this court agrees with the High Court's decision and the previous courts, including the Transborder Crime Tribunal, and agrees that those applying for damages were able to apply in time. Some of them paid the fees, others were not able to pay because they are indigent, and therefore their case should have been heard. And under Article 124 of the law of 2019, concerning cases such as application for compensation or for damages. Therefore, there is no, it is not true that some of the cases asking for compensation or for damages were illegally submitted. That is not the case. There is also a case of someone who was asked to pay compensation who claimed they had no reason to do that. Nikuze says that none of the actions that were adduced concerned her, this lady. She said she had no part in what they're accusing her of, for which they're asking for compensation or damages. And the second person also says that they had nothing to do with the consequences of those attacks, for which the complainant are asking for damages, and therefore he's not responsible. Ntonyimana's case may have caused damages that people should claim for, but he himself was not involved in any of those acts. He never told anybody to go and damage the property of these people for which they are applying for compensation. So Ntonyimana says that MLCD FLN had a plan and an objective, and their objective and their plan was simply to show that it is the organization that should pay for these claims of damages. And he said that all Rwandans know about the genocide criminals and the looting and the damages, and some of the Interahamwe were imprisoned for what they had damaged or stole. And he said that there are some of these who had not paid yet for what they damaged. And he explained that, in fact, the compensations and no compensations were paid, for example, for somebody in Butare in the south who claimed damages, and somebody in the north who were paid. In any case, he says that it is unfair to charge him with paying compensation for the damage that was done by more than 400 people. So is it, maybe they want to make an example of me, he says, or he asks. It is a fact that some points here are not clear. The Article 33 of the 2018 Criminal Code. This is the Code of Criminal Procedures. This article actually covers the issue of who pays compensation. Those who pay compensation are the entire group each one should pay so that the total amount of what they pay is sufficient to compensate the claimant. Also, I think we should now move to the issue of who is the author, who is the accomplice, who is the overall responsible for those crimes. And the question is that there are the theories of causality or proximity of causes that were not followed or were not applied. Because in these theories, any cause, proximate or remote, has to be examined. But another lawyer has said that these principles do not apply because they cover too many or rather wider fields. For example, the theory of the proximity of cause, théorie de la proximité de cause. That this theory should apply because it already exists in the Civil Code 259, 260, 261. And these articles apply to all those who were involved in causing damages for which there is a request for compensation, but including also those who made the weapon, who bought the weapons, who transport them, and also even those who made those weapons. Maître Sharif Youssouf, representing Hakizimana Théogène and Judgement Jean Chrétien, this counsel says that his clients, who are 3, and also those who have applied for damages, they explain that these people were forced to act the way they did. They were compelled, and in any case, they had no direct involvement in the damages. The damages for which now compensation is sought, and that there are others who were directly involved in those distractions, and therefore the accused or his clients, based on the theory of the equivalence of conditions or equivalent conditions, based on this theory. And in fact, on page 230 of the report, it is explained that these 3 theories, the ones I mentioned previously, and then this third one, of proximity of causes, those theories explain that these people were required to pay for compensation, but in fact, the court should have looked at this case and determined what are the limits, because there is also the theory of the wide or universal causality, which means that anything that happens has a cause or a root. Therefore, there are necessary effects, necessary effects, but in the universal causality theory, they say that any acts or all acts cannot be assumed to have had material effects. Therefore, the court use this theory, but in a defective manner. First, the lawyer said that the people he's representing would like the court to examine their behavior, their conduct, and their conduct was not taken into account by the court. And the lawyer said that the criminal Code of Criminal Justice also provide for the need to follow the theory of adequate causality. Adequate causality. And therefore, it has to be explained or proved that their activity, the accused activities, had a specific impact as regards the damage that are being claimed. And the lawyer says that there is a distinction in the responsibility of the accused, and we should have been, the court should have been very specific in each case separately to see who was responsible for what and to what extent. The three accused, who are represented by Maître Wunganye James, in this particular case, these accused have killed no one, have not robbed, have not looted, but and therefore those who are actually guilty of those crimes should be the ones to pay for the compensation that will given to those who are seeking damages. That these particular three people, these three individuals were not involved in anything that caused any damage, and therefore their counsel says that those who should be responsible for paying compensation and or damages are the people who were actually found to have been involved in these activities. It was also said that one of his clients was not actually at the time involved in the attack in question, and the lawyer, his colleague who has been supporting him, also said that Marcel, specifically, did not get involved in anything at all that caused any destruction, any of the destruction that are being mentioned. Marcel himself said that his role was to select the people who were to be sent to Nyamasheke. And he said himself that, in fact, beyond that, he is not responsible for anything. So if the theory of the equivalence of conditions should apply properly, so that a person should be responsible for what they actually did. And this, the accused says that he actually never sent anybody into battle. That there is nobody can prove that the people concerned who were sent into those battles were selected by him, and therefore no damage should be demanded from him. His colleague said that he was at that time a student and cannot be held responsible for any damages. It was also decided that this person should be involved, but should be among those who should pay damages. And their counsel said, well, there are 20 people who were supposed to pay, whom it was decided that they should pay compensation. But he said, my three clients had nothing to do with that. For example, a car was burnt out, but not everybody took part in the burning of that car or torching of whatever else was torched. Therefore, the explanation should be given as to who pays compensation for what damage and what is their responsibility, direct responsibility in those damages or destructions that occurred. For example, his three clients, did they go into Nyungwe for the attack, or were they part in the Nyaruguru attack, or were they convicted of having helped cross the lake, maybe provide a boat or some other means? If not, they cannot be required to pay compensation. Responsibility should be direct. James say that these people were forced and compelled to join these groups, but they have no responsibility that can be called specific, and therefore they cannot be required to pay compensation. Jean Damascene, Shaban Emmanuel, and their counsel, women Shani, say that they cannot be required to pay to pay compensation or damages, because in fact they were not the ones. What they were sent to do could not have happened without damage, without destructions. So those who send them, their leaders should be the ones who are responsible for those damages. And I think so that this is the point, that the head of that armed group, the heads, should be responsible for the damages. One of the clients say that he cannot be responsible for the damages that were done in Rusizi, because there was no personal involvement. He just found himself in that body or that armed group, and cannot be held responsible for anything that was damaged. The theory of equivalence of conditions was applied, but the theory of adequate causality was also applied, but if it had been followed, it should have meant that the people involved should be responsible for what they actually damaged. If they did not damage anything, or if they didn't damage whatever the claimant is mentioning, then they shouldn't be held responsible. Now, Counsel Muka Rusagiriza Chantal and her client say that what happened in Nyaruguru, Nyamagabe, Nyungwe Forest cannot be the responsibility of her client, because first of all, they had not entered that armed group, and they were not in that attack. So what happened in Rusizi certainly can be related, connected with her client, but not these other three. Further, as regards damages, the attacks in Rusizi are the ones that he accepts being responsible for. But in Nyarimata, Nyamagabe, and others, he does not accept that. He was not involved in those. Therefore, the 39 claimants, Maitre Munyamahorene Mukashima Marie Louise representing them, they have said that they should not have been ordered to pay compensation, because in fact, to pay damages, because in fact they had nothing at all to do with these attacks. They were not involved in them, and in fact also the appropriate law of 2018 on sentencing explains clearly that the accused does not necessarily have to have been personally and directly involved in damaging what was damaged, but the group that they were in, that they were involved in and committed that particular act. And therefore, even those who didn't actually get involved in a particular destruction have got to collectively pay the compensation.
Those representing those claiming for compensation, about 73 of them, referred to three types of theories. They said they can base their argument on any reason related to the activity. Second is direct cause to effect, and the third would be the probabilistic theory, which is that the action closest, the reason closest to the action occurring. They asked the High Court to consider the equivalency of conditions, where they clarify the crimes committed, so those who committed them should be held accountable. Those accused who belong to MRCD FLN are in different categories, including those in the leadership, namely Paul RUSESABAGINA, the leader, Sankara, the spokesperson, others including commissioners and high-ranking officers and other soldiers. There are others in charge of logistics and those who carried out the attacks, and those are the ones supposed to pay compensation, and they cannot evade that responsibility. They say that about Nsengimana Herman, who was the spokesman for that terrorist organization. In 195 section, we see that he's the one who produced a communique about what happened in Mborera sector, so he knew what had happened. Nzeyimana Mark was a colonel with FLN. In paragraph 221 in the appeals case, he himself has said that he identified and selected the soldiers who carried out the attacks. And Nshimiyimana Emmanuel, though he was a student, was a member of FLN MRCD and played a role in the planning of the attacks. And Nero Marcel, a colonel, prepared and trained the attackers. And others who admit having participated in the actions in Rusizi do not clarify when the terrorist organization was founded. But the attorneys representing the civil parties have given such information. Attorney Munyamahoro Irene and Mukashema Marie-Louise further clarify that the equivalency of conditions and the cause to effect theory match articles related to the fight against terrorism, where the law says that a terrorist organization is a group of people that is whose operations are very well planned. So they say this to mean that the terrorist organization in question was organized. The FLN was there. It had a plan. They had a division of labor. The activities were assigned to different people in different areas, in Nyabimata, in Rusizi, around Nyungwe forest. The attorneys also say that, like Sankara said, before they issued a communique, they also had pictures, which meant that their terrorist organization was organized. When they attacked in Rusizi, they sent photos of the attacks, the dead, the loot, and the damage. Sankara, who was the spokesperson, could not do this on his own. If there were nobody else in Rusizi who took the pictures to send to him for his press releases to prove that FLN was in Nyungwe forest or had captured Nyabimata region. The counsel to the ones claiming compensation referred to the law about the fact that the terrorist organization is organized, it has an organizational chart, and there's a division of labor within the organization. In paragraph 391 in this appeals case, Nirora Marcel, who was colonel, aka Bama, has said that he had different duties, including key ones in these activities. They included the welcoming the new recruits, and this matches Sankara's statements that they used to recruit people from Uganda and they would cross into the Congo, which means that Nirora, as an officer, would welcome them and train them and tell them how everything would be unfolding. Therefore, he cannot stand before the court and say that he was a young guy or a handicapped who didn't do anything. Still, he's among those who pleaded with the court to be released or have his sentence suspended. The attorneys have requested the court that they take into account the goodwill of the accused and their plea to have their sentences reduced so it matches what's in their case and the compensation that is claimed. Attorneys Munyamahoro and Marie-Louise say that though the accusers want to be tried personally, they have personal responsibility, they said that cannot work because that would work if they had been found innocent. They are being held accountable for what they did. What the accusers said, according to those attorneys, are baseless because they did not play a role in founding the FLN, so they cannot be accountable for that. They did not create the organization, though they were members of the organization, and that organization has caused damages and has attacked different areas. And when they say that the equivalency of condition theory cannot be used in this case, in a case where you have many accusers who cannot be tried at the same time, attorneys Munyamahoro and Mukashema say that the point that there are many accusers, co-accused in this case, the most important thing is personal responsibility. Even though there are others who should be held accountable, they will be, but those who are accused are the ones who should pay compensation. So based on the reparation in Soldum, they are the ones who should pay those reparations fully. About what was said by Nsengimana Herman about compensations, that it should be paid proportionally based on each and everyone's role in the damage. Those represented by attorneys Munyamahoro and Mukashema, they refute that. They said it's not the legal principle. Those accused and found guilty of the same crime can pay reparation as a group, and maybe one of them can pay that fully because the law provides for it. It allows them to do so. So they say that the accused, if they wrote a letter and say they wanted to pay together, that would be okay, because those who claim compensation all they need is to be compensated, and there needs to be full reparation. Attorney Munyamahoro and Mukashema also say that about those who say that compensation is very small, is likely to be very small, there's another responsibility, civil responsibility, that says that the gravity of the crime should not determine the amount or the size of the nature of compensation. Anybody who committed a crime should pay for it. It doesn't matter how small or big. They also add that the accused who have played a role in the Mercedes FLN can pay those reparations. And anybody who has the means to pay it could pay the full reparation because the law allows them to do so. Attorney Morango Faustin, who represents 4 people claiming compensation, says he agrees with the Munyamahoro and Mukashema, and adds that the accused who are requested to pay compensation for the crimes they were not found guilty of, rather the crimes they did not appeal for, the sentences they did not appeal for, the High Court referred to Article 11 in the Penal Code because those accused from the FLN are known, the accomplices are known, and they did not appeal for anything, any of those points. They were members of the terrorist organization, which caused damages that the people seeking compensation are referring to. So the theory of equivalence of conditions were not used, even though we have different defendants. And he said that Attorney Rugeyo Jean, representing some of the defendants, neglected the fact that there are some crimes that some defendants were found guilty of, and the crime of being a member of a terrorist organization, MRCD FLN, is the source of the damage suffered by these claiming compensation. So there's a cause-to-effect relationship. And about how compensation will be paid, he says that that is related to enforcement of the verdict. It's not about how compensation is determined. And those claiming compensation cannot get involved in everybody's role, the defendant's role as authors or accomplice within that terrorist organization or during those attacks. So he finds that the defendants who said they cannot pay compensation, they're contradicting themselves. Karirangawa Antoine, one of those claiming compensation, represented by attorneys Paul and Joseph, says that some of the defendants who say that they cannot be ordered to pay compensation because they did not participate in attacks is baseless, because maybe they participated for a few days, but they did. Attorney Hakizimana Joseph, representing Karerangabo, claiming compensation, he says that he supports what was said by his colleagues in this case. No defendant has ever appealed to be found innocent. And about Karerangabo, who did not get any compensation, he refers to Article 73 of the Penal Code that provides that people who were found guilty for the same crime should pay together, including court fees. And he's talking about all of the 21 defendants who participated in destabilizing Rwandan's security with terrorist acts and murder, because their plan was to destabilize the stability and the security of Rwandans. They committed different crimes, but all related to a terrorist organization. And this had consequences on the population. Some of them were traumatized, and this is the basis for compensation that is being requested. This is the court's stand on this. The appeals court finds that in this argument between the defendants and the claimants, it is based on the defendants. Even though Rusesabagina did not appear before this court, Sanzubukire and Munyaneza were not found guilty of belonging to MRCDFL and terrorist organizations. All other defendants who said they should not pay compensation because they did not participate in the attacks, the fact that they were members of the FLN, they say, is not good reason for them to pay compensation. They say compensation should be paid by the FLN or its leadership that organized and planned those attacks. But those claiming compensation say that all defendants should together pay compensation because all of them participated in MRCD terrorist organizations' attacks that resulted in different damages, including the loss of their loved ones, others who were injured, and their properties destroyed. That compensation should be paid because they committed that crime of belonging to that terrorist organization or getting involved in its terrorist activities, even though they were not present on the scene where those attacks occurred. This court finds that the defendants have admitted that they played a role in the Rusizi attacks, including Matakamba, Bizimana, and Jean Damascene, though they say they should not be paying compensation for Nyaruguru attacks and Nyamagabe because they were not on the scene. They say they had not even started cooperating with FLN. They say it should be paid by the co-accused. But though they also say they did not participate in those attacks, and they said they should not be held accountable for Rusizi attacks because there are others who admit they participated. They are the ones who should pay compensation. And Article 11 of the Law 27/2019 of 19 September 2019 about criminal cases provides the following. A defendant can be held accountable or their accomplice or the others who should pay compensation. Compensation should also be paid by those who inherit from those who committed the crime. And it's not about just the person who was there physically, but others related to them who are associated with them. But the court finds that given the nature of the crime, it's possible that a crime is committed in one place and the consequences are suffered by other people in another location or property in another location. And those found guilty who should pay compensation. Article 33 of the paragraph point 3 of the law of 2018 about crimes and sentences provides for this. All those who were sentenced for a same crime participate together to pay compensation and reparation as well as court fees. And this means that when the commission in the commission, if a crime committed results in damage, there should be compensation. If it has caused some kind of trauma, there has to be compensation. When that commission of crime was confirmed by a court following a trial and court cases, all those responsible should pay the compensation and court fees, and the court orders them to pay those fees together. And as the primary court said in paragraph 630, page 230 of the case that was appealed, this court agrees with the primary court on the guideline to follow, as it was explained. And in this appeal, that guideline was never contradicted by any of the parties. So the one who commits a crime and it results into damages should pay. And it's been confirmed by different scholars in different countries about compensation. Any act by a person that results in damages, the person who commits that crime pays for compensation. And when the one who has committed the crime is one individual, and there's a principle that was clarified. Paragraph 33 of that law from 2018 about crimes and sentences, as we've reiterated, it emphasizes that principle. Those who commit a crime as a group pay together in soldum. There's no need to calculate what each and everyone is to pay separately. Those who are found guilty together of a crime, you don't need to establish each and everybody's role separately. If a crime was committed and has resulted into damages and somebody is claiming compensation, somebody was found guilty, then there's no need to encourage others to look anywhere else, because the law has clarified this in this paragraph 33, that the one found guilty should pay compensation. And when there are many who are found guilty, they pay together, as we have explained. As we examined who should pay the compensation, those seeking compensation have said that the attacks damaged and their property, and one needs to know whether what was damaged was actually damaged by the act of forming MRCD, a felon terrorist organization, and the commission of a crime as in those terrorist attacks, and whether those who committed the crimes were found guilty.
All The accused appealed on the grounds that they should not be asked to pay compensation while not having had any role in the damages. The Special Chamber for International and Transboundary Crimes has considered that all the grounds should be considered in determination of compensation, and has found that MRCD, by its very existence, has caused the commission of those damages, and those who committed the damages did it as members of FLN. Therefore, those who are convicted of participation should, in solidarity, contribute to pay for damages. Therefore, all the accused and the counsels request the court to reject the conviction for compensation, because the accused themselves agree that they took part in what happened in the Rusizi districts. But they want the court to not hold them responsible for what was done in Nyaruguru and Nyamagabe, because they didn't take part in the attacks in those areas, and that when this happened, they were not yet members of FLN. All the those who applied for damages also all consider that the sentence be maintained. It took time for the court to analyze the different aspects of this issue in terms of analyzing the principles that govern compensation, and the fact that this has led to a long debate. The court considers that it was not necessary to dwell too much on the arguments of the experts, because the law of 30 August 2022 is sufficient, because Article 33 of the law of the law of 30th of August 2022 doesn't require any other grounds to request the accused to act in solidarity and compensate the victims, apart from the examination of the crime that led to the damages. The court finds that the accused in these appeals proceedings were members of RCD, and others have also taken part in the acts of terrorism that led to the damages in various parts of Rwanda. Therefore, all the accused, even in this proceeding, are responsible for those acts of terrorism, and they must remain in solidarity, liable to the payment of damages. Therefore, the appeal of all the accused in this respect has no foundation. There are 47 persons who applied for compensation, and the High Court did not obtain them as requested. The court having used its discretion. Habyarimana Jean-Marie Vianney bapakurera Venice, Rugirinyange Venice, Nabarisha Dativa, Habyarimana Jean-Marie Vianney, Shumbusho Damascene, Saimana Anastase, Mukaseka Josephine, Siborurema Venice, Ngendakumana David, Rudahunga Ladislas, Kiranga Dalius, Umuriza Deine, Shumbusho David and Rudahunga Damene, who was represented by Rudahunga Radislas. Rudahunga Radislas near Verian Girabavie Desire, Bimana Zerot, Nionegereje Azier, Kaitesi Alice, Nirandibgami Marianne, Wambaje Françoise. 5 children of Mkaba is Hilary, represented by Boniga Richard. These are Dikumana Isaac, Mkankundi Alphonsine, Uzai Sengalidian, Habakubaho Adeline, and another sister. There is also Mkaba is Hilary, Boniga Richard, Fugabagabo Jean-Marie Vianney, Murengeranzo Aridona, Kizimana Deni, Ramigo Alexis, Nyirangavire Valérie, and Semigabo Deo. There is also Ngurunziza Jean de Bomsen, Zaimana José de Masen, Rutaishiri Felix, Mahoro Jean de Masen, Zaimana Paulin, Dutia Yusuf, Omega Express Limited, and Axfa Express Company. The applicants in this category claim that the consequence of MRSD FLN in Nyabimata, Ninya Aruguru, in Nyungwe, at Kitabi, with the Nyamagabe, as well as Kamembe Nyakarenzo in Rusizi. Those who appealed the amount, Maitre Munyamahoro René and Mkashema Marie Ruiz claimed that their clients were prejudiced by the attacks in Nyabimata, and 11 of them were not happy with the compensation decided. Bafakulera Venuste lost their motorbikes. Habyarimana Jean-Marie Vianney, Simon Anastasia Pararama Venus, Ngendakumana David, and Shumbushu Damasen, property was looted, and they were forced to carry the loot. Dative lost a child, Gabriel Marie Santana Mukashaga Josephine lost their husbands.
Havugimana Jean-Marie Vianney
Concerning Havugimana Jean-Marie Vianney Pakulera Venust, got their motorbikes burnt. Nyamahoro Vena and Mukasha Marie Louise, as lawyers, say that Havugimana Jean-Marie Vianney obtained only 500,000, although his motorbikes was burnt, and he lost, while he lost the property worth 300,000. His motorbike was new and it was not registered to his name because he was paying it in installments. Therefore, the money he used to obtain the papers that were burnt together with motorbike, 120,000 that he lost, trying to follow up on this question because the owner was suing him in court, and he finds that the compensation should be 1,100,000 and not 500,000 that they had requested for. He says also that his motorbike was burnt by the attackers of FLN in Nyabimata, Nyaruguru, and he had purchased it for 1,400,000. He was meant to pay it for it within 1.5 years, but he had owned it for 4 months only, and it was not his own because he hadn't finished paying for it in order to obtain a mutation of a transfer rather. Bafakulir Venus obtained 600,000 of compensation for the value of his motorbike, whereas he had shown a report of the authorities showing what had happened, and this has had damages, rather prejudice to many people, and he was asking for 500 million plus that was supposed to cover all the damages. They consider that the court did not compute the damages properly because they only paid lump sum for the value of motorbikes only, and they consider that in Rwanda there is no law that explains in detail the computation of certain types of property, and in this appeal they filed a document that shows how this computation is done in other countries. They say that in the case of Germain Katanga, the lawyers for the applicants matters compensation showed that the court does not only compensate for the value of property damages, but also that there are other prejudices that are derived from the loss of that property. Also, the living standard change because of the loss of such a property. They are therefore requesting the appeals court to take into consideration those aspects. And they say that they never proved how much they were making every day. And since they were in the informal sector, it was impossible to obtain documents showing how much they were making. Therefore, they considered that a motorbike brings between 5,000 and 8,000 francs per day. The two lawyers say that about 5 people have in common the fact that they applied for damages because on top of losing some of their properties, they were also kidnapped and made forcefully to carry looted property. That's Sivoruma Venus, Ngendakuman David, Shumbusha Namasen, and 2 others. And they say that for all those people, the court only based on the report of the Nyabimata district showing that they were kidnapped and a lump sum was of 300,000 was paid, but they were dissatisfied with that amount, and that's why they appealed. Regarding Savimana Jean-Marie Vianney, the court granted him 300,000 because he was made to carry property, but he did not show proof of other properties of his that were looted or damaged. And the court has therefore proof that damages were to property were made. Therefore, he's requesting more than $1 million telephone, trousers, stock of beans, and other things. He wants, therefore, to be given 1 million francs. Sabiman says that he had applied for 1,230,000, whereas the court only granted him 300,000 and ignored other requests. Now he's asking for 1,213,000 as he had requested before, including 150,000 francs that for which he had sold his cow and he had to pay it to attackers so that they don't kill his wife, and many other things, including 1 million of damages and prejudice because he was made to carry the loot, and he came back at daybreak. Therefore, they are applying for 570,000 as he had requested. This money includes 70,000 of his property that was looted, milk, telephone, clothes, and 500,000 for damages for prejudice. Gendakumbana David had applied for 528,400 francs because he was kidnapped and his property was stolen. But the court only gave him 300,000 because he was kidnapped. But he wants compensation for his property also. He wants the same amount that he had applied for, including 28,400 that represent the value of many things that he had: food, stuffs, telephone, and clothes. Also, the 500,000 are for prejudice for having been kidnapped and made to carry the loot. Samuel says he had applied for 554,000, but the court granted him 300,000 only without taking into account his stolen property. Now he's requesting 654 that he had applied initially, and this includes 500,000 for his for the prejudice and many other properties. Metro Munyamahoro René and Mukashima Marie Ruiz, who represent these clients, consider that that the court, just because there is no proof of those damage and stealing of this property, they did not prove that these represented damage. They show in their evidence that they lost property, and that the court in its independence should take into account this, because it's difficult to obtain the receipts for telephones and clothes and such items. But the prejudice they're talking about is a part of the kidnapping and the stress caused by the abuses that they suffered during that kidnapping, and they're requesting the court to base on all these damages and prejudices to grant them the amount requested initially. There are also other people represented by Nyamahoro Reni and Mukashima Marie Louise. These people are from Nyabimata. They also applied for damages, and compensation was not satisfying. Mukdative and Mukashika Josephine and others lost either children or husbands. Rigelinyange and Dative say they obtained each 5 million for the killing of their child, Habarorema Joseph, but the report of the authorities that the court considered shows that some boutiques were also looted, and their own was also one of them. They are requesting 17 million, including for prejudice and compensation of the damaged property to the tune of 7 million. The two lawyers explained that the reason for appealing is that the court only granted them 5 million for the death of their child, but they didn't consider the telephone that was worth 19,000, the boutique where the motorbike was burnt, and the fact that Nyakwigendera Habarurema Joseph was living there, working there, and there was a flat television valued at 200,000. They are dissatisfied with the decision of the court because they obtained 5 million only, whereas they had applied for 45 million in compensation, because this child was helping his parents, and now they are not only suffering pain, but they're also suffering loss of income because their child was helping them, and they also were not compensated for the property because the court considered that they had no proof of those damages. The wife who lost her husband says that she had applied for 30 million because her husband, Manirao Anatol, was killed because he was the head of a school in Nyabimata, and she considers that the court only granted her 10 million, and all other compensations were not granted because allegedly she had provided no evidence. The two lawyers hold that damages were proving the amounts of money that were coming into the family, but they did not prove how much the deceased was making. But Annex 11 now has been deposited, and it shows that the gross salary of her husband was 207,037 francs, but he was getting a net of 130,000, and they consider also that the compensation of 10 million does not take into account the expenses for the burial because she did not present any proof. They consider that all those people who lost should not be held should not be denied the opportunity to obtain compensation for all the damages linked to the burial, because it is impossible to prove or obtain receipts for all the expenses made during the burial process. And they compounded all this in under the what they call the prejudice, because even the money she had was lost during these activities and of burial, and this has affected her standards of living. They also say that there is no way they could have shown the details of the expenses, but they had asked for this money as a lump sum together with the prejudice, especially since for Ingabire Marie Chantal these details could not be given because there is no proof of all the money that was spent during that process. They request that during its deliberation, as they requested, that other factors should be considered in order to increase the grants that the High Court had granted. They wish, therefore, that losing a family member cannot be assessed restrictively, but that the damages should be considered in a large interpretation. The loss of Munyaneza Fideri also led to the application of his widow, and she had applied for 100 million because her husband was making 100,000. She had younger children, and the husband was the breadwinner for his family and his parents, but the loss of income was not compensated because she had, apart from her statement, she had not brought any proof of the amount that the husband was making. They claim that later on they obtained proof that the deceased was making 100,000 per month, and this document was submitted into evidence as appendix number 111, and she requests the court to consider the salary of the husband and other damages and prejudices and grant her 100 million francs. Senjuva Fensa, represented by Mr. Murangwa Foster, holds that on the 19th of June 2018, FLN attacked his home and burnt his car, RAV4, with a value of 25 million, with some private property of 30, in the value of 30 million, that he was wounded seriously on the head, and that he spent 1,500,000 for medical expenses, and that while he was receiving medical treatment, he spent 4 million. He says that on top of all those expenses, 20,600,000 should be added, because every day he lost 20,000 million because he could not use his vehicle that was bringing him income. He was therefore applying for compensation for prejudice and 40 million for court charges. And he says that he submitted several documents proving the veracity of what he says, and that witnesses also testified. And this declaration of witnesses should help the court understand that some evidence could not be obtained because of the trauma, physical and mental, and circumstances of the attacks. He claims that the court analyzed the evidence and found that he was wounded and that he was treated within King Faisal Hospital, where he was sent by the University Hospital in Butare. Nevertheless, that decided that he could not obtain less than 5 million that he used in the hospital and for medical treatment. And the court considered that nothing proved that he was hospitalized and how long he spent there. And he says the court was contradictory because having admitted that he was sent from the Butare hospital to King Faisal, turned around and said that nothing proves that he was hospitalized. He is therefore requesting in appeal for the compensation to the tune of the amount he had asked. He says for his vehicle that was burnt, the court considered that he had this vehicle as the owner, and he was granted 15 million in its discretion because he could not prove that that vehicle was worth 25 million. He also criticized the fact that the court was contradictory because the court obtained the evidence concerning the value of vehicle, but then had to make an estimate to fix the amount, whereas the amount should have been clear. Regarding the damage to personal property in the house, they consider that each party should prove the veracity of their claims. Sengyumva Vincent has proven that his property was worth 30 million, and the court considered that the report that made by the authorities in Nyabimata does not contain a reference to a loot of property, and he considers that the report says that the property was burnt, not stolen, and he says that the court should base on the evidence of the witnesses such as Antoine, but he should not be denied his rights. He also mentions the expenses due to transport because he used to utilize his vehicle. The court has given him 6 million because his claim was too high. He considers that there was an estimation, whereas he had proven that he needs a vehicle in his daily life, and that every day when you rent a car, you have to spend between 15 and 20,000 per day, and he used that as a basis to compute the amount that he had applied for, and he does not understand on what the court based its reasoning in determining his compensation. He also requests, he says that 500,000 only was given to him for his transport and all the court proceedings, whereas the court should have considered his trip to Nyanza, and he obtained altogether 21,500,000, and considers that all the evidence that he had used should be considered, and others that were submitted on appeal, including witnesses, that this should be considered to increase that amount. The advocate says that the receipts and the expenses in the hospital were shown, that the carte jaune was shown, showing that the vehicle was bought in 2016, and that as a civil servant, this car was not older, had not more than 40 kilometers. He had bought this vehicle 25 million. Giving him 15 million after 20 years only would not be understandable. He says it would be inconceivable that the vehicle lost half of its value within 2 years only. The witness, Callisto, who lived with Sengyumva Vincent, explains how the attackers burnt his vehicle and burnt property within the house. After that, they damaged property there, and it would be difficult to obtain the receipts for all those properties. Regarding the prejudice, he says that he had applied for 20 million considering his prejudice and his suffering, because up to this day he still has wounds and he can't work properly and take care of his family, whereas the court has only granted him 6 million when the amount he had requested were not all that high.
As regards those from for Munyamasheke, who asked for compensation, their counsel says that 26 people were affected and they were compensated, but they find the damages too little. Nyirabye Desire Boniface and their friends, Rudahunga, Ladisias, Yodone, Madeline, Marius, Mbonigaba Richard, Ndikuman Isaac Mokan, Dutier, Alphonsine, Adeline Habakubaho, Fugabagaba Jean-Marie Vianney, Nyiramana Alexis, Nyirangabire, Semigabo, Nyirayumve, Ndebwami, Karegesa Phineas, Zelot, Azel, Alice, and Yamabari Vedast. Now, as regards Wambaje, Françoise, her counsel said that her client's husband died in the attack and she was traumatized, and especially as she was left alone to bring up the children, and that she, of course her resources have dropped very seriously, but also that she had to pay for the funeral and all that had really set her back. Her husband was a self-employed man. He had 2 cars that he rented, and he worked with the government resources plus the reserve force and the local school and the municipality, so that he could get 4 million per month of receipts if he was lucky. And he had also borrowed 100,000, or rather, she had asked for 100,000 compensation, and so she thought this was what she should get, because she had also proved that her husband, income flow. She had, bank receipts and so on. And in fact, the bank gave a statement where the husband's deposits were proved. Therefore, she thinks that the amount is too little. And the court explained to her that the problem is that she had children, and she should have also been, that should also have been considered. She is bringing up all these small children on her own. She is not able to get the same income as when she had a husband, and she said it's a pity that one does not also compensate for the death of the husband, because sometimes, when you had an accident, a car accident, or even when you were killed by an animal in the park, wildlife, there are compensations. But for somebody who, like a husband who died, the compensation was not properly evaluated, because they assume that since he didn't have a regular job and income, therefore, that wasn't taken into account. But the husband, of course, was earning money, and the income that he was getting was approved by his bank deposit. But no, they decided that since he was an unemployed man, he self-employed, in fact, he should, the compensation should be based on a minimum salary. So 100,000 that she asked, she found that it's not enough. There were so many problems, so many people died, others are traumatized, they are wounded, and in fact, they even didn't think there would be justice for them, And sometimes the proof, a proof of loss is very difficult to show. For example, the funerals of her husband, where she had no receipt or anything, she couldn't prove anything because at that time she was in such a state that nobody thought of counting. And also, there are other evidence that proved that her husband worked with the government. He had cars, as explained, government, local authorities, and so on, even the military, and that can be proved because that is, of course, documented. So that there are also photos. There are references where she showed the funeral, the tomb, how much it cost, and the burial as such. But then there was also transport, because she had to transport their family and friends, and others who needed to come to the funeral and be transported back. So this is the problem. What was lost, also compensation for trauma, compensation for the death of her husband and others who died with him, plus these are the things that she lost, like loss of earning. And therefore, she thinks that the 10 million plus economic damages, the losses, that should also have been counted. And in fact, she should be helped or compensated, because, for example, the funeral, okay, there may be no receipts, but it's very easy to determine the value of the tomb and the associated items. But the court doesn't seem to have taken that into account. So she is requesting compensation for those expenses, because they were real expenses. But the 10 million compensation, that is also very little. So that, she thinks 50 million is what she really should get. So, Parababje himself had asked for over 50 million because he was wounded, then 20 for compensation, and then the court expenses, but he was only awarded 2 million. And it was said that Desiree was a driver, and he was coming from Rusizi, and when he got in Nyungwe with his minibus and tourists, they were shot at, many died, others were wounded, and he himself was very seriously wounded because he can no longer drive, and the doctor has already certified at the hospital, Chibagabaga Hospital, that his disability is at 20%, but he cannot be operated on to remove the bullets from his leg or his feet, because that is too dangerous. So, but the court says that he did not present that medical report in time, but he did present it. In fact, it's in the system. And even he says that when he was a driver, he used to earn 5,500 per month, but he has not been able to prove that. Well, he also said that he should be compensated because between now and his retirement, he cannot work because he is handicapped. So his counsel also said that the Kibagabaga Hospital doctor gave a report showing that he's handicapped at 20%, but also he will always be in permanent pain because, unfortunately, he cannot be operated upon. So that he was given compensation, but also for his medical condition. So compensation for his loss of earning and then medical condition, but both of them are very low. Now, Kirenga, Darius, Lisa, and accused or co-plainant, they received 30 point something million compensation as a group. But there was one, Adeline said that she spent a lot more, much more, that Shumbusho, David, Kirenga, Darius, and Adeline were only given 2 million. So they're asking for a revision. This amount is very little and does not correspond to what they lost in their case. Now, another group with Liliane Mukandutier and Bwagabagabo, Murengera Ntwari, Dennis Rwamihigo Alexis, Nyirangabire Valerie, Semigabo Deo. Their lawyers have represented that following the death of Hilaria Vaziga, that they were asking for compensation of 5 million, but unfortunately they were given 2 million and 5 million for the surviving children of the deceased. So that group, which is a family, are asking for higher compensation given their situation. So the counsel for these people have explained that a 20-year-old a student who was going home was killed. For that compensation, they are asking for 15 million and also 5 million for material losses. But unfortunately, so that's 20 million. But unfortunately, the court has awarded only 5 million, which they find very little, and they want the amount raised. And Yetri Mukashima has explained that one of her clients has lost her husband, and she has asked for 23,500,000 compensation, but the court awarded her only 15 as compensation as damages. But unfortunately, for what she had lost, the material losses and so on, that doesn't seem to have been taken into account. And so she was given just 10,500,000, including court fees and so on. And what was looked at was the earnings of her husband and the evidence that she was able to present about her husband's earnings. But since there was no, he was not a regularly employed person, the SMIG, that is a minimum salary level, legal minimum salary, will be used as a basis. But the student, her son who had died, she asked for compensation for barrier and losses and so on, but she asked for over 23 plus million, but she only got 5. So she thinks it's very little. Her lawyer said that in addition to the above, there were other people who were also wounded in the Nyungwe attack, and they were Habimana Zelot, Tinyon Hegereje, and Vedast. As regards Habimana Zelot, his counsel say that he had asked for 139.5 million, but the 2 million that he was awarded is very little, very, very different, or the gap is huge. So because there was a report from the doctor at the Judgement hospital about his handicap and the constant pain that he's in, and plus the loss of earning and so on, and they think this amount is very little. As regards Nyirantegereje Azel, she had asked for 5.5 million, but only got 2 million. And the court said that the doctor has not shown that she has a handicap resulting from the attack. The doctor's report showed that she was damaged and she's handicapped, and her face has been damaged, so she should be compensated. Unfortunately, she only got 2 million instead of 5 million and a half that she had asked for. And also they should take into account the medical effects. Now, Vedast had also asked for compensation. He has a medical certificate showing that he was wounded and he's handicapped. But unfortunately, when you look at the report, the reading says that his evidence was presented and justifies 2 million compensation. But then he was also at another paragraph listed as not having been compensated. It is true that he had asked for 20 million and he only got 5 million. But 5 million is very little, but it is not in the report. So I think the report should be revised so that these issues are also dealt with. Now, Metro Murangwa Foster's clients also say that they were not happy. Metro Murangwa Foster, who represents Yusuf said that he was coming from Rusizi and he was in the Nyungwe forest and he met armed people. They stopped him. He came out of the car. It was a golf car, and he gave the plate. Well, then, when he came out, he found that they were armed, so he ran into the forest, and then he found later on that his car had been set on fire, and he found that it was FLN fighters who had burnt it down, and therefore he's asking for compensation, including 20,000 per day, to compensate him from the loss of this car, which was his livelihood. And therefore, also the pro forma invoices from Kameka, the car dealers and everything is there. And the car was worth 8 million at the time, and the insurance was also included. In fact, there is even a photo of that car that shows that at that particular time in the Nyungwe forest, fighters from illegal groups burnt a number of cars, including that one. And therefore, he should like to be compensated for his car, which was a VW Golf 2021 model, and that he had all the documentation, including insurance and other, and also a report, because when they found it had been burnt, they made a report as to what has been lost. So he says that he should have been got 4 million, and he's very sorry that he was only given 4 million because 4 million can't buy a car, and therefore maybe they should evaluate the car, because the amount they gave him, it does not correspond to the amortization of that car and so on. It's just far too little. He also said that since his car was burnt and he was traumatized by these armed people, that he should also be compensated by 2 million for the trauma. Unfortunately, the court says that the documentation presented did not justify the amounts that he was asking. And he said, no, but this is my car that was I using, this was my livelihood, and now I had to hire another one to survive, and the rental is between 15 and 20,000 francs a day, as is well known. So, and Sufi went to court in Nyanza, and then he came to Kigali when the court was moved here, and he said, of course, that was loss of earning because he wasn't at his work, and the compensation that was given is also very small, and therefore it should be increased. Omega Express Company Limited. Maître Murangwa Faustin says that this company is a tourist company or transport company that lost 2 cars of the Coaster type. The number plate was given, and these cars were burnt in Nyungwe Forest. And he said that all the papers, documents, bills, and the receipts from Akagera Business Group and everything, the chassis number was given, and everything was provided, so that and the number plate as well was given. And the price that it will cost, 51 million, almost 52 million, and the car was 5-year-old. And the second car, whose number plate and chassis number were also provided, and the price, which was over 52 million, and the car was just 1 year old. Both these cars were burnt, so that the amount should have been over 600 million, because of the price, because of what they were earning as as the transport vehicles, and other damages, including 20,000 compensation because of loss of customers, because the company was no longer trusted, and that really set them back, and they should be compensated for this as well. Therefore, the court says that they went by the documentation, 2 tourist cars or transport persons transport cars, that they should be compensated for that, including also the court expenses, and the 51 or under 52 million, the court found that it was too high. 40 million was approved. The second car would also be given 42 million compensation because it was newer. And also the other requests were not clear. For example, they said that the car was going to last for 20 years, and therefore the daily income over 20 years was calculated, and the court disagreed with it. They say that the car wasn't working every day. It's not every day that they have people to transport, and therefore it cannot be calculated in that way. So it can be calculated over 30 months of loss of earning. 30 months, and therefore, because a car can work for 24 days, 50 million a day, and therefore that's what it should be. But the accused said, or rather the claimant said that it's not true. A car does not work only 24 days a month. It's not possible. In fact, that is not the case at all. So he was asking for 79,200,000, so 79,200,000. Plus other compensations. I was asking for 164,700,000, and he said that he didn't agree with this because in fact they should have compensated him for 52 million and should also be counted over 30 days, because you cannot say that a transport car only works for 24 days. It's not possible. So, and he said he was asking for compensation, including 1.2 million, which is a lump sum as regards the expenses connected with the following the case, and the company therefore have also asked for compensation. It was a coaster bus or minibus, and it was also burnt in the Nyungwe forest. The price is 52 million plus 2 million compensation plus 1 million for quoting.
Hagarijwe ibimenyetso bigizwe n'ibyangombwa by'iyo modoka, inyemezabwishyu yaguriweho yo kuwa 9 Mutarama.
That invoice from 2015 and a report by the local leaders attesting to the fact that some public transport vehicles, buses, were burnt. Alpha Express provided some evidence. Its coaster bus was burnt down in Nyungwe Forest on 15 December 2018. And that company is claiming for compensation because of the loss of their bus, and also for the court fees. That bus was 4 years old, and it should be compensated for 40 million francs. And for loss of income, given that the bus was expected to last 16 years more, then it was decided that compensation would be given for the value of the bus and 30 months of operation. And based on the fact that the court finds that a bus operates 24 days a month with 50,000 francs a day, was going to be compensated for about $30 million and 500,000 for court fees. Alpha Express was going to be paid 80 million francs. Attorney Faustin does not agree with the court because that bus's value increases as it operates, and also based on devaluation of the currency. So they should not take into account when the bus was made. If you wanted to buy that bus, like Omega bought a similar bus for 51 million, and then later on it was at 57 million. And loss of income should be counted on the basis of 30 days a month. So he's requesting for 1 million in court fees since Nyanza, and Alpha Express could not have lost only 500,000 francs as the court claims. Well, the court asked them what his company did to get paid by the insurance companies. Attorney Faustin says they did their best, but didn't work out because of their insurance principles. So they decided to go to a guarantee fund. It didn't work out either. And for those claiming compensation for the attacks in Kamembe and Nyakare Nzo district, attorneys Munyamahoro and Mukashema say that there were 2 attacks in Kamembe, in Stella Bar and in Nyakare Nzo at the factory, and vehicles were burned down. And 4 of their clients appealed for more compensation, namely for the Kamembe attack. Those include Jean Pumsen, Felix, and Paulin. Mahoro Jean Damascene appealed for what he was given following the factory attack in Nyakarenzo sector. Attorney Munyamahoro and Mukashema say that Munyamahoro wanted $30 million because of the handicap that ensued from that attack with 60% incapacity. The court decided to give him 3 million francs. He appealed because he found that the amount was too little. Rutaisire Felix, Attorney Munyamahoro and Mukashema representing him, say that he wanted 5 million francs because of his incapacity. But the court decided he deserved 4 million francs. They appealed to get more compensation. And Sabimana Joseph, with his attorneys, they say he was injured during those attacks and he wanted 9 million francs and 6 million for the 80% incapacity. So he was going to be given 3 million francs. So they are requesting the court to re-examine the case and give him more compensation. And Zeimana Paulin and his lawyers, they say he was injured during that attack when grenade fragments landed on different parts of his body. He had requested for 5 million, but the court decided 2 million. So they want more compensation based on medical reports. Mahoro Jean Damascene, represented by Attorney Munyamahoro and Mukashema, He said he's the owner of the Daihatsu Dina, plate number RAC 943C, burnt down at the factory attack in Nyakarenzo sector. The court decided he deserved 4.5 million, but he says the vehicle itself had cost 11 million used to transport goods to the Congo, and each trip would bring in 30,000 francs, and he was operating on a bank loan, and now he has been he's bankrupt now, he says, so the court needs to re-examine the compensation. His lawyers say that in addition to compensation for his vehicle, he had claimed for 29 million for the loss of income that he was going to get from that transport business to the Congo and other locations. He had also requested 10 million, but the court had decided 5 million altogether. But they did not give him any compensation for the income that would be generated by the transport business because he did not provide evidence of that kind of business he used to do. He said all the vehicle's documents were burnt down during the attack, but he said his driver could testify, and if necessary, the court could bring them in for testimony. He says the local leaders knew he owned that car, and the prosecution knew that during the Nyakarenzo attack, a Dina pickup truck was burnt, and the fact that it was a pickup truck, it was used for business, and he had been operating that truck since 1 year and making about 60,000 francs a day. So he was going to make 29 million. He wants the court to re-examine the compensation issue. Those who appealed for compensation because they didn't get any at all, there are about 51 at the primary level who claim that they gave evidence, including local leaders' reports, medical reports, witnesses, and different types of evidence in the prosecution's files. But the court says they did not deserve any compensation because there was no evidence. Those include Viateur, Venuste, Marceline, Melanie, Godelive, Ruhigisha, Munyentwari, Gayabosha, Nsabimana, Sebagema, Barayandema, Nyiragema, Nsaguye, Ndikumana, Calixte, Theophile, Kangawe, Calixte, Vestine, Nyiramana, and Habyarimana, Daniel, Gashumba, Samuel, Theogene, Gashongore, Nzabirinda, Nzayisenga, Baragamba, Enos, Innocent, Pascal, Emmanuel, Nzajibwami, Monsiera, Habakurama, Emmanuel, Ngaberura, Kanyandekwe, Verediana, Patrice, Emmanuel, Claudine, and Gakwaya Gerard. Those claiming compensation in these categories say that they suffered different damages from FLN attacks in Nyabimata and Nyungwe, Kitabi location, and Rusizi, Nyakarenzo, and Kamembe, and others who suffered different consequences from those attacks. those who appealed for having received no compensation in Nyabimata. Attorneys Munyamahoro and Mukashema say their clients were affected by the attacks in Nyabimata, but the court did not decide to give them any testimonies. Those include the following: Marceline, Godelive, Emmanuel, Cassien, Jean-Marie, Simon, Josephine, Dative, Viateur, Calixte, Kangabe, Vestine, and Damasen. Overall, their lawyers say that what they have in common is that the court decided to not award them any compensation for lack of evidence, and also in Nyabimata, local leaders that do not mention their names. They urge the court to re-examine Nyabimata reports. And they also say that there are various witnesses who said that their property was looted, and that in Section 47 in this case, the court referred to some of those claiming compensation, including Damasen, who is among those whom the court said did not deserve compensation, even though there are reports and witnesses who say what happened. About Habimana Viateur, his lawyers say that he's among those who were in Joseph's bar, Joseph who was killed. He was beaten up, but there were no wounds that a medical report could have confirmed. It is also said that his clothes were torn and he lost his shoes, and he is claiming compensation up to 30,000 francs. He also says that he was traumatized, as it was attested by local leaders, and he wants 180,000 francs in compensation, and altogether it's 1,210,000, even though the court says there's no evidence for any of that. And they say because there was no evidence that he was beaten up or looted, and the court is urged to re-examine Nyabimata local leaders' report from June in 2018 and July 2018. Different witnesses spoke about those attacks. Habimana Viateur was among the witnesses who spoke about Habimana Joseph's death. And what happened was seen by different people, and that Viateur should be given compensation. About Venuste Ngirwonsanga, attorneys Munyamahoro and Mukashema say that he's among the people affected by the attack of 1st July 2018. He was in his home. A different property was looted, and he was forcefully ordered to carry it on his head all the way into Nyungwe forest. 70 kilos of wheat, 50,000 of beans, equivalent to 35,000 francs, 40 kilograms of corn, clothes, including sweaters, with the value of about 60,000 francs, boots, and 140,000, and he wanted 1,056,000 for that damage and prejudice. The whole amount would be 2,140,000 francs. But the court, based on a report from local leaders that does not mention him, says he does not deserve any compensation, but he's appealing so the court can re-examine that based on what is known in the local leader's report, that the local residents' crops were looted, and there are videos of testimonies. And those videos mention how people were attacked and their crops were looted. And they urged the court to read where the local leaders' report mentions that the local leaders were forcefully ordered to carry the loot to Nyungwe Forest. And that's according to the law that provides that the judge can base his judgment on what is known to find out what is not known. That Ngironsanga Venuste cannot prove that he had 70,000 kilograms of corn, so the court should base its judgment on what is known from people's testimonies and the local leaders' report about what was done in Nyabimata sector. They also explain that based on Article 74 on evidence, it's hard to find some evidence for various reasons, including time elapsed, the way these attacks were, they surprised everyone, the fact that it's hard to find invoices or other documents for some of the products in that area in Nyabimata. But there are things that are known, and those should guide the court to determine compensation for people like Ngironsanga Venuste, attorneys Munyamahoro and Mukashema. They urge the court, though Nyabimata local leaders' report does not clarify the amounts and figures, they should start from what is known to clarify what is not known, namely the details, the amounts that are mentioned by the owners, but based on evidence or the beginning of evidence to establish the truth about what was stolen from the people. So they should use testimony and videos that were recorded during those attacks, after the attacks, by testimonies. And they should also use Saimana Kalix, aka Sankara, who clarified a lot of things about their logistics, saying that their fighters could not go on fighting without looting the local residents' crops, so they could eat where they were based in the forests. Now, Marcelina and her lawyers, she says she lost her phone was stolen, and she was traumatized because she was forcefully made to walk a long distance, and he wants 2,054,000 francs for the phone and the prejudice. Her attorneys say that Nyabimata attack abducted her husband, who was on patrol. He was forcefully made to carry the loot, and he came back home 2 weeks later. And this traumatized the wife, and she wants 500,000 francs for that. She did not get any compensation because the court says she did not prove that her husband was abducted or that her property was stolen. About Godelive, her lawyer says that this is a 60-year-old lady. She was in her home, and people broke the door, and they started looting clothes and crops. She filed for compensation for that loss. a large piece of cloth, 9,000, a sweater, 3,500, a machete, 1,200 francs, 5 kilograms of beans, 3,000 francs, and 438,000 in compensation. So the whole amount would be 500,000. But there was no evidence, so it was not granted. There was a farmer who collaborated with RAB. He had a lot of crops in his on his property. He was told that armed people came and looted his crops, and he claimed for compensation as follows. Irish potatoes, about 5,000 kilograms for 2 million francs, 350,000 kilograms of beans, 245,000 francs, 250 kilograms of peas, 200,000 francs, 5 chickens for 25,000 francs, 500 kilograms of corn for 180,000 francs, clothes with a value of 40,000 francs. So he claimed for 7,690,000 francs. The court decided that Ruhigisha was not going to be granted that compensation because there was no evidence for that loot, and the local leader had not mentioned anything in the report. But he based his claim on the fact that those attackers were looting everywhere they went. He would like the appeals court to reconsider the local leader's report. It's a report that he did not mention on the primary level. But Munyenhwari Kassien, attorneys Munyamahoro and Mukashema, who represent him, said that the attackers arrived at 9 p.m., broke in his house, took 10,000 francs, and looted property, then ordered him to get out and to carry the loot for them. He filed for compensation as follows. The damage, a sweater, 5,000 francs, 2 large pieces of cloth, 20 kilograms of peas, which is equivalent to 30,000 francs, 30 kilograms of beans, which is 18,000 francs, and the whole amount would be 571,000 francs. The court did not grant this because there was no evidence, and the local leader did not mention anything about him being one of those who were affected by these attacks.
Jean-Marie Vianney, Maître Munyamahoro, Maître
Jean-Marie Vianney, it is said that he was a Dassault and he was on patrol, and the attackers came and found him and tied him up and asked him where the executive secretary and the local bank's manager were. They took his 2 funds, and when they took everything, they forcefully ordered him to carry the loot, but they kept abusing him because they knew he was the head of security in the sector. They released him about 4 a.m. It is also said that For that, he claimed compensation for the two phones for 113,000 francs, 28,000 that was taken from him, and 500,000. The whole amount is 641,000. The court did not grant that because it said there was no evidence of it. And the report by the local leader did not mention anything about what he claims. Simon Straton and his lawyers, they say he had a beer business and he lived in that same shop in the bar. So the attackers came and drank the beer and took some away. He managed to get away and he left his wife and the kids. They shot in the wall, but to scare him so he could come back, but he did not, and nobody was injured. He then claimed compensation as follows. Mitsik beer, which is 22,000 francs, 2 crates of Primus, which is 16,000, 1 crate of Turbo beer, 16,000, 5 crates, which is 5,000, Technophone, 50,000, and all the full amount is 1,149,000. The court did not grant that. And Sebagima Simon, attorneys Munyamahoro and Mukashima, who represent him, say he was a business person with TIN number 1046667, and when the attackers came, they looted his property and took his money. This resulted into loss because he was working on a loan from a local Sacco bank. He claims compensation as follows: 110,000 francs stolen, wheat flour, 100 kilograms of wheat flours, which is 80,000 francs, a box of 12 boxes of Packmeyer, which is 21,600 francs, 50 kilograms of sugar, which is 45,000, 50 kilograms of rice, which is 35,000, bread, 15,000, 12 sweaters, which is 18,000 francs, 1 box of cookies, 1,200 francs, 12 underwear, 9,600, corn flour, 12,000, 1 phone, 12,000 francs. He also says that he sold a piece of land to pay back the local bank's loan, 300,000 francs, and transport fees, 45,000. So the whole amount, 3,150,000 francs. But the court decided to not give him any compensation because he did not provide any evidence. And the local leader's report did not mention anything about that or mention him as one affected by those attacks. So he wants them to he wants the court to base its judgment on a report by the tax collection agency, so they know what kind of taxes he used to pay, even though it does not clarify the amount of property that was stolen. He wants the court to correct the mistake when it said that he used to make business using Sacco loan which is contrary to what he was saying. He's claiming compensation for his personal property that was stolen.
inzu yacururizagamo ku gasantere.
He was a trader at the center, and on the 19th of June 2018, when attackers came at night, they called him, telling him that they burned the car belonging to the executive secretary. He got out to see what happened and to check whether nothing was stolen. So he met the attackers and he hid them. He was hearing the bullets fly, and they were breaking into houses. After the departure of those attackers, he went to see what happened and found that his shop had been looted. He had applied for compensation as follows: 15,000 cooked mandazi, valued at 6,000, 300 kilos of sugar, value 300,000, 500 kilos of rice, flour, wheat flour, in value of 350,000, 50 kilos of small fish, 100 kilos of groundnuts, 40 pairs of boots, milk, powder milk, valued at 42,000, clothes, trousers and shirts, kitenge clothes, 540,000, shirts for children, 775,000, underwear for men, 80,000, metallic dough, 70,000, and a field of potatoes that was worth 350,000. They say that the court considered that he did not, he was not entitled to compensation because he had no evidence of the damaged and the stolen property, and the executive secretary did not include him in the victims. He says that the court did not consider his losses and requests the court to examine Annex 118, showing that he was paying taxes, and grant him the compensation that he had requested.
ndabona abantu batangiye gusa n'abarushye birashoboka.
I see that everyone is tired. Maybe we need a short break. We could grant 5 minutes. We are about to conclude. Sorry for that.
abadahari nuko bakiri hanze cyangwa
those absent in the courtroom are still outside, or they will not come back? Could someone tell them to come back quickly so that we may resume?
Maître Shani gerageza kugira vuba bagaruke.
Madam Shani, please tell them to come back quickly.
Iminota twahaye abantu yarangiye tugiye.
We had granted 5 minutes. We have largely gone beyond. Let us start. Others will find us. After the arguments of the applicants for damages, the accused have also defended themselves. They said that the applicants were saying they were not granted compensation or reduced compensation. In view of the above, namely that some damages, application for damages should not be admitted, and that for some the accused should not be held responsible because they did not take part in the attacks. The accused hold that the applicants did not adduce evidence. Musaimana Jean Damascene Mutakamba consider who admit having taken part in the attacks in the Rusizi as well as Mukandute Chirina, add the following explanation to the above mentioned defense. Matakambaja Berkmans holds that about the victims who paid legally their court fees and who showed evidence of the damages, that those should be paid. But he says that, for instance, Mahoro Damascene, someone who was his neighbor, who knows that this vehicle that says, he says was burnt, is still running on the road, and that this vehicle was bought in Gitarama for 6,500,000, but he never showed pictures of other vehicles that were really shown as burnt, and only the back part was burnt, and this vehicle, as evidence, as is known, is transporting flour to Congo. Now, Matakamba also mentioned that the grenade that was launched in Kamembe that wounded 6 women, and that the same grenade caused damages to property, he says this is not possible because this property has a 3-meter perimeter fence, and that it's above the road, and that this is not impossible. He also says that the attack that was carried in Rusizi caused no damage because their leaders had ordered them to do that. He says they met a truck that was loaded, but they took nothing. Therefore, looting and stealing were not done, as the applicants say. Bizimana Kassien says he cannot deny the attacks in Rusizi because he was guiding them, commanding them, but he says that he was following the orders of FLN as he was receiving them. He mentioned the vehicle that was burnt containing uniforms, police and military uniforms, and he says that he broke the windshield and poured petrol on them and the vehicle and burnt it. And he says that he was following the orders and he could not be held responsible for attacks that took place in other places. And he says that he started working with Matakamba, and he says that Matakamba gave him a grenade to give it to Claude, and he says Claude knows what to do with it. And this is the grenade that was used in the town of Kamembe. He asked the court to check whether really the evidence adduced by the applicants for damages are true, because the doctor issued a report in which he mentioned the people who were wounded by this grenade, but this grenade was used in February 2019. He says that he should not be accused of acts that were committed before he started working for Matakamba. Mukanduti says that what happened was really sad, but that the applicants should be compensated. But she says on her part that she owns nothing anymore, and that those who have property and who have the means should pay for those damages. The court considers that regarding those who claim that their compensation was little, considering that they wish their compensation to be increased, the court will examine the criticism that these express, so that this court may re-examine the reasoning of the court in first instance. The applicants state that they had already adduced evidence and that they are now submitting other evidence to the appeals level. They say that according to laws governing the procedure for civil, commercial, and other matters, they said that the court should consider that, as seen in article on page 213, that the court of first instance did examine this because some people were killed, others were injured, others were kidnapped, and damage was damage. There are evidence that these damages are proven, and also taking into account that the law on civil case procedures and commercial procedure, the applicants should show where the court erred, and it should be understood that if really evidence existed but the compensation was not given, or whether the evidence is now available and it was not in the past, that the compensation should be given. But if there is no evidence, the compensation will not be given based on Article 12 of the law on civil and procedure for civil and commercial cases, where it said that every party should adduce evidence to their claims. Concerning those who claim that the claimed evidence linked to what happened in Nyabimata, in Nyaruguru, concerning Havgiman Jean-Marie Vianney, the court finds that the chamber found that it could not compensate for his stolen money and moral prejudice because he was kidnapped, but it granted him compensation based on the value of its motorcycle, based on the photos and the report of the executive secretary of Nyabimata, granting him 600,000 because he had not adduced any other evidence that the motorcycle was worth more than that. The Court of Appeal, before the Court of Appeal, the victim and his lawyers are asking for 1,200,000, and Havgimana Jean-Marie Vianney continues to ask for 1,100,000 plus, and he only received 600,000, and all the other damages were not paid because there was lack of evidence. The Court of Appeal finds that it could find no justification for granting any additional damages, compensation, but that he deserves the moral compensation for moral prejudice, because the acts of terrorism, a crime itself by its nature, can cause such damages because it's aimed at intimidating and scaring and causing damage to the person, the victim, and the population generally. Therefore, Jean-Marie Vianney and Havgimana should receive 300,000 more on top of what he had been granted in the appeal judgment. On page 600, the Special Court for International and Transborder crimes had found no evidence that his money was taken and that his motorcycle was burnt, because he had adduced no evidence as to how much he was making every day or was going to make in the future. Instead, he was granted the value of that motorcycle because you're asking for more money based on the photos and the value and the report of the executive secretary. In its discretion, the court had granted him 600,000 because he had adduced no additional evidence as to the value, real value of the said motorbike when it was burnt. The Procureur Venust and his lawyers are asking for 5,144,000 that he had applied for in the first instance, because this amount contained the value of the damages and more compensation for reasons of the moral prejudice. He had shown the report for what was damaged. The Court of Appeal considers that there is no problem as the value of the motorbike, but the problem is that he was not granted any compensation for moral prejudice. The court, as said above, considers that Babakorera Venus also deserves compensation for moral prejudice because of the proven crime because of the motorbike. This is based on the nature of the crime of terrorism, because the crime by itself or in its nature is, without having to prove it, is aimed at intimidating, causing insecurity and hurting the victim and the public in general who live in the place where the crime is committed. Therefore, Babakorera Venus should be paid by the convicted persons 300,000 on top of the compensation that had been granted by the judgment, the appeal judgment. The court of first instance found that he deserved 300,000 because he was kidnapped and was made to carry the looted property based on the report of the executive secretary of the area. But he was not granted any compensation for the stolen property because he did not adduce any evidence to that effect. He asked that the court grant him 1,600,000 that he had requested at the first instance, including 660,000 for the value of his property, the telephone, trousers, bins, and the telephone. He adduced that they are not taking into account the fact that the attackers stole and looted. Jean-Marie Vianney did not agree with the compensation that was granted, and he's still asking for 1 million and above based on the court considers that it could not change the amount that was granted in the first instance. All the court can say is that he is asking for 560,000 for the value of his property, trousers, kitenge clothes, bins, and the telephone. He did not bring any additional evidence, or he never did that in first instance. Therefore, the court considers that the 300 should be maintained. 300,000. Concerning Habimana Anastas, the court finds that the court of first instance considered the report of the executive secretary of Nyabimata, whereby it's shown that he was kidnapped and taken to the for Nyungwe forest, and 300,000 is granted to him because he was kidnapped and was made to carry stolen property. But his property that he claims that was stolen cannot be compensated because he did not adduce any evidence to that. Simon Anastas and his lawyers consider that he should be given 1,200,000, including 150,000 he had obtained by selling his cow that he gave to attackers so that they don't kill his wife, and the value of his property, including 1 million francs for damages for moral prejudice. The court considers that on appeal, the victim requests the same amount without showing what he criticizes about the determination of the court of first instance. The court finds no justification for increasing the damages, apart from saying that application concerning his property can not be granted for lack of evidence, both on appeal and on the first instance. The Court of Appeal has also no justification to modify the 300,000 that had been granted before. Sibo Rurema Venist, the court finds that in first instance, the court found that Sibo Rurema Venist is also one of the people who were kidnapped and taken to Nyungwe Forest carrying the loot, and that he had also obtained 300,000 compensation as a compensation for moral prejudice, but that he should not be compensated for his property that is claimed to have been taken, including foodstuffs, a telephone, clothes, and other things, because he did not prove that. Sibo Rurema Venist is asking on appeal that he should obtain 570,000 that comprises 70,000 as value of the property that was stolen, and 500,000 for moral prejudice. The court considers that Sibo Rurema Venist proves that, mentioned that he disagrees with the compensation granted to him, and that he is asking for 500,000 plus, as he has done on the trial at first instance, without providing any proof. The Court of Appeal has no justification to modify that compensation. All it can say is that he had applied for that amount as the value of his properties, including milk, telephones, and clothes, and that there is no new evidence on appeal different from what he could have provided at first instance. Therefore, the court has no justification to modify the amount of 300,000 that he had obtained as a compensation for moral prejudice. The court of first instance also shows that the Hindakumana David is one of the inhabitants who were taken to Nyungwe Forest. Based on that report, he was granted 300,000 francs for moral prejudice, but did not grant any compensation for other stolen property. On appeal, Ngendakumana and his lawyers apply for 540,000 that he had also applied for during the trial at first instance, including properties that were stolen, 500,000 as compensation for moral prejudice. And they consider that the court of first instance did not consider the value of his stolen damaged property. The court registers notes that he did not agree with the compensation granted to him, and his asking for 500,000 as he has done during the court trial in first instance, but does not prove that the court erred. The Court of Appeal also considers that it has no justification for increasing that amount. And apart from acknowledging the application for that amount, it cannot grant any higher amount than that, because he does not produce any evidence beyond what he could have done in first instance. The court considers that the 300,000 that he obtained should be maintained. Shumbusho Jean Damascene. On page 216, the report was of the Executive Secretary of Nyabimata was considered, and he is shown to be one of the members of the population that were kidnapped and taken to the Nyungwe forest, and the court granted him 300,000 as compensation for moral prejudice, but did not grant any compensation from the property, clothes, telephone, and food stuff, because he did not adduce any evidence to that effect. He applies for 654,000, and this includes 60,000 for moral damages, and the rest of the money is for 4,000 francs that was taken from him and other property that was stolen from him. The Court of Appeal considers that on appeal, he approves that he does not agree with the 300,000 he was granted, and he applies for 600,000 as he had done before, but adduces no evidence. The Court of Appeal has no grounds to increase the granted amount. This application is also not founded, and the Court of Appeal maintains the 300,000 that he was granted. Regarding Nyange and Nabaresha Dative, the court finds that the appeal judgment did not find any evidence that property was stolen, where their son Habarurema was carrying out his trade, and the court found that there was no evidence to grant any compensation to that effect. And the court considered that Habiman Joseph was killed during the attack of the 16th of June 2018, and there is a death certificate dated 6th of 11th of November, considers that since the applicants are proven to be their parents, that these compensation to be granted, and 5 million for Genyange Dominic and 5 million for Nabarisha Dative were granted. On appeal, Nugerinyange and Habarisha apply that 16 million should be granted, comprising 10 million for moral damages and 7 million for damaged property, and this is the same amount that was applied for at first instance. The applicants state that the court of first instance did not take into account the looting of the boutiques. The court considers that this application is the same amount as what was applied for at first instance, because they're applying for 10 million and each one was granted 5 million. The Court of Appeal considers that there is no need to re-examine the issue of moral prejudice. And apart from noting that the applicants are asking for 7 million for the property stolen in the boutique of their son, they are not adducing any additional evidence at this level or at the level of first instance. Therefore, that compensation is not founded. The amount for moral prejudice will be granted as it was decided by the previous judgment. For Ingabire Marie Chantal, the court finds that the report of the Executive Secretary of Nyabimata shows that Manira Anatole, who was her husband, was killed during the attack that was launched there on the 16th of June 1918. And the court granted her 10 million for moral damages because her husband was killed and she was left with children that she has to educate alone. But the court considered that there was no lost income because she did not prove that her husband was bringing any income. Marie Chantal Ingabire and her lawyers claim that they had proven the amount that the family was making, but that there was no proof of the salary, but that now she has adduced the evidence which was admitted into evidence as exhibit number 111, showing that he was making a net of 111,000. They also say that 10 million alone was not enough, taking into account what she had lost during the burial process, because she did not prove that. And they add that the court did not ask for any details of those expenses, but they had asked for a lump sum because especially they did not have any receipts for those expenses. They are therefore requesting the court to increase the moral damages, including those that take into account the suffering during the loss and the expenses for the funeral. The court considers that these applications amount to 30 million. The moral damages to the tune of 70 million because the husband was left her with children that she will bring up on her own. The court finds that it's not that the applicants did not separate the funeral expenses from the other moral damages, and consider that the court was in no position to determine that amount, and that it should be admitted that the lump sum of 10 million comprised the expenses for funerals and also the moral damages, which does not include Marie Chantal's, did not include only Marie Chantal as the widow, but also the moral prejudice to the children who were left as orphans. The Court of Appeal considers that the lost damage, the lost income that the husband could have brought, the court did not grant anything because no evidence was adduced. Now that there is a new exhibit, number 111, the court should take that document into account because he received a gross of 207, but his net was 130 and 650. Therefore, these should not constitute a basis to determine that would be his salary until he dies if he were not killed by the FLN attack. The court considers that this is a proof that the bereaved was really bringing salary, means of subsistence of his family, and this could constitute a basis to guide the court in determining the adequate compensation. The court, in its discretion, considers that the loss damages that are adequate are an amount of 15,678,000 that are computed on the basis of the salary of the bereaved, of the departed, and over a period of 10 years as determined by the court in its discretion, because the lump sum of 70 million is excessively high and does not show the any relation to the salary that was proven. The court finds that it has no other basis to go beyond the 10 million that was determined, because she also thinks that this amount very low. The Court of Appeal considers that Ingabire Marie Chantal should not obtain any additional compensation except 15 million that plus that would come as an addition to those granted in the first instance, and the total will be 25,678,000. Concerning Mukasheka Josephine, the court finds that on page 297, the Court of First Instance based its judgment on the report of the Executive Secretary of Nyabimata, showing that her husband was killed during the attack that was launched there on the 19th of June 2018, and that the court had granted her 10 million for damages, moral damages, because she was left alone and she had 2 children to bring up. But the court had considered that she was not entitled to damages for lost income, because nothing proved that her husband was making 100,000 per month in order to use that as a reference to prove that he really made that amount.
In this appeals case, Mukasheka and counsel do not like the fact that the court decided 10 million compensation and nothing in terms of loss of income, because there was no evidence produced. They also don't like the fact that there was no loss of income to be compensated, but later on they came to get a piece of evidence that the deceased used to make 200,000 francs a month. So they'd like the court to consider that and give them 100 million francs as compensation. This court finds that 10 million francs that Mukasheka that was decided for her by the primary court cannot be changed, because there's nothing that they explain in terms of any mistake by the primary court. This court finds that the loss of income that Munyaneza Fidele would have brought home if he had remained alive, the court did not decide on it because there was no evidence presented. But her family wants the court to consider the piece of evidence produced and give Mukasheka Josephine the compensation she is seeking. The deceased used to bring home 186,000 francs a month, and that could not be a basis to say that that was going to be his permanent salary if he were not to be killed during that FLN attack. This is rather a sign that the deceased used to make some money. And this will guide the court in determining the right amount in terms of compensation. So the court finds that the right compensation in terms of loss of income is 10,146,000 francs. Based on 186,000 francs, the salary that the deceased used to bring home, and multiply that by 10 years. This court has no other basis to change the 10 million francs of compensation, because Mukashyaka does not prove that the court was wrong in determining that. This court overall finds that Mukashyaka Josephine does not deserve any more compensation rather than loss of income amounting to 10 million francs, as explained above, in addition to what was mentioned before. So altogether, 20,346,640 francs. Now, Saint-Yumva Vincent, from 579 to 583, from page 225 in this appeals case, the court has explained the reason why he deserves compensation amounting to 21 million francs, including 15 million for the car that was burned down instead of 7 million, 6 million francs for the fact that he was shot, and 21,600,000 equivalent to rent from that car that was burned down, and 500,000 in court fees. The court finds that the primary court had explained that Saint-Yumva Vincent did not deserve the $30 million for his furniture that was burned down. 1,500,000 that he paid in medical fees, and 4 million for food while he was in hospital, because he did not present any evidence. As per Article 12 about civil and commercial proceedings and administrative proceedings, Saint-Yumva Vincent and counsel say that his evidence, he also mentioned the witnesses who were on the scene, and those could be used by the court even though they could not be available sooner because of the nature of the attack and the situation that prevailed. They say that the court analyzed the evidence and found that he was injured during the attack, and he sought medical care at King Faisal Hospital and Butare University Hospital, but that he did not get 1.5 million francs in medical fees and food when he was in the hospital, because there was no evidence and nothing explains how much time he spent in the hospital. He says the court has contradicted itself, because it had said that it was satisfied with evidence about the value of the vehicle, but it approximated when it came to the compensation. The 500,000 in court fees is not enough, because he made many trips from Nyanza and to Kigali before the court moved to Kigali. So he spent a lot of money because he lost his car. He had been specific that he needed his car on a daily basis. But if you rent a car on a daily basis, you pay between 15,000 and 20,000 francs, which is the basis of his calculation. And about furniture that was burnt down, and the court says it was not mentioned in the Nyabimata local sector administrative report, that furniture was burnt down. The report mentions the equipment that was burnt down as well. Overall, the court finds that Nsengiyumva Vincent says he deserved 21 million francs, and this should be reviewed based on evidence that was presented and other evidence that was presented during the appeal. And this court finds that the 30 million francs, which is equivalent to the furniture that was burnt down, and that was compensation was denied by the primary court. Even at this stage, the appeal, he's not entitled to that because he did not produce the required evidence. And the 1.5 million francs that Nsengiyumva claims to have spent on medical fees, and that the primary court did not award him because of lack of evidence, because the only evidence is invoices of about 2,000 francs and 77,000 in Exhibit 98, and another invoice of 11,000, Exhibit 079. The medical fees, in terms of compensation, is around 90,000 francs that he is entitled to based on Article 154 of Law 22/2018 about civil, commercial, and administrative proceedings. He's asking for 1.5 million, though there's no evidence. The 4 million francs that he claims were for food while he was at the hospital, the court finds that there's no grounds for that because there was no evidence. And about the burnt down vehicle that was decided by the court, even though Nsengiyumva Vincent wants more, this court finds that he does not base his claim on the real value from when he bought the vehicle. And he should look at the price, today's price for the same type of vehicle. He is considering today's price, not the price when the car was burnt down. So there's no evidence he gives for the primary court's decision to be changed. This court finds that the 6 million decided by the primary court, that was for moral prejudice because he was shot and injured and was deprived of his vehicle that was burnt down. But Nsengiyumva Vincent had separated that type of compensation and has requested for 20 million francs and a rental car fee for 21 million, which is 20,000 francs every day, starting from 19 June 2018 when his own car was burnt down until the verdict day. This court finds that the primary court was wrong in combining those types of compensation with the loss of his car, because those are different types of compensation in nature. And with moral prejudice, is awarded at the discretion of the court, because in most cases there is no clear-cut measurement, because it's based on people's feelings. The economic damage can be measurable, because when you lose your vehicle, then you find an alternative, and that is valued has monetary value. So this court finds that, like it has done for others, because of how they were affected by these terrorist attacks, at its own discretion, gives them 300,000 francs. And Saint-Guillaume Vincent was entitled to specific compensation based on the fact that he was deeply affected, and physically he survived those gunshots that were meant to end his life. So he is entitled to 5 million francs. And for having been deprived of his vehicle and his daily activities, the court understands he needs to continue. He needed to continue his trips. So this court finds that there is no evidence supporting the 21 million that he was claiming, based on 20,000 francs per day. Therefore, the court decides that he deserves 5,000 francs a day, starting from 19 June 2018, when the vehicle was burned down, until 4th April 2022, which is 1,369 days times 5,000 francs, which is 6,845,000 francs. And the 500,000 in court fees, then Saint-Guillaume Vincent says, is too little for his trips to Nyanza and to Kigali. He wants this to be 1 million francs. This court confirms what was decided by the previous court, because there's nothing that supports his claim that he spent more than that. He does not prove the court wrong in any way on that decision. So at the appeals level, this court does not have any grounds to change the previous court's decision. So overall, Saint-Guillaume is entitled to the same compensation for the vehicle, which is 15 million, and the court fees 500,000, and medical fees, well, with the right evidence, is 90,620 francs. Being deprived of the right to use his vehicle, 6,845,000 francs. Moral prejudice, 5,000. So the whole amount is 27,435,620 francs. For those were applying for compensation for the Nyungwe attacks, Wambaje Françoise, the court finds that on page 26 in this appeals case, the previous court found that the medical report from Butare Hospital shows that Habyarimana Dominique died on 16 December 2018, and the autopsy shows that he had injuries, bullet injuries. So his wife is entitled to 10 million francs for that moral prejudice with the loss of her husband. But she is not entitled to any loss of income because she did not produce any evidence. Wambaji Francoise and counsel say that based on Article 154 of Law 122 of 2018, there are other evidence that they produced saying that her husband was an entrepreneur who worked with the district. It's an evidence produced by Gashonga sector where he used to work, and there are photos, exhibit 106 and 107, showing his tomb and the invoice for the funeral service. But she also says she could not find other invoices, including water and transport and refreshments. She could not find those because of her current situation. And she had applied for compensation, and that was not granted. But the court should consider that her husband was still able to work, and they could approximate the number of years he could still be active, and the court would grant her more compensation. And about the 10 million she was granted, and that she does not accept and wants the court to increase that up to $50 million. This court, Francoise does not like the fact that the court granted her 10 million francs and would like to have 50 million, while she overall wanted to have 100 million francs with every form of compensation together. But she does not explain where the previous court was wrong in determining the amount. So this court has no grounds to change the amount of compensation she was granted. So the 10 million is confirmed. The loss of income, because late Habyarimana was very active and he could bring some money home. The court finds that Francoise and counsel do not produce any evidence. Exhibit 104 does not help this court to approximate the amount of that income. So the court is based on evidence from the Gashonga sector executive secretary, who says that Habyarimana Dominique, an entrepreneur who supplies construction material for the construction of schools, was a professional entrepreneur who collaborated with the sector at GS Morehe Gashonga Catholic since 2017 to 2018. So loss of income that Francoise is claiming will not be granted because the piece of evidence she produces does not support it. The fees incurred for funeral services, as she says, the court finds that Francoise deserves 250,000 that was spent on the coffin, as the invoice proves. Exhibit 264 in the dossier, and 200,000 for the vehicle that transported the body. And based on and now about the photos of the tomb, the court finds that they are not the basis for any more compensation. So at this level, at this appeals level, she's entitled to 450,000 francs because of the evidence she was able to produce, in addition to 10,000 that the previous court had decided. Ngirabyeyi Desire, in paragraph 611, the previous court found no evidence that proves his incapacity that justifies 66 million that he was claiming, saying he had been incapacitated. There's no medical report that proves that he deserves that 50 million. So the court finds that he sought medical attention for the left leg following grenade fragments, and also a long walk in Nyungwe forest after his vehicle had been burned. The court grants him 2 million in moral prejudice and 500,000 in court fees. In this appeals case, Ngirababyeyi and counsel say that based on a medical report from Kibagabaga Hospital, which is in the file, it shows that Ngirababyeyi has 22% of incapacity. And it also mentioned 250,000, which was his monthly salary, and he had been granted 2 million for the pain he had following the injuries. His compensation was solely for the pain, but the law provides for compensation for the injuries in an accident, including pain. This court finds that Ngirababyeyi does not prove how the previous court was wrong in determining the 2 million. But he calls those 2 million, that was overall compensation, he calls it for pay, compensation for pain. He wants this court to increase that amount and to be given loss of income, though he is not specific. As he asked the court to base its judgment on his salary, 250,000, though he does not produce any evidence for that. And he does not, this court finds that the 2 million that the previous court granted Ngirababyeyi Desire was explained in paragraph 611 that it was from a moral prejudice due to the injuries and the long nightly walk in Nyungwe forest. So when he says it's for just pain, it's baseless. And about other forms of compensation, because he no longer works, when he used to make 250,000 francs a month, the medical report says that his injury on the left foot is 22%, but this is temporary because he's still undergoing treatment. So he does not prove how the compensation he claims is proportional to that level or those details he's providing. And this court finds that there is no grounds to change this compensation of 2 million in addition to the 2 million and the 500,000 francs. Rudahunga Ladislas and his children, the court finds that the previous court finds that based on evidence produced by Rudahunga gave, he is entitled to 5 million francs and Mutesi Jacqueline's siblings should get 2 million each. The previous court had found that Rudahunga should be given back 2,190,000 that was used during the funeral service as confirmed by the invoices, in addition to 500,000 in court fees. Rudahunga Ladislas and his children and their counsel, they're requesting this court to re-examine the compensation granted because they did not accept the amount given, because what they had requested was reasonable. This court finds that in this appeal, Rudahunga Ladislas and his children they explain that they don't like the amount granted in compensation, but they do not clarify where the court was wrong in determining that amount. So this court has no grounds based on which they can change that compensation, that amount. Bonigawa Richard, Mukeshimana Diane, Isaac, Alphonsine, Liliane, Adeline, Jean-Marie Vianney, Murengera Ntwari, Denis, Alexis, Nyiragabire, and Deo. The court finds that in paragraph 617, page 226, the previous court, based on a report from December 2018 by Kigeme Hospital, that says that Mukawajima died following gunshots, and the children, Uzayisenga Liliane, Adeline, represented by Mbonigawa Richard, that they deserve compensation, moral prejudice, because of their parent who was shot during the Nyunga forest, with 5 million francs for each. And Mbonigawa Richard, Donat, Denis, Alexis, Valérie Deo, and each would get 2 million. The previous court says that they cannot get compensation for what they said that they've used or what the deceased could have made in terms of income. In this appeals case, Adeline Habakubaho, Jean-Marie Vianney, Donat, Denis, Alexis, Valérie, and their counsel, they request the court to re-examine the compensation that they got, or if it can be increased. The court finds that Richard, Diane, Isaac, Liliane, Adeline, Jean-Marie Vianney, Donat, Alexis, Valérie, and Deo, they say they did not accept the compensation by the previous court. They're still requesting for the same kind of amount, but they do not show where the court was wrong in determining that compensation. So this court has no basis on which they can change this amount. But Liliane, on page 617, the previous court says that she was entitled to 5 million francs in its own discretion because her child Niobo Hongiro was killed during the Nyungwe attack as per the medical report on 16 December 2018. But the court said that they cannot be compensated for what they lost because of that child, because she did not explain and there was no evidence. Nyirandibwami Marianne and counsel request the court to re-examine that case in its discretion because there's no law on how to count that compensation.
Nibwami Marianne did not agree with the compensation granted by the Court of First Instance, and she applies on appeal for the same amount without showing her the error of the court. Therefore, the Court of Appeal has no justification for changing that. The court finds that Liliane has presented the marriage certificate and medical certificate showing that her husband and his Yao Samuel was killed by the attackers in the Nyungwe forest, and she was granted 10 million in compensation because she lost her spouse and she is to bring up children alone, and it granted to her 500,000 in form of court fees, but the court found no ground to grant her 10 million in lost income, and the amount she claims was used for funerals. Liliane and her counsel, based on Article 54 of the law on civil, commercial, and administrative procedure, she provides evidence that was granted number 187. She will therefore obtain 250,000 that she used for the funeral and 1 million for court charges and 10 million of compensation for moral evidence. And she says that she can't prove evidence of her husband's income because he was in a informal sector. Therefore, she says she relies on the court to appreciate in its own authority, so that the compensation to be computed on the basis of the minimum salary. The court finds that Liliane shows that the 10 million that she was granted was not acceptable to her. Sorry, she does have no issue with the 10 million for moral prejudice. She only requests that the additional compensation should be re-examined, and the court finds no ground to do that. Concerning lost income, because Desiderio Samuel was gaining an income, but the former wife cannot prove it, the court finds that it has no basis for estimating. Whereas the expenses for the funeral based on Article 54 of the civil, commercial, and administrative procedure allows party to adduce new evidence. The court admits the Exhibit 071, but having examined it, although the submitter calls it the receipt for funeral, it's something else because it's a document that she wrote herself with her hands on the 24th of January 2022, using it to apply for compensation to the tune of 2,780,000. comprising the different expenses made during a funeral. 278,000 for the tools that her husband had on him when he was killed, and 1.2 million francs that he had when he was killed, because he had just received payment for timber that he had just sold. The court finds that this document emanating from the party cannot be considered, and therefore Nyirayumva Liliane, unable to provide any evidence for those expenses, cannot grant more money than what was granted on first instance. Concerning Karegesa Phineas, the court finds that in the appeal judgment, the Karegesa Phineas had adduced evidence of papers from the Kigeme hospital, where his child Nyanshuti, who died because of heat, constitutes evidence, and the father was granted 5 million in compensation and 500,000 for court fees. This child died of burning, and the 5 million were granted as moral prejudice for that loss, and the court estimated an amount of 500,000 for him, but the court considered that the money he says having spent for the funeral cannot be refunded. Karegesa Phineas and his counsel request the court to re-examine his application for all the compensation to the tune of 67 million, 63 million being compensation for moral evidence, plus the other amounts without showing in what he criticizes the determinations of the court of first instance.
Kiza kababaro Karegesa Phineas yagenewe ku rwego rwa mbere. Kuri Habimana Zerote, urukiko rusanga mu gika cya 312 ku rupapuro rwa 224 kugera ku rwa 225 rw'urubanza rwajuririwe. Urukiko rubanza rwarasanze ibimenyetso yatanze bitagaragaza ubumuga yagize butuma atabasha gukora akazi nk'uko byari bisanzwe, ku buryo urukiko rwamugenera miliyoni 68,400 abisabira, bikaba bitanagaragaza ko akeneye ubundi buvuzi busumbye ubwo yahawe, ku buryo urukiko rwamugenera miliyoni 50 asaba. Urukiko rwavuze ariko ko ikimenyetso yatanze kigaragaza ko yivuje ibikomere yatewe no gukomeretswa na grenade, bityo kubera gukubitwa, kwikorezwa imizigo n'abarwanyi bakamujyana mu ishyamba rya Nyungwe ku gahato, rumugenera mu bushishozi bwarwo indishyi z'akababaro zihwanye na miliyoni 2, kuko ngo ayasaba ari menshi, ndetse n'amafaranga 500,000 yikurikirana rubanza yose hamwe akaba miliyoni 2,500,000. Muri uru rubanza rw'ubujurire, Habimana Zerote n'abavoka bamuhagarariye basaba urukiko kongera rugasuzuma indishyi zari zasabwe ku rwego rubanza, rukamugenera izindi, ngo indishyi urukiko rwamugeneye zikaba ari nkeya. Uru rukiko rurasanga muri ubu bujurire Habimana Zerote yagaragaza ko yagaye indishyi z'akababaro zingana na miliyoni 2 ndetse n'amafaranga 500,000 yikurikirana rubanza yagenewe mu bushishozi bw'urukiko, agasaba izingana n'izo n'ubundi yasabaga ku rwego rwa mbere, ariko ntagaragaza icyo anenga mu bushishozi bw'urukiko rubanza bwakoreshejwe mu kuzimugenera. Uru rukiko rukawusanga ntaho rwahera rero ruhindura indishyi z'akababaro yagenewe ku rwego rwa mbere, cyane cyane ko n'ikimenyetso gishya cya raporo ya muganga cyatanzwe muri ubu bujurire ku mugereka wa 090 nta bumuga buhoraho buvugwa n'ababuranira Habimana Zerote kigaragaza nk'uko babivuga, kandi kikaba nta na hamwe gihuzwa n'inyongera y'indishyi bagitanze bagamije kugisabisha. Kuri niyo ntegereje Azera urukiko rurasanga mu gika cya 613 ku rupapuro rwa 225 rw'urubanza rwajuririwe, urukiko rubanza rwarasanze muri dosiye harimo icyemezo cya muganga kigaragaza ko kuwa 16 Ukuboza umwaka wa 2018 yasuzumwe n'umuganga wo ku bitaro bya Kigeme muri Nyamagabe nyuma y'uko bisabwe n'umugenzacyaha kuwa 16 Ukuboza 2018. Icyo cyemezo kikaba cyaragaragaje ko afite igisebe ku rutugu rw'ibumoso rw'iburyo. Urukiko rushingiye ku kuba niyo ntegereje Azere yarakomerekejwe n'abarwanyi ba FRN mu gitero cyagabwe mu ishyamba rya Nyungwe kuwa 15 Ukuboza 2018 rukaba rwaramugeneye amafaranga miliyoni 2 y'indishyi z'akababaro ngo kuko rwasanze ariyo akwiye aho kuba miliyoni 5,500 zirimo miliyoni 5 z'akababaro n'ibihumbi 500 z'ubumuga yasabaga. Urukiko rukaba rwaravuze ko atagenerwa indishyi zijyanye n'ubumuga kuko ngo raporo ya muganga itagaragaza ko hari ubumuga yatewe no gukomeretswa n'icyo gitero. Muri uru rubanza rw'ubujurire niyo ntegereje Azere n'abavoka bamuhagarariye bavuga ko yari yasabye indishyi zingana na miliyoni 5,500 ariko ko hari raporo ya muganga bashyize muri systeme ifite nimero 094 igaragaza ko agifite ubumuga cyane cyane bushingiye ku buranga. Bakaba basaba urukiko kongera rukabisuzuma kuko indishyi yahawe ari nkeya. Uru rukiko rurasanga ikimenyetso gishya cya raporo ya muganga kigaragara ku mugereka wa 094 muri dosiye ntacyo cyahindura ku byemejwe n'urukiko rubanza ko niyo ntegereje Azere nta ndishyi yahabwa zijyanye n'ubumuga yaba yaratewe no gukomeretswa n'igitero kuko uretse no kuba abamuhagarariye batagaragaza uko icyo kimenyetso gisobanura ingano y'indishyi z'ibihumbi 500 bagisabisha. Iyo raporo inagaragaza ko ubumuga buhoraho bukomoka kuri uko gukomereka ari ntabwo 0%. Uru rukiko rukaba rero ntaho rubona rwahera ruhindura indishyi z'akababaro zingana na miliyoni 2 urukiko rubanza rwageneye niyo ntegereje Azere. Kuri Kayitesaris urukiko rurasanga mu gika cya 614 ku rupapuro rwa 225 rw'urubanza rwajuririwe, urukiko rubanza ruvuga ko rwashingiye ku bimenyetso biri muri dosiye birimo icyemezo cya muganga kigaragaza ko kuwa 16 Ukuboza 2018 Kayitesaris yasuzumwe n'umuganga wo ku bitaro bya Kigeme muri Nyamagabe kikanagaragaza ko afite igisebe ku kuguru kw'iburyo rwasanze kuba yarakomerekejwe n'abarwanyi ba FRN mu gitero cyagabwe mu ishyamba rya Nyungwe kuwa 15 Ukuboza 2018 agomba kugenerwa indishyi z'akababaro zihwanye n'amafaranga miliyoni 2 ariko ko atagenerwa indishyi zijyanye no gutakaza uburanga kuko nta kimenyetso yatanze kigaragaza ikigero cy'uburanga yatakaje, akaba ataranagenewe amafaranga yo kwivuza kuko nayo nta kimenyetso yatangiye kimwe n'indishyi z'ibintu yavuze ko yatwawe n'icyo gitero kuko nabyo nta kimenyetso yabitangiye. Muri uru rubanza rw'ubujurire Kayitesaris n'abavoka bamuhagarariye bavuga ko hari raporo ya muganga bashyize muri dosiye igaragaza ko uyu munsi agifite ubumuga bungana na 20%, bityo ko aho yari yasabye indishyi zingana na miliyoni 50 ariko urukiko rukamugenera miliyoni 2, urukiko rwakongera rukabisuzuma ngo akaba yagenerwa indishyi zijyanye n'ubumuga yatewe n'igitero cyo muri Nyungwe. Uru rukiko rurasanga ikimenyetso gishya cya raporo ya muganga kigaragara ku mugereka wa 091 muri dosiye ntacyo cyahindura ku byemejwe n'urukiko rubanza ko Kayitesaris nta ndishyi yahabwa zijyanye n'ubumuga yaba yaratewe no gukomeretswa n'igitero kuko uretse no kuba igipimo cy'ubumuga bw'agateganyo temporary disability iyo raporo igaragaza cya 20% kitagaragaza ubumuga bwa burundu kuko umuganga wayikoze anatanga inama yo gutegereza hakazapimwa uko ubumuga bwa burundu buzaba buhagaze nyuma yo gusoza imirimo y'ubuvuzi agomba gukorerwa. Ariko abamuhagarariye mu rubanza nta nubwo bagaragarije urukiko uko icyo kimenyetso gisobanura ingano y'indishyi bagisabisha. Uru rukiko rukaba rero ntaho rubona rwahera ruhindura indishyi z'akababaro zingana na miliyoni 2 urukiko rubanza rwageneye Kayitesaris. Kuri Yambabariye Vedaste urukiko rurasanga mu gika cya 618 ku rupapuro rwa 226 rw'urubanza rwajuririwe, urukiko rubanza rwarasanze hashingiwe kuri raporo y'akagari ka Ngugu yo kuwa 6 Ugushyingo umwaka wa 2020 igaragaza ko Yambabariye Vedaste yarasiwe mu gitero cyagabwe mu ishyamba rya Nyungwe kuwa 15 Ukuboza umwaka wa 2018. Kuva icyo gihe akaba akivuza ibikomere yagenerwa indishyi z'akababaro zingana na miliyoni 2 agenwe mu bushobozi bw'urukiko kuko izindi asaba atagaragaza icyo azishingiraho. Muri uru rubanza rw'ubujurire Yambabariye Vedaste n'abavoka bamuhagarariye bavuga ko yari yasabye indishyi zingana na miliyoni 20 kubera ubumuga yatewe no kurasirwa mu gitero. Ubu bakaba barongeye muri dosiye ikimenyetso cya raporo ya muganga kigaragaza ku mugereka wa 099 ariko ko ibye urukiko rutabisobanuye neza kuko biri mu gika cya 618 cy'urubanza rwajuririwe bigaragaza ko urukiko rwabonye ibimenyetso bye kandi rwabishimye rugasanga yagenerwa indishyi zingana n'amafaranga miliyoni 2 ariko mu cyemezo cyarwo mu gika cya 711 rukaba rwaramushyize mu cyiciro cy'abataragenewe indishyi. Ubu bakaba basaba urukiko ko rwakosora iryo kosa ariko nanone ngo kuko yari yasabye indishyi za miliyoni 20 akagenerwa miliyoni 2 bagasanga nazo ari nkeya nubwo zitanagaragara mu cyemezo cy'urukiko, bagasaba urukiko ko rwakongera rugasuzuma ishingiro ry'indishyi yari yasabye mbere rukazimugenera. Kubirebana no kuba mu gusobanura icyemezo mu gika cya 618 cy'urubanza rwajuririwe urukiko rwarasanze Yambabariye Vedaste akwiye kugenerwa indishyi zingana na miliyoni 2 ariko rwagira ahagenewe kwandikwa icyemezo nyirizina rukamushyira mu cyiciro cy'abataragenewe indishyi. Uru rukiko rushingiye ku biteganywa n'ingingo y'141 y'itegeko nimero 22 agakwego 2018 ryerekeye imiburanishirize y'imanza z'imbonezamubano, iz'ubucuruzi, iz'umurimo n'iz'ubutegetsi. Urukiko rurasanga ari ikosa ry'ukwibeshya mu myandikire y'icyemezo rishobora gukosorwa n'uru rukiko muri ubu bujurire, bityo kuba rubona nta mpamvu yari hari yabuze urukiko rubanza gukomeza no mu cyemezo cyarwo rukemeza ibyo rwari rumaze gusobanura mu gika cya 618. Rukaba rusanga urukiko rubanza rwaramugeneye indishyi rwari rwasobanuriye impamvu zingana na miliyoni 2. Kubirebana n'ibisabwa na Yambabariye Vedaste n'abamuhagarariye ko uru rukiko rwashingira ku kimenyetso gishya kiri ku mugereka wa 099 maze rukongera izi ndishyi yagenewe zikaba miliyoni 2 yari yaregeye na mbere. Uru rukiko rurasanga iki kimenyetso cyatanzwe ku wa 16 Mutarama 2022 na muganga wo mu bitaro bya Kigeme yise attestation de maladie chronique ntacyo cyahindura ku byemejwe n'urukiko rubanza ko Yambabariye Vedaste atahabwa indishyi zose asaba nk'izikomoka ku bumuga yagize kuko akirimo kwivuza, ahubwo rukamugenera indishyi z'ububabare yatewe no gukomeretswa n'igitero kubera ko uretse no kuba bamuhagarariye batagaragaza uko icyo kimenyetso gisobanura ingano y'indishyi za miliyoni 20 bagisabisha. Icyo kimenyetso nta nubwo kigaragaza ubumuga buhoraho bukomoka kuri uko gukomereka, ahubwo gishimangira ibyemejwe n'urukiko rubanza ko Yambabariye Vedaste agifite uburwayi akomeza kwivuza. Uru rukiko rukaba rero ntaho rubona rwahera ruhindura indishyi z'akababaro zingana na miliyoni 2 urukiko rubanza rwageneye Yambabariye Vedaste, ahubwo rukaba rusanga urubanza rwajuririwe rugomba gukosorwa izo ndishyi zikanagaragara mu cyemezo cy'urukiko. Kuri Ndutiye Yusuf urukiko rurasanga mu bika bya 599 kugera kuri 600 ku rupapuro rwa 220 rw'urubanza rwajuririwe urukiko rubanza rwarasanze atagomba kugenerwa amafaranga miliyoni 8 yasabye y'agaciro k'imodoka ye yatwitswe hashingiwe gusa kuri facture pro forma yakozwe kwa 24 Mutarama umwaka wa 2020 nyuma yo kwitwikwa kuko iyo facture itagaragaza agaciro yari ifite ayigura n'igihe yari ayimaranye, ahubwo mu bushobozi bw'urukiko rukaba rwaramugeneye amafaranga angana na miliyoni 4. Urukiko rurasanga kandi muri ibyo bika by'urubanza rwajuririwe urukiko rubanza rwarasanze kubirebana n'izindi ndishyi Ndutiye Yusuf yasabye kuba yaratwikiwe imodoka agaterwa ubwoba n'igitero no kuba yaravukijwe uburenganzira bwo gukoresha imodoka ye mu buzima bwa buri munsi yabiherwa indishyi z'akababaro zingana na miliyoni 2,500,000 zigenwe mu bushobozi bw'urukiko kubera ko rwasanze indishyi yabisabiye ari nyinshi kandi akaba ataranagaragaje icyo ashingiraho asaba ku imodoka ye ibarirwa 20,020 ku munsi, runamugenera amafaranga 500,000 yikurikirana rubanza. Bityo amafaranga y'indishyi nayo ikurikirana rubanza yagenewe yose hamwe akaba angana na miliyoni 7. Muri uru rubanza rw'ubujurire Nduti Yusufu n'abavoka bamuhagarariye bavuga ko banenga kuba indishyi z'agaciro k'imodoka zingana na miliyoni 4 zagenwe n'urukiko ntacyo rugendeyeho, ngo kuko aya mafaranga nta modoka yagura, bagasaba ko yagenerwa miliyoni 8 yari yasabye, ngo cyangwa urukiko rugahamagaza abahanga mu kugena agaciro k'ibinyabiziga hagendewe ku myaka biba bimaze bikora n'igihe biba byarakorewe. Bananenga kandi ko kuba Ndutiye Yusufu yaratwikiwe imodoka agaterwa ubwoba n'igitero no kuba yaravukijwe uburenganzira bwo gukoresha imodoka ye mu buzima bwa buri munsi yarabiherewe indishyi mbumbe z'akababaro zingana na miliyoni 2,5 zigenwe mu bushobozi bw'urukiko. Bagasaba ko imodoka ibarirwa amafaranga 20,020 ku munsi kubera ko ariyo modoka yakoreshaga mu mirimo ye ya buri munsi, ku buryo mu gihe cyose atakiyifite byamusabye gukodesha indi yifashisha yisimbura. Banavuga ko amafaranga 500,000 yikurikirana rubanza urukiko rwamugeneye nayo ari make hashingiwe ku gihe cyose Ndutiye Yusufu yitabiriye amaburanisha i Nyanza urubanza rukiberayo, nayo yitabiriye kuvaho rwimuriwe i Kigali. Bagasaba ko izi ndishyi zakongera zigasuzumwa akagenerwa izingana na miliyoni 1 yari yasabye mbere. Uru rukiko rurasanga ku birebana n'indishyi z'agaciro k'imodoka ya Ndutiye Yusufu yatwitswe, urukiko rubanza rwarasobanuye ko rwagennye mu bushobozi bwarwo izingana na miliyoni 4 aho kwemeza izingana na miliyoni 8 zasabwaga hashingiwe ku kimenyetso Ndutiye Yusufu yise facture pro forma, kuko urwo rukiko rwasanze iyo facture pro forma idashobora kuba ikimenyetso gihagije gihamya agaciro iyo modoka yari ifite, kuko uretse no kuba yaranditswe kuwa 24 Mutarama 2020 imodoka yaramaze gutwikwa kuwa 15 z'ukwa 12 2018, nta nubwo igaragaza agaciro imodoka yari ifite ikigurwa igihe nyirayo yarayimaranye ayikoresha ndetse n'agaciro yari isigaranye igihe yatwikwaga. Uru rukiko rurasanga ariko akamaro ka facture pro forma atari ukugaragaza agaciro imodoka yari ifite igurwa cyangwa se itwikwa, ahubwo akamaro kayo ni ukugaragaza igiciro wajya kugura imodoka nk'iyo uko imeze umunsi iyo pro forma ikoreweho yayibonaho ikiguzi cy'imodoka y'ubwoko bumwe nayo. Uru rukiko rusanga nanone akamaro ko kwaka indishyi z'agaciro k'icyangijwe ari ukugira ngo uzihawe abashe gusimbuza icye cyangiritse kibashe kumufasha nk'uko icyangijwe cyamufashaga, reparation intégrale, akishyurwa hakurikijwe agaciro agaciro kari ku isoko mu gihe nta bundi buryo buhari bwo kumenya agaciro kayo nyakuri. Rushingiye rero ku kuba Ndutiye Yusufu yaragaragarije urukiko ko yatunze iyo modoka, birimo ikimenyetso ko yajyaga ayifatira ubwishingizi muri Sonarwa, akaba kandi yaragaragaje igiciro kiri ku isoko cy'imodoka yo mu bwoko bumwe nayo kandi zakorewe rimwe. Mu baregwa ntihagire ukivuguruza ngo agaragaze ko hari aho imodoka nk'iyo Ndutiye Yusufu yahoranye yaboneka ku giciro gito. Uru rukiko rusanga urukiko rubanza rwaragombaga gushingira kuri iyo facture pro forma mu gihe nta kindi kiyivuguruza kigaragaza uko imodoka nk'iyo yayibona aramutse agiye kuyigura uyu munsi. Urukiko rurasanga ku birebana n'indishyi zingana na miliyoni 2,500,000 zagenwe n'urukiko rubanza rwarasobanuye ko ari indishyi z'akababaro zikomatanyirije hamwe izikomoka ku kuba Ndutiye Yusufu yaratwikiwe imodoka agaterwa ubwoba n'igitero no kuba yaravukijwe uburenganzira bwo gukoresha imodoka ye mu buzima bwa buri munsi, mu gihe nyamara Ndutiye Yusufu we mu kuregera indishyi yari yatandukanyije indishyi z'akababaro yasabaga zingana na miliyoni 2, naho izirebana n'ibyo yatakaje ashaka ubundi buryo yabona indi modoka imufasha mu ngendo ze za buri munsi nyuma yo gutwikirwa imodoka, agasaba ko zibarirwa ku bihumbi 20 buri munsi, uhereye ku munsi imodoka yatwikiyeho tariki 15 z'ukwa 12 2018 kugeza ku munsi w'isomwa ry'urubanza. Uru rukiko rusanga urukiko rubanza rwaribeshye mu gukomatanyiriza hamwe indishyi z'akababaro n'indishyi zo kuba yaravukijwe uburenganzira bwo gukoresha imodoka ye mu buzima bwa buri munsi, kuko izi ndishyi zidahuje kamere kandi zikaba zitabarwa kimwe. Mu gihe indishyi z'akababaro, indishyi mpozamarira zitangwa mu buryo bw'ubushishozi, kuko akenshi biba bigoye ko haboneka ibipimo bifatika zishingiraho, kuko zishyura ibifitanye isano n'amarangamutima, indishyi zivutswa amahirwe mbangamirabukungu zo zigira ibipimo zishingiraho n'iyo byaba bigenekereje, kuko wavukijwe uburenganzira bwo gukoresha ikinyabiziga cye ashaka ukunda bigenza kugira ngo abeho uko bisanzwe, ibyo akaba ari byo bihabwa agaciro mu mafaranga. Uru rukiko rusanga rero nk'uko rwabigenje ku bandi rwageneye indishyi z'akababaro, kuko bagizweho ingaruka n'ibi bitero by'iterabwoba, rubikoze mu bushishozi bwarwo rukaba rwabageneye ibihumbi 300. Ndutiye Yusufu nawe yagombaga kugenerwa indishyi z'akababaro zihwanye n'ibihumbi 300. Naho ku bijyanye n'indishyi zo kuba yaravukijwe uburenganzira bwo gukoresha imodoka ye mu buzima bwa buri munsi, urukiko rusanga rutakwirengagiza ko kugira ngo abashe gukomeza imirimo ye ya buri munsi hari ikiguzi cy'ingendo yakoresheje. Muri urwo rwego uru rukiko rusanga nta kimenyetso gishyigikira ibihumbi 20 asaba ku munsi, ku buryo urukiko rwayashingiraho, bityo mu bushobozi bwarwo rukaba rumugeneye ibihumbi 5 ku munsi uhereye igihe imodoka yangirikiye ku wa 15 Ukuboza umwaka wa 2018 kugeza kuri uyu wa 4 Mata 2022. Ni ukuvuga iminsi 1190, gukuba amafaranga 5,000 ku munsi bihwanye n'amafaranga 5,950,000. Ku birebana n'amafaranga 500,000 yikurikirana rubanza, urukiko rwageneye Ndutiye Yusufu akajurira avuga ko ari make hashingiwe ku gihe cyose yitabiriye amaburanisha i Nyanza urubanza rukiberayo, nayo yitabiriye kuva aho rwimuriwe i Kigali, agasaba ko izi ndishyi zakongerwa zikaba 1,000,000 yari yasabye mbere. Urukiko rurasanga yagenwe n'urukiko rubanza rwarayagennye kuko nta kimenyetso kigaragaza ingano y'ukuri y'amafaranga Ndutiye Yusufu yakoresheje mu gukurikirana urubanza, kandi n'ubu akaba akomeje gusaba ay'urwo rukiko rwamwimye atagaragaza icyo kimenyetso cyangwa se ngo agaragaze icyo anenga ubwo bushishozi bw'urukiko rubanza. Bityo mu bujurire uru rukiko rukaba ntacyo rufite rwashingiraho ruhindura iki cyemezo cy'urukiko rubanza. Muri rusange indishyi Ndutiye Yusufu agenewe mu rubanza rwajuririwe zikaba zihindutse ku bijyanye n'indishyi z'agaciro k'imodoka zibaye amafaranga 8,000,000, n'indishyi zo kuvutswa uburenganzira bwo gukoresha imodoka zibaye amafaranga 5,950,000, iz'akababaro zibaye 300,000, kongeraho amafaranga y'ikurikirana rubanza 500,000 yari yahawe mbere, yose hamwe akaba abaye 14,750,000. Kuri Omega Express Company urukiko rurasanga mu bika bya 601 kugera kuri 603 ku rupapuro rwa 221 rw'urubanza rwajuririwe, urukiko rubanza rwarasanze hari imodoka zayo 2 za Coaster zitwara abagenzi zatwikiwe mu ishyamba rya Nyungwe n'abarwanyi ba MRCD-FRN, kandi ko icyo gihombo bagize kubera icyo gitero kigomba gutangirwa indishyi, haba iz'agaciro k'imodoka, iz'igihombo Omega Express Company yagize bitewe no kutazikoresha, ndetse n'amafaranga yatakaje kubera gukurikirana urubanza. urukiko rurasanga ku birebana n'agaciro k'imodoka zatwitswe urukiko rubanza mu bika byavuzwe haruguru by'urubanza rwajuririwe rwarasanze imodoka isabirwa kwishyurwa agaciro kangana na miliyoni 51,809 yari imaze imyaka 5 ikora maze mu bushobozi bw'urukiko rubishingiraho rugena ko yakwishyurwa miliyoni 40 naho kuba indi modoka isabirwa kwishyurwa miliyoni 52,079 n'amafaranga 986 yari imaze umwaka umwe ikora urukiko mu bushobozi bwarwo rukaba rwaragennye indishyi zingana na miliyoni 45. urukiko rurasanga ku birebana n'indishyi mbonezamusaruro z'igihombo Omega Company yagize bitewe n'igihe imaze idakoresha imodoka zayo kuko zatwitswe urukiko rubanza rwarasanze Omega Express Limited itararugaragarije ku buryo bwumvikana ikishingira hisaba izo ndishyi mbonezamusaruro kuko ngo gushingira ku gihe cy'imyaka 20 ivuga ko buri modoka yatwitswe yari kuzamara ikora no ku mafaranga zinjizaga ku munsi bidahagije kugira ngo izo ndishyi zisabwa zigenwe. urukiko mu bushobozi bwarwo rukaba rwarasanze rushingiye ku kuba imodoka itwara abagenzi itashobora gukora buri munsi itaruhutse kuko Omega Express Company nayo isaba indishyi yaragennye mu buryo bwo kugenekereza amafaranga ikorera ku munsi runashingira ku kuba Omega Express Limited yagenewe izindi ndishyi z'agaciro k'imodoka bituma ruyigenera gusa indishyi mbonezamusaruro z'amezi 33 abazwe kuva ku wa 15 Ukuboza 2018 igihe imodoka yatwikiwe kugeza urubanza ruciwe kandi zibariwe ku minsi 24 ku kwezi ku mafaranga 50,000 kuri buri munsi. Bityo ku modoka zombi rugenera indishyi mbonezamusaruro zingana na miliyoni 79,200. urukiko rukaba rwaragennye n'amafaranga 500,000 yikurikirana rubanza. muri ubu bujurire uburanira Omega Express Company akaba avuga ko urukiko ntaho rwahera ruvuga ko bisi ikora iminsi 24 mu kwezi kuko ngo niyo umushoferi yaruhukijwe imodoka yo bitayibuza gukomeza gukora, akananenga ko urukiko ntacyo rwavuze kukuba ibyabaye byaratumye Omega Express itakarizwa icyizere ku bayigana kandi ngo ibi bikaba bikomeje kuyihombya. Akaba asaba urukiko kugena indishyi mbonezamusaruro zibariwe ku 50,000 ku munsi kugeza igihe urubanza ruzasomerwa kandi ko izo ndishyi zigomba kubarirwa ku minsi 30 y'ukwezi ngo kuko imodoka zikora buri munsi nk'uko umutangabuhamya Rurangwa iwari umushoferi yabisobanuye. Avuga kandi ko amafaranga yikurikirana rubanza asaba ari miliyoni 1,240 akubiyemo 20,020 ndetse na miliyoni 1,220 abazwe mu buryo bw'imbumbe ngo kuko ibyo babaga bakoresheje mu gukurikirana urubanza batabisabiraga fagitire. uru rukiko rurasanga ku birebana n'indishyi zijyanye n'agaciro k'imodoka ebyiri zatwitswe uburanira Omega Express Company icyanenga kuzagenwe n'urukiko rubanza ari ukuba ziri munsi y'agaciro kagaragazwa n'ibimenyetso bya fagitire zaguriweho, hakaba hashize imyaka 5 kuri imwe n'umwaka umwe ku yindi, aho yumvikanisha ko agaciro kazo kakabaye kariyongereye mu buryo bw'amafaranga ukurikije ko imodoka nk'izo zagurwa ubu ku isoko, naho urukiko rubanza rwo rukaba rwarafashe ibintu mu murongo w'uko imodoka igenda igabanuka agaciro uko igenda nayo imara igihe. Kuri iyi ngingo uru rukiko rukaba rusanga bishoboka koko ko agaciro mu mafaranga k'imodoka kiyongera uko imyaka igenda yicuma aho kugabanuka, ariko ko ibiyo bibaye biba bidasanzwe kuko ibisanzwe ari uko buri kintu uko gisaza ari nako kigenda kigabanya agaciro kacyo. uru rukiko rukaba rusanga ariko mu gihe uburanira Omega Express Company abasanga imodoka zayo zarashaje ziyongera agaciro aho kugata, ari nawe wari kugira inshingano zo gutanga ibimenyetso bibihamya kugeza ubu atigeze atanga kuko ibyo yatanze ari inyemezabwishyu izo modoka zaguriweho mu myaka 5 kuri imwe no ku mwaka umwe ku yindi uhereye igihe zaguriweho. urukiko rubanza rukaba rero nta kundi rwari gukemura iki kibazo rutiyambaje ubushishozi bwarwo no kugenekereza agaciro k'izo modoka rugendeye ku kureba amafaranga zaguzwe, igihe zimaze ziguzwe, kandi rwitaye ku buryo busanzwe bwo kuba igikoresho cyose kigenda gitakaza agaciro uko kigenda gisaza, amortissement cyangwa depreciation. Urukiko rukaba rero ntaho rubona rwashingira ruhindura uyu murongo wakurikijwe n'urukiko rubanza mu kugena indishyi zirebana n'agaciro k'imodoka za Omega Express Company zatwitswe mu gitero cy'umutwe w'iterabwoba wa MRCD FLN. Urukiko rurasanga ku birebana n'indishyi mbonezamusaruro z'amafaranga imodoka ebyiri zatwitswe zari kwinjiza iyo zidatwikwa, icy'uburaniro Omega Express Company Limited anenga ku cyemezo cy'urukiko rubanza ari uko amafaranga zakabaye zarinjije guhera igihe zatwikiwe kugeza igihe urubanza rwasomeweho yaragiye abarirwa ku minsi 24 y'ukwezi aho kubarirwa ku minsi 30 yose y'ukwezi. Urukiko rukaba rusanga mu gihe iby'uburanira Omega Express Company Limited avuga abishingira ku buhamya bw'umushoferi wa bene izo modoka, naho iby'urukiko rubanza rwo rwemeje rukaba rwarabishingiye ku kuba mu buryo busanzwe imodoka yose ibigomba kugira igihe isiba gukora kugira ngo nayo ibashe kwitabwaho. Uru rukiko rurasanga icyari kumara impaka mu buryo bwizewe na bose ari uko uburanira Omega Express Company Limited aba yaragaragaje ingengabihe umunsi ku wundi w'imikoreshereze y'izo modoka zatwitswe kuva zatangira gutungwa na Omega Express Company Limited kugira ngo bigaragazwe ko koko zikoreshwa buri munsi ubutaruhuka. Naho ubundi uburyo bwo kugena iminsi y'akazi k'imodoka mu bushishozi bw'urukiko, uru rukiko narwo rurasanga ariyo nzira yonyine yashoboka mu kugena indishyi, kandi ko nta gukabya cyangwa se gupfobya akazi k'izi modoka mu kugena ko zakabaye zarakoraga iminsi 24 mu kwezi ku buryo bw'impuzandengo. Indishyi mbonezamusaruro zagenwe muri ubu buryo n'urukiko rwajuririwe nazo zikaba zigomba kuba arizo zigumaho. Ku birebana n'amafaranga 500,000 y'ikurikirana rubanza, urukiko rwageneye Omega Express Company Limited ikajurira ivuga ko ari make, igasabayo n'ubundi yari yaregeye ku rwego rwa mbere angana na 1,240,000 ngo kuko ibyo babaga bakoresheje mu gukurikirana urubanza batabisabiraga fagitire. Uru rukiko rurasanga nabyo nta shingiro byahabwa kuko n'uburanira Omega Express Company Limited yivugira ubwe ko amafaranga asaba gusubizwa adafite inyemezabwishyu yasohokeyeho. Urukiko rubanza rushingiye ku kuba muri rusange nta rubanza rubaho rutagira icyo rutwara nyirarwo mu kurukurikirana, rukaba rwariyambaje ubushishozi bwarwo rukagena izingana na 1,500,000 kuko nta bimenyetso bigaragaza ingano nyakuri y'izisabwa byigeze bigaragazwa. Muri rusange urukiko rukaba rusanga nta gihinduka ku ndishyi zose Omega Express Company Limited yagenewe n'urukiko rubanza. Kuri Alpha Express Limited urukiko rurasanga mu bika bya 604 na 605 ku rupapuro rwa 221 kugera kuri 222 rw'urubanza rwajuririwe, urukiko rubanza rwarasanze hari imodoka yayo ya Coaster itwara abagenzi yatwikiwe mu ishyamba rya Nyungwe mu gitero cyo kwa 15 Ukuboza 2019, kandi ko kubera iyo mpamvu igomba kugenerwa indishyi kubera igihombo yagize kijyanye no kubura imodoka yayo n'amafaranga yari kuzakorera iyidatwikwa, ikanagenerwa amafaranga yatakaje kubera gushorwa mu manza. Urukiko rushingiye ku kuba iyo modoka yari imaze imyaka 4 ikora, rukaba rwarasanze itagenerwa agaciro yaguzwe nk'uko urega yabisabye, ahubwo mu bushobozi bw'urukiko rugena $40,000,000. Urukiko rurasanga ku birebana n'indishyi mbonezamusaruro urukiko rubanza rwarashingiye ku kuba imodoka itwara abagenzi itashobora gukora buri munsi itaruhutse, ku kuba Alpha Express Limited yagenewe izindi ndishyi z'agaciro k'imodoka, bituma ruyigenera gusa indishyi mbonezamusaruro z'amezi 33 abazwe kuva ku munsi kuva ku wa 15 Ukuboza 2018 igihe imodoka yatwikiwe kugeza urubanza ruciwe kandi zibariwe ku minsi 24 ku kwezi ku mafaranga 50,000 kuri buri munsi, bityo rugena indishyi mbonezamusaruro zingana na miliyoni 39,600. Urukiko rukaba rwaragennye n'amafaranga 500,000 yikurikirana rubanza. Muri ubu bujurire uburanira Rufa Express Company akaba anenga uburyo urukiko rukuru rwabaza izo ndishyi ngo kuko imodoka nk'iyi ya Coaster agaciro kayo katagenda kagabanuka kubera igihe imaze ikora, ngo ahubwo kiyongera binatewe n'itagaciro ry'ifaranga. Ibi ngo urukiko rukaba rutarabyitayeho mu kugena indishyi z'agaciro k'iyi modoka rugendeye ku gihe yari imaze ikora, aho gushingira ku gaciro k'imodoka nk'iyi ku washaka kuyigura uyu munsi. Asaba kandi ko indishyi mbonezamusaruro zibarirwa ku minsi 30 y'ukwezi, ngo kuko imodoka zikora buri munsi, ndetse na miliyoni 1 yikurikirana rubanza, ngo kuko kuva urubanza rutangiye i Nyanza kugeza ubu nta kuntu Rufa Express yari kuba yaratakaje amafaranga 500,000 gusa urukiko rwayigeneye. Uru rukiko rurasanga ku birebana n'indishyi zijyanye n'agaciro k'imodoka yatwitswe uburanira Rufa Express Company icyanenga kuzagenwe n'urukiko rubanza ari ukuba ziri munsi y'agaciro kagaragazwa n'ibimenyetso bya fagitire yaguriweho hakaba hashize imyaka 4, aho yumvikanisha ko agaciro kayo kakabaye kariyongereye mu buryo bw'amafaranga ukurikije uko imodoka nk'iyo yagurwa ubu ku isoko, naho urukiko rubanza rwo rukaba rwarafashe ibintu mu murongo w'uko imodoka igenda igabanuka agaciro uko igenda nayo imara igihe, nk'uko bimaze gusobanurwa haruguru ku birebana n'imodoka za Omega Express Company nazo zatwitswe. Kuri iyi ngingo uru rukiko rukaba rusanga bishoboka ko koko agaciro mu mafaranga k'imodoka kiyongera uko imyaka igenda yicuma aho kugabanuka, ariko ko ibi iyo bibaye biba bidasanzwe, kuko ibisanzwe ari uko buri kintu uko gisaza ari nako kigenda kigabanya agaciro kacyo. Uru rukiko rukaba rusanga ariko mu gihe uburanira Rufa Express aba asanga imodoka yayo yo yarashaje yiyongera agaciro aho kugata, ari nawe wari kugira inshingano zo gutanga ibimenyetso bibihamya kugeza ubatigeze atanga, kuko ibyo yatanze ari inyemezabwishyu iyo modoka yaguriweho mu myaka 4 ishize uhereye igihe yaguriweho. Urukiko rubanza rukaba rero nta kundi rwari gukemura iki kibazo rutiyambaje ubushishozi bwarwo no kugenekereza agaciro k'iyo modoka rugendeye ku kureba amafaranga yaguzwe, igihe imaze iguzwe, kandi rwitaye ku buryo busanzwe bwo kuba igikoresho cyose kigenda gitakaza agaciro uko kigenda gisaza. Urukiko rukaba rero ntaho rubona rwashingira ruhindura uyu murongo wakurikijwe n'urukiko rubanza mu kugena indishyi zirebana n'agaciro k'imodoka ya Rufa Express Company yatwitswe mu gitero cy'umutwe w'iterabwoba wa MRCD-FLN. Urukiko rurasanga ku birebana n'indishyi mbonezamusaruro z'amafaranga imodoka yatwitswe yari kwinjiza idatwikwa icy'uburanira Rufa Express Company Limited anenga ku cyemezo cy'urukiko rubanza ari ukuba amafaranga yakabaye yarinjije guhera igihe yatwikiwe kugeza igihe urubanza rwasomewe yaragiye abarirwa ku minsi 24 y'ukwezi aho kubarirwa ku minsi 30 yose y'ukwezi. Urukiko rukaba rusanga mu gihe iby'uburanira Rufa Express Company Limited avuga abishingira ku buhamya bw'umushoferi wa bene izo modoka, naho iby'urukiko rubanza rwo rwemeje rukaba rwarabishingiye ku kuba mu buryo busanzwe imodoka yose iba igomba kugira igihe isiba gukora kugira ngo nayo ibashe kwitabwaho. Uru rukiko rurasanga icyari kumara impaka nanone mu buryo bwizewe na bose ari uko uburanira Rufa Express Company aba yaragaragaje ingengabihe umunsi ku wundi b'imikoreshereze y'iyo modoka yatwitswe kuva yatangira gutungwa na Rufa Express Company, kugira ngo bigaragazwe ko koko ikoreshwa buri munsi itaruhuka, naho ubundi uburyo bwo kugena iminsi y'akazi k'imodoka mu bushobozi bw'urukiko. Urukiko narwo rurasanga ariyo nzira yonyine yashoboka mu kugena izi ndishyi, kandi ko nta gukabya cyangwa se gupfobya akazi k'iyi modoka mu kugena ko yakabaye yarakoraga iminsi 24 mu buryo bw'impuzandengo. Indishyi mbonezamusaruro zagenwe muri ubu buryo n'urukiko rwajuririwe nazo zikaba zigomba kuba arizo zigumaho. Ku birebana n'amafaranga 500,000 yikurikirana rubanza urukiko rwageneye Alpha Express Company Limited ikajurira ivuga ko ari make hashingiwe ku gihe cyose yitabiriye amaburanisha i Nyanza urubanza rukiberayo nayo yitabiriye kuva aho rwimuriwe i Kigali uyiburanira agasaba ko izi ndishyi zakongerwa zikaba miliyoni 1 yari yasabye mbere. Uru rukiko rurasanga ayagenwe n'urukiko rubanza rwarayagennye kuko nta kimenyetso kigaragaza ingano y'ukuri y'amafaranga Alpha Express Company Limited yakoresheje mu gukurikirana urubanza, kandi n'ubu ikaba ikomeje gusaba ay'urwo rukiko rwayimye itagaragaza icyo kimenyetso cyangwa se ngo igaragaze ikinenga ubwo bushishozi bw'urukiko rubanza. Bityo mu bujurire urukiko rukaba ntacyo rufite rwashingiraho ruhindura iki kimenyetso cy'urukiko rubanza. Muri rusange indishyi zose Alpha Express Company yagenewe mu rubanza rwajuririwe zikaba ntacyo zigomba guhindukaho muri ubu bujurire. Ku birebana n'abajuririye, ingano y'indishyi zifitanye isano n'ibitero byagabwe mu murenge wa Kamembe n'uwa Nyakarenzo mu karere ka Rusizi. Kuri Nkuruziza Jeanne Paul mu gika cya 620 ku rupapuro rwa 227 rw'urubanza rwajuririwe, urukiko rubanza rwasanze rushingiye kuri raporo ya muganga yo kuwa 7 Ukwakira 2020 igaragaza ko afite ubumuga buhoraho bungana na 6% n'ubusembwa bwo ku kigero cya 2/6, no kuri raporo y'umurenge wa Kamembe yo kuwa 22 Ukwakira 2020 igaragaza ko ari mu bakomerekejwe na grenade agomba kugenerwa indishyi kubera akababaro yagize ko gukomeretswa agasigarana ubumuga n'ubusembwa zingana na miliyoni 3 zigenwe mu bushishozi bw'urukiko. Muri uru rubanza rw'ubujurire Nkurunziza Jeanne Paul n'abavoka bamuhagarariye bavuga ko yajuririye izo ndishyi kuko ari nkeya, bagasaba urukiko ko rwakongera rukazisuzuma maze rukazongera. Uru rukiko rurasanga indishyi isaba ko urukiko rwongera mu bujurire asaba ko ruzigena mu bushobozi bwarwo mu gihe niza atishimiye akazijuririra zari zaragenwe mu bushobozi bw'urukiko rubanza. Uru rukiko rukaba rusanga ntaho rwashingira rusimbuza ubushishozi bwarwo ubw'urukiko rubanza mu gihe nta na kimwe Nkurunziza Jeanne Paul n'abavoka bamuhagarariye bavuga ko banenga ubwo bushishozi bwa mbere ngo banagitangire ibimenyetso. Bityo indishyi zose Nkurunziza Jeanne Paul yagenewe n'urukiko rubanza zikaba ntacyo zigomba guhindukaho. Kuri Rutayisire Felix urukiko rurasanga mu gika cya 622 ku rupapuro rwa 227 na 228 rw'urubanza rwajuririwe, urukiko rubanza rwarasanze rushingiye kuri raporo ya muganga yo kuwa 6 Ukwakira 2020 igaragaza ko yagize ubumuga buhoraho bungana na 24% n'ubusembwa bwo ku kigero cya 2/6, no kuri raporo y'umurenge wa Kamembe yo kuwa 22/2020 agomba kugenerwa indishyi kubera akababaro yagize n'ubwo bumuga yatewe no gukomeretswa na grenade zingana na miliyoni 4 zigenwe n'ubushishozi bw'urukiko, ariko akaba atagomba kugenerwa indishyi z'ubusembwa kuko nta kimenyetso yabutangiye. Muri uru rubanza rw'ubujurire Rutayisire Felix n'abavoka bamuhagarariye bavuga ko izi ndishyi ari nkeya, bakaba basaba urukiko ko rwakongera rukazisuzuma maze rukamuha indishyi yari yasabye zingana na miliyoni 5. Uru rukiko rurasanga indishyi asaba ko uru rukiko rwongera mu bujurire asaba ko ruzigena mu bushishozi bwarwo mu gihe niza atishimiye akazijurira zari zaragenwe mu bushishozi bw'urukiko rubanza. Uru rukiko rukaba rusanga ntaho rwashingira rusimbuza ubwo bushishozi bwarwo ubw'urukiko rubanza mu gihe nta na kimwe Rutayisire n'abavoka be bamuhagarariye bavuga ko banenga ubwo bushishozi bwa mbere. Bityo indishyi zose Rutayisire Felix yagenewe n'urukiko rubanza zikaba ntacyo zigomba guhindukaho. Kuri Nsabimana Joseph urukiko rurasanga mu gika cya 621 ku rupapuro rwa 227 rw'urubanza rwajuririwe, urukiko rubanza rwarasanze rushingiye kuri raporo ya muganga yo kuwa 6 Ukwakira 2020 igaragaza ko yagize ubumuga buhoraho bungana n'8% no kuri raporo y'umurenge wa Kamembe yo kuwa 22/2020 mu bushishozi bwarwo yagenerwa indishyi zingana na miliyoni 3 kubera akababaro yagize n'ubwo bumuga yatewe no gukomeretswa na grenade. Muri uru rubanza rw'ubujurire Nsabimana Joseph n'abavoka bamuhagarariye bavuga ko izo ndishyi ari nkeya, bakaba basaba urukiko ko rwakongera rukabisuzuma. Indishyi yari yasabye mbere zigizwe n'indishyi z'akababaro zingana na miliyoni 9 n'indishyi zingana na miliyoni 6 kubera ubumuga yagize bungana n'8%, n'ubundi yari yasabye ku rwego rwa mbere. Uru rukiko rurasanga indishyi asaba ko urukiko rwongera mu bujurire, asaba ko ruzigena mu bushishozi bwarwo mu gihe niza atishimiye akazijuririra zari zagenwe mu bushishozi bw'urukiko rubanza. Uru rukiko nk'uko bimaze kuvugwa haruguru rukaba ntaho rwashingira rusimbuza ubushishozi bwarwo ubw'urukiko rubanza, mu gihe nta na kimwe Nsabimana Joseph n'abavoka bamuhagarariye bavuga ko banenga ubwo bushishozi bwa mbere ngo banagitangira ibimenyetso. Indishyi zose Nsabimana Joseph yagenewe n'urukiko rubanza zikaba ntacyo zigomba guhindukaho. Kuri Nzeyimana Paul, urukiko rurasanga mu gika cya 624 ku rupapuro rwa 228 rw'urubanza rwajuririwe, urukiko rubanza rwarasanze raporo ya muganga yo kuwa 19 z'ukwa 2019 igaragaza ko Nzeyimana Paul yakomerekejwe na grenade nuko yoherejwe ku muganga w'inzobere mu kubaga kugira ngo bamukurikirane, bityo rumugenera indishyi z'akababaro zigenwe mu bushishozi bw'urukiko kuko izo asaba ari ikirenga. Agenerwa indishyi zingana na miliyoni 2, ariko ruvuga ko atagomba guhabwa amafaranga y'agaciro k'ibirahure by'imodoka ye, avuga ko byamenetse nayo yishyuye uwabisubijemo kubera ko nta bimenyetso yabitangiye. Muri uru rubanza rw'ubujurire Nzeyimana Paul n'abavoka bamuhagarariye bavuga ko indishyi yagenewe ari nkeya, bagasaba urukiko ko rushingiye kuri raporo ya muganga yari yatanze ngo nubwo igaragaza gusa ko yakomeretse rwamugenera, rwakongera rukabisuzuma rukamugenera indishyi yari yasabye mbere zingana na miliyoni 5. Uru rukiko rurasanga indishyi asaba kuri urukiko rwongera mu bujurire asaba ko ruzigena mu bushobozi bwarwo mu gihe ntazo atishimiye akazijuririra zari zaragenwe mu bushobozi bw'urukiko rubanza. Nk'uko byasobanuwe ku bandi hejuru, uru rukiko rukaba rusanga ntaho rwashingira rusimbuza ubushobozi bwarwo ubw'urukiko rubanza, bityo indishyi zose Nzeyimana Paul yagenewe n'urukiko rubanza zikaba ntacyo zigomba guhindukaho. Kuri Mahoro Jean Damascene, urukiko rurasanga mu gika cya 623 ku rupapuro rwa 228 rw'urubanza rwajuririwe, urukiko rubanza rwarasanze rushingiye kuri raporo y'akagari ka Karangiro mu murenge wa Nyakarenzo yo kuwa 21 z'ukwa 2020 igaragaza ko mu ijoro ryo kuwa 8 z'ukwa 2019 imodoka ye y'ikamyoneti Dina yatwitswe n'igitero cyagabwe ku ruganda rw'ifu mu Karangiro aho yari ihagaze, akaba agomba kugenerwa indishyi kubera ko bigaragara ko yari atunze iyo modoka, ariko kuba ataragaragaje ikimenyetso cy'agaciro kayo akagenerwa indishyi mu bushishozi bw'urukiko zihwanye na miliyoni 5. Akanagenerwa indishyi z'akababaro zingana n'ibihumbi 500 yatewe n'uko yatwikiwe imodoka, ariko akaba atagenerwa indishyi z'igihombo kubera ko atagaragaje aho agishingira. Urukiko rurasanga muri uru rubanza rw'ubujurire Mahoro Jean Damascene n'abavoka bamwunganira bavuga ko urukiko rwamugeneye indishyi zose hamwe zingana na miliyoni 5,500, ariko ko abona zidakwiye kubera ko ngo imodoka ubwayo yari yayiguze miliyoni 11, ngo ikaba yarajyaga ikora akazi ko gutwara amafu yerekeza mu gihugu cya Kongo, igakora inshuro 2 ku munsi ikorera ibihumbi 60, kuko ngo inshuro imwe yabaga ari ibihumbi 30. Ngo amafaranga yari yayiguze akaba yari yayagujije muri banki, bityo ngo bikaba byaramuteje ubukene n'uyu mwanya adashobora kwivanamo. Basaba urukiko ko rwarebana ubushishozi izo ndishyi rukamugenera izo yari yasabye zingana na miliyoni 11 z'agaciro k'imodoka ye, miliyoni 29 z'umusaruro yakabaye yinjiza kuko yari imodoka y'ubucuruzi, akaba yari yayizanye kuri urwo ruganda ngo izajya ijyana amafu muri Kongo n'ahandi hatandukanye, ndetse n'indishyi z'akababaro zingana na miliyoni 10. Banavuga kandi ko kuba batarabashije kugaragaza ibimenyetso by'uko imodoka yakoraga kandi yinjizaga n'amafaranga ngo byatewe n'uko ibyangombwa byayo byose byahiriye muri iyo modoka. Urukiko rurasanga muri uru rubanza rw'ubujurire Matakamba Jean Berkimas uregwa wemera kuba yaragize uruhare mu bitero byabereye muri Rusizi, harimo n'ibyabereye muri Karangiro mu murenge wa Nyakarenzo, aho Mahoro Jean Damascene avuga ko imodoka ye yatwikiwe. Yiregura ku bivugwa na Mahoro, yemeza ko amuzi neza kuko baturanye, akaba azi neza n'imodoka ye avuga ko yatwitswe, kuko avuga ko azi n'aho yayiguze, igihe yayiguriye ndetse n'amafaranga yayiguze, ariko ko mu gitero cyagabwe ku ruganda mu Karangiro iyo modoka ya Mahoro Jean Damascene itatwitswe ngo ikongoke ku buryo yahagarara burundu kongera gusubira mu muhanda no gukora, ko ahubwo ngo yatwitswe ku gice cy'imbere kabine, ikaba ubu iri mu muhanda ikomeje gukora nyuma yo kwisanwe. Akaba avuga ko Mahoro Jean Damascene atakabaye asaba indishyi zihwanye n'agaciro kayo kandi ikiriho inakora, kandi akanenga kuba we ataratanze ibimenyetso by'amafoto agaragaza ko imodoka ye yatwitswe, nk'uko n'abandi baregeye muri uru rubanza ko batwikiwe imodoka babitangiye ibimenyetso by'amafoto. Urukiko rurasanga kuri iyi myiregurire ya Matakamba Jean Berkimansi, Mahoro Jean Damascene n'abavoka bamwunganira nta kindi bagaragaje kimunyomoza uretse gusa kongera kuvuga ko imodoka yatwitswe, naho ibyo avuga ngo bikaba ari ugushinyagurira ba nyiri imitungo, kuko ngo bamwe mu bo bafatanyije kuyangiza barimo Byukusenge Jean Claude babyemera. Uru rukiko rurasanga ikibazo ku bijyanye n'indishyi zishyuzwa kubera itwikwa ry'imodoka ya Mahoro Jean Damascene atari icyo kumenya niba yaratwitswe cyangwa se itaratwitswe, ahubwo ikibazo kikaba ari ukumenya ikigero yatwitsweho, niba yaratwitswe yose ku buryo itasanwa cyangwa se niba yaratwitswe igice ku buryo yasanwa igakomeza gukora, kugira ngo urukiko rubashe kumenya ikigero rugeneraho indishyi zikomoka kuri iryo twikwa. Urukiko rurasanga mu gihe Mahoro Jean Damascene uregera indishyi avuga ko imodoka ye azisabira yatwitswe yose ikaba itabasha kongera gusubira mu muhanda, naho Matakamba Jean Berkimansi uri mu baregwa izo ndishyi akavuga ko imodoka itatwitswe kuri urwo rwego, ko yatwitsweho igice igasanwa igasubira mu kazi, hagomba gukurikizwa iby'itegeko riteganya birebana n'uko ibimenyetso bitangwa mu rubanza, aho ingingo ya 12 y'itegeko nimero 22 agakwego 2018 ryo kuwa 29 Mata 2018 ryerekeye imiburanishirize y'imanza z'imbonezamubano, iz'ubucuruzi, iz'umurimo n'iz'ubutegetsi, iteganya ibihura n'ihame rusange mu mategeko, rivuga ko urega ari ufite inshingano zo kubanza kugaragaza ibimenyetso by'ibyo avuga, noneho mu kwiregura uregwa akagira inshingano zo gutanga ibimenyetso binyomoza ibyabanje kugaragazwa n'urega. Ihame rikunze kuvugwa mu magambo akurikira y'ururimi rw'Ikilatini Actori incumbit probatio reus in excipiendo fit actor. Hashingiye ku bimaze kuvugwa aha hejuru, urukiko rurasanga haba ku rwego rubanza ndetse no kuri urwego rw'ubujurire Mahoro Jean Damascene nta kimenyetso yigeze abasha gutanga mu rukiko kigaragaza ko imodoka yasabira indishyi zingana n'agaciro kayo kose yaba koko yaratwitswe ku buryo itongeye kubasha gukora ngo isubire mu muhanda, bityo indishyi zibariwe ku gaciro kayo zingana n'amafaranga miliyoni 5 yagenewe n'urukiko rubanza zikaba nta shingiro zifite